Deeply obliged.
Lordship, I'm seeking your leave to use this stamp paper in this case, where it has been purchased in the name of another advocate, and the department is not letting us to use the stamp paper unless your Lordship give us the leave.
Take the no objection from the other advocate here. He will not claim this stamp duty in future. And he has no objection
We want
to
file this
use you. If it is in the name of the other advocate,
Yeah.
so you take the no objection from the other advocate that he has no objection, you will use that.
Okay.
Then only tomorrow, then he will claim who will the responsible for that.
So after taking his no objection, then should I take the Lordship?
Take the no objection. He has no objection to use this. Used by you for the purpose. Then only.
My lords, may I have my lord's kind leave to mention a
My
matter?
lord, may I kindly mention, my lord? My lord, this is the election petition, my lord. My lord, here the respondent has passed away. The main electorate, my lord, who was elected has passed away.
Correct.
Now, my lord, your lordship had given a direction, my lord, where your lordship had required that an official gazette notification be made.
Correct.
Now, my lord, there is a time period for this. My lord, we have come across, because my lord, this was quite my lord, published all over, my lord. So, my lord, we have come to know that there should be a gazette notification. But we have gone from pillar to post, but we could not get any such gazette notification as such. Now, my lord, there is a time limit for this.
Mr.
And now, my lord, we have prepared the petition.
You being the senior person and you know the law, who has published the notification, you can approach the person.
My lord, we have approached all persons.
Meeting in the morning hours, that is mentioning the matter, sir. You know who has published the matter, who has published the notice. Have you requested the authority? To whom?
My lord,
we have gone to the learned register, my lord.
Gone to the learned register, my lord. The register, the office of the register had said that in order to check any records of the election petition, my lord's leave is required.
Check that, no problem. I will give the liberty to inspect the
And only gives that liberty, my lord, we'll do the needful. Only gives that liberty, my lord.
Previously, this was mentioned previously last Friday. My lord was pleased to, my lord, refuse. My lord,
no, they have on the last occasion they asked for the short cost letter. That I they wanted to
only
there'll be no problem.
Only let us have a look at the record, my lord, then we'll do the needful, my lord.
In any event, tomorrow, my lord, the matter is listed. And my lord, the rules, my lord, are very specific. It has to be done 14 days from the publication, my lord. So that period is already over.
I am not allowing it. Yesterday, that's why on the last occasion, one of the advocates asked for the leave. So that I will not grant the leave because there is an election petition. 5
notices received by my learned advocate in record. Even yesterday, I had to come for this.
Leave is granted only for instruction of the record.
Grateful, man. Very grateful, man.
My lord, may I have your lordship's leave to mention one listed matter, my lord, item number 182 for your lordship's list. It's an assigned matter, my lord. It's a patent revocation of ferric carboxymol. Lordship, it was fixed on yesterday, my lord. Yesterday, due to, my lord, the weather condition, no one has been able to come. So, lordship, kindly fix this matter post 10th November at a fixed time, my lord. That is the only indulgence, my lord.
If you want the fixed matter, then it will go to this last week of November or first week of December.
Lord, then as per your lordship's convenience,
I don't think December also there will be any date. It is better to come after vacation.
Come after, my lord. I am in no hurry, my lord.
Mention after vacation.
My lord, your lordship will kindly fix any day, my lord, subject to your lordship.
Who is for the other side?
My lord, I have served notice. I'm mentioning upon.
Not here.
My lord, I shall inform them, my lord. I shall.
Then again, you come with him, then I will fix. You come with the other side. You come with the other side.
My lord, may I come back at 1:50?
Whatever it.
Grateful.
Before rising, you come, then we'll see.
But I am for the defendant. I'm for the defendant, my lord. Today's for file of the report of the commissioner, my lord. For the defendant number DW3's evidence is going on board. But next date is fixed in month of November, your lordship.
I am fixing in the month of January 27. You complete it.
Lordship,
because in my tenure, none of only 2 cases have been completed in the commission. And none of the commissioner is diligent to carry out. None of the advocates are diligent to carry out, give the evidence. One or the other reason, once the advocate is appointed, then you are paying for.
No, my lord, we are
I am recalling that, and let the witness come here. I will see within 2 days the witness will examine and cross-examine.
Lordship,
the whole day I will fix that. No problem.
DW3 is going on, your lordship, on DW4. The another witness, he's under.
I am giving the benefit to the bar, but the bar is taking the otherwise.
We are doing negligently.
What negligently? When the commissioner was appointed?
Commission is appointed 2020 January, man.
Then
My lord, we have
9 months you are not able to complete.
My lord, plaintiff's witness completed, your lordship. Now our witness is going on, your lordship, and this is a third witness, your lordship, and another.
As per the prayer made by the counsel for the defendant, time to file the report by the commission extended for a further period of 4 weeks. Let the matter appear on 4 weeks after Puja vacation ke liye. Let the matter appear on 3rd of December 2025 for filing report by the commissioner.
My lord.
So in this matter,
Yes.
the commission of the plaintiff witness has been completed.
Blood, I appear for the plaintiff.
Commissioner was to file his report. Commissioner was Mr. Shomava. Report is also ready. That is being told to me. I don't find
Filing
it
report.
Oh,
Filing report.
Yes, my lord. Today is fixed for.
Where is the commissioner?
I believe because of the rain.
Rain, no, it is over.
I'm not aware. I'm just assuming. Mr. Ali.
Yes, ma'am. Who is for the plaintiff? You.
Blood, yes, my lord. I appear for the plaintiff, my lord.
Why the remuneration is not being paid to the staffs?
Lord, that I'm not aware, my lord. I have to
Till the
ask
night,
Mr. Das.
Till the night 9 p.m. or 10 p.m. the staffs continue with the document, but you are not paying. I am recalling the. I will not accept
there was
the
a.
report.
Your lordship, Mr. Shoman Das is the advocate on record. I'll just ask from him.
Whoever it may be, unless and until that not been paid, I will recall the order and I will not accept the report.
In fact, there was a request from the commissioner to the plaintiff that the secretarial staff's payment should be made.
Yes.
In that case,
First,
my lord, kindly keeps the
First, you pay the payment, make the remuneration, then I will accept the report. Let the matter appear.
kindly keeps it at then, Lord, 115, Lord. By that time, you all will be there.
Let the matter appear on 4th of November 2024 under the same heading.
Oh, grateful, my lord.
Pay the remuneration first.
Gratefully.
Presentation of claim, item number 3.
Very well, my lord.
My lord, this is the matter I was, my lord, trying to present, my lord, yesterday.
Yes.
My lord, there was some, my lord, mistake with the, my lord.
Corrected, page number
Yes,
correct.
my lord, it is, my lord.
Yeah.
My lord, if lordship kindly comes to, my lord, the division bench, first, my lord, the order passed by the city civil court, lordship will kindly come to page 46. My lord, the agreement says, my lord, the agreement says that I cannot assign or transfer the property, but I can sublet. That is specifically, my lord, provided in the agreement.
Assign and
I cannot assign or sublet.
Hmm.
May I draw my lord's attention to the agreement clause once? My lord, at page 41, my lord. I'm sorry, my lord, at page 39. Clause 2G.
yes.
The tenant shall not be entitled to assign or transfer the tenancy without consent in writing. So this is an embargo on me. Next line. But the tenant shall be entitled to sublet the tenanted premises in whole with a further right to subtenancy on such rent and on such terms and conditions as tenant deemed fit provided. However, the tenant shall always remain liable to make payment of rent herein reserved regularly and punctually and of due performance and observance of terms. So I cannot transfer or assign, but I can sublet. Now, my lord, they go to the city civil court and obtain this order, my lord. Page 46.
Yes.
Their allegation, my lord, last 7 lines, my lord, which I was, my lord, referring to the yesterday. Accordingly, plaintiff has filed the suit for declaration and plaintiff is apprehending that defendant firm may at any point of time sublease the property to any third party. My lord, kindly marks the date 11th of June. May 2025, I have already, my lord, created third party rights that I will show from his document as well as my plaint case.
Yes.
That is why plaintiff has filed an application for injunction and moved for ad interim injunction so that defendant respondent firm may be restrained from assigning, selling or creating. My lord, the allegation was I was subleasing, but the, my lord, prayer was restrain me from assigning, selling or creating third party interest. Now kindly turns the page, what order the court passes, page 47. Second para, balancing the situation and considering the facts and circumstances of the case, both plaintiff petitioner firm and defendant and their main agents and associates are directed to maintain status quo in respect of the premises number so and so.
Yes.
As regards possession, nature and character till 11 July.
Yes.
My lord, possession I had already parted with because the fit out period for the third party had started by then. Now, my lord, I go to the division bench challenging this order. My lord, kindly takes, my lord, page 78. In my appeal, this is the, my lord, order which the Honorable Division Bench passes. Paragraph 2. We modify the impugned order to the extent that appellant shall not act in derogation of the agreement dated 25th January 88 till disposal of the injunction application. Mala 25th January 88 is the clause which I showed from that agreement. So I will not act in derogation of that agreement, meaning thereby I will not transfer or assign, but I can sublet. So, my lord, I got this clarification. My lord, this order is passed on 20th of August. Realizing this, immediately they terminate my tenancy on 22nd August at page 79. No, my lord, quarrel with this. They have a right to terminate if they can establish, my lord, later on, my lord, that this right was there. So they terminate. My lord, after termination, what they do is, my lord, on 13th of September, they sent, my lord, their, my lord, persons and local, my lord, goons to, my lord, forcefully evict, my lord, the person who is now, my lord, put into possession by me. My lord, paragraph, my lord, at page 80, paragraph 2 is, my lord, police complaint to the local police station about the, my lord, incident that happened on 13th of September. 15th of September is the date of, my lord, lodging of complaint. And in my plaint, my lord, kindly takes 2 paragraphs regarding the urgency at page 11, paragraph 24 and 25. And this step they take, my lord, only because I got that order from the division bench clarifying that I can, my lord, I will only not act in derogation of the agreement. My lord, kindly comes to page 11, para 24. Plaintiff contemplates urgent interim reliefs in the suit by the notice dated 22nd August 25 received by the plaintiff on August 25, 25. The defendant had threatened the plaintiff to evict the same on expiry of 15 days from the receipt of the notice. Said 15 days period expired on so-and-so. Defendant was always aware that plaintiff had subleased the premises to a third party and business operation of such third party is being carried out in the premises. On or about 13 September, defendant sent its men, agents and hooligans at the premises who entered into the suit premises and
where your tenancy you have created?
My lord, that is also there, my lord, in the plaint itself, my lord, I have said, my lord, kindly comes to para 7. By virtue of, my lord, 6 and 7, plaintiff has been in possession of the said premises, utilizing the same for commercial purpose since January 88 and has observed and honored all the obligations recorded in the agreement. There has never been any dispute with regard to possession of the plaintiff in respect of the premises. By virtue of the rights granted to the plaintiff, plaintiff has sublet the premises in favor of a third party in or about May 2025. Plaintiff was in actual physical possession of the said property since 88 and is continuing to be in possession of the said property through sublessee at present. Now, in their city civil court plaint also, my lord, May 2025 is admitted. My lord, the plaint is annexed, my lord, at page 48. My lord, kindly comes to page 58, capital A. My lord, type copy is there.
58.
58, capital A.
Yes.
And if required, my lord, I can produce that document also because it is an urgent filing, my lord. I have that 30-day window, my lord, to put in, my lord, additional document, which would be the agreement with the third party. Para 12, it is with deep concern that plaintiff reports a troubling incident occurring on so-and-so. On this date, representatives of the plaintiff suddenly observed defendant beginning to vacate the lease property and relocate assets. My lord, I had the right of subletting. I was, my lord, removing my lord, articles which were there so that, my lord, the subtenant.
What you are praying for?
My lord, kindly comes to this, my lord, prayer, relief in the suit, my lord. At page, my lord, 14. My lord, the right which flows from the agreement of 88, which is now being interfered with despite the division bench order, I need, my lord, a declaration to that effect that this right to sublet is in accordance with that agreement and that the defendant does not have a right to terminate that agreement. For the present, my lord, kindly, my lord, comes to page 15, which is very important for me. Page 15, prayer D. This perpetual injunction, in aid of this perpetual injunction, I would be seeking an interim relief in the suit so that, my lord, during the vacation, I don't suffer, my lord, an eviction without the due process of law.
Yes.
This is, my lord, the urgency. Hence, I am, my lord, praying before your lordship to my lord kindly dispense with the mandatory my lord pre-institution
Why
requirement.
you not gone to the mediation?
My lord, it won't, my lord, happen, my lord.
Why?
After the division bench order, lordship sees the conduct of the party, my lord. I cannot, my lord, if I go, my lord, if the position goes in the meantime, my lord, I will have nothing left, my lord.
The plaintiff has filed the suit praying for declaration and perpetual injunction. Plaintiff also prayed for dispensation of the mandatory provisions of section 12 of 12 capital A of the Commercial Code Act 2015. Mr. Rashid Datta, learned advocate appearing for the plaintiff, submit that on 25th of January 1988, an agreement was an tenancy agreement.
Yes,
was
that's
entered
my lord.
between the plaintiff and the defendant, wherein the plaintiff has been inducted as a tenant with respect of the suit property. Inducted as a tenant in respect of the suit property. It is further submitted that as per the agreement, the tenant has a right, is entitled to sublet the tenancy on such rent, on such terms and conditions as the tenant may deem fit and proper. But the tenant shall always liable to make the payment of rent regularly to the defendant being the landlord.
My lord also takes page 41, subclause E. That is, my lord, the condition on which he can terminate.
Consider for the Mr. Datta further submit that as per the said agreement, the defendant being the landlord only can terminate the agreement, terminate the tenancy if the plaintiff being the tenant willful breach any terms and conditions of the said agreement. Mr. Datta submit that as the defendant being the plaintiff being the tenant has the right to sublet the premises in question, and accordingly in the month of May 2025 has subleased the said premises to third party and has handed over the possession to the third party for running the business over the premises. The defendant had initiated a suit before the
City Civil Court, my lord.
City Civil Court before the Judge Bench 6 City Civil Court Calcutta, being title suit number 1036 of 2025, and also prayed for an ad interim injunction. Accordingly, the learned judge has passed an ad interim injunction restraining the defendant, his men, servant, agents, or associates, and also to maintain status quo in respect of the premises with regard to the possession, nature, character, and possession of the property. Being agreed with the said order, the plaintiff has preferred an appeal, and in the appeal, the appellate court has clarified
It's 78, my lord.
order passed by the learned judge by modifying that the appellant shall not, the defendant plaintiff shall not act in derogation of the agreement dated 25th January 1988 till the disposal of the injunction application. He submits that after the order of the appeal, immediately on 22nd of August 2025, the defendant has issued a notice by terminating the agreement entered between the parties. And subsequent to the termination, the defendant has also sent several persons to evict the plaintiff from the suit premises.
My lord, no breach alleged in the notice.
Premises. He submitted that in this, though the defendant had issued the notice of termination, but no allegation with regard to the breach of any terms and conditions of the agreement. As the defendant has sent some persons to evict the plaintiff from the premises in question, accordingly, the plaintiff has made a police complaint, which was duly received by the officer in charge of the Shakespeare Sereni police station. Counsel for the Mr. Datta submitted that from 27th, the puja, ensuing puja vacation is going to be started, and the defendant is taking every course for evict the plaintiff from the premises in question by taking the law in hand. And as such, if at this stage the plaintiff will be allowed to, and as such, at this stage, plaintiff is not in a position to go for the mediation. And if the plaintiff will initiate the pre-institution mediation, comma, in the meantime, the defendant will illegally evict the plaintiff, and the grievance of the plaintiff will become infectious. Accordingly, he prays for leave under clause 12 capital A of the Commercial Code Act. Had the learned counsel for the plaintiff peruse the materials on record, this court find that the defendant has already initiated a case and also obtained an order of injunction. In the injunction order, the appellate court has clarified that the defendant and the appellant shall not act, and the appellant / plaintiff herein shall not act in derogation of the agreement dated 25th of January 1988. It is the specific case of the plaintiff that the plaintiff has already inducted one tenant in the premises on 15th of May 2020, in the month of May 2025. That is prior to the order passed by the Leonard City Civil. And the defendant had the knowledge with regard to induction of the tenant by the plaintiff in the said premises. In spite, the defendant has filed a suit against the plaintiff, but in the meantime, the defendant had terminated the tenancy and also threatening the plaintiff for eviction of the premises illegally. Considering the above, this court finds that the plaintiff has made out a case for urgent relief, and accordingly, leave under clause under section leave for dispensation of the provisions of section 12 capital A of the Commercial Code is granted. Plaintiff is admitted subject to scrutiny.
My lord, I have filed the GA, but because my lordship now follows a practice that unless the plaintiff is admitted tomorrow, my lord, I'll just get the number and give you.
The plaintiff submitted. The plaintiff has filed an urgent interim application. Let the same be placed before this court tomorrow.
Very grateful, my lord.
Lord, before your lordship takes up the next matter, I was there when I was trying to come, my lord. But should I file the report as the commissioner today, or should I file it on 4th November?
Let them pay
Ready,
the,
my lord, I can file
let them pay the amount.
My lord, I beg to appeal for the plaintiff, my lord.
Yes.
Representation of plaintiff, I am here, but there is an dispensation, pay for dispensation of 12A of the Commercial Courts Act.
Why?
Yes, my lord.
What is the urgency of the dispensation?
Is urgency is we have make a farm with 3 members, 2 plaintiffs or 2 others. First and second partnership. Registered partnership deed. Whatever may be. Third partner, that means defendant herein, who is under the charge of the farm regarding the business transaction, bank transaction, everything. But what happened, my lord? He squeezed all the monies from the business account, one after another. One after another.
When you came to know what the
Yes,
is siphoning of the amount?
Yes, my lord. Each and I came to know from on 16/6/25.
2025. And finally on 14 July 2025. Correct. Where is the document that he is siphoning of the amount? Have you disclosed the document?
I filed the document within 30 days. Whatever. But I have written everything detailed.
But the your main case is that he is siphoning of the amount from your account. That's why if you go to the mediation, then it will. Where is the document that is siphoning the amount?
I am telling you paragraph wise, I am telling everything.
Paragraph, but where is the document, sir?
Doc.
It is a bank account.
What happened? One document I can show immediately. This defendant, without the consent of the other partners, have an agreement with the Zomato. Here is and accused money
Agreement with the Zomato.
Zomato. Kindly look at my lord.
What is your partnership?
Mine-
What is your partnership?
Partner,
It's a restaurant business.
Restaurant.
restaurant business, my restaurant business, a franchise,
Catering.
restaurants and catering, franchise of the Korim, my lord, Korims. Kindly come to কত নম্বর এটা বলো paragraph 16. Yes, my lord. Paragraph number 16, please. Paragraph number 16. That the defendant taking the opportunity of the direct dealing with the clients, the defendant had started to fraudulently seize the eminent clients. Just the clients, nothing here is. All clients have been in the city by suppressing the same to the plaintiffs and provide service in the alternative method, as the defendant was a responsibility to manage the public relation through the social media, whose details he never shared with the plaintiffs. Taking these opportunities, the defendant had executed an agreement with the food delivery agency, namely Zomato, since September 2024 for his own profit, using the name of the said partnership firm and taking capital of 7 lakhs per year. Kindly look at annexer, kindly look page 140.
That is September 2024.
Yes, madam.
No, we are on September 20 after 1 year.
We came to know on the 16th. We came to when he to escape from these all sorts of things. Which from all
As per the partnership deed,
he cannot.
Who can maintain the account?
Anyone can maintain the account.
So you are not knowledge with regard to that he is siphoning up the amount from the account.
It was not. It is beyond. I am not informed.
You are also the person can maintain the account.
Yes,
so you are not vigil for that.
My lord, I have written. My lord, due to the sudden death of the father and mother, parents at a time,
Whose?
plaintiffs, he has not any way to look after his business. But page 7, kindly. Page 7, kindly.
Yes.
My lord, the plaintiffs had ample faith and reliance on the defendant, for which they have delegated the responsibilities of handling the above said vital business bank account.
Okay, here you go for the mediation. What is the urgency now?
Urgency, if your lordship now restrain this defendant.
2024 agreement was done. July 2024 onwards, he is taking the amount. Now you are June 2025. And final amount was taken 25. Why you have not initiated the mediation process?
So mediation, if I go to the mediation, my all account will be, all money will be snatched.
You are also signatory. You can make a request to the bank not to release. You take you are the 3 persons in the partnership. Correct. And both you are 2 with you and he single. If you take the resolution in the majority and give the resolution to the bank, stop the account.
Whatever
what is the necessity of the order of the court and go to the mediation?
But he is using our goodwill, our name.
Everything is
interest, own capital, our capital for his own business.
You are having the partnership. Where is the what is the condition of the partnership?
Condition, yes. Partnership, page 21.
He is taking all the raw materials from our suppliers and did not give the money. We have to pay him.
Okay, go. But where is the?
restraining order, my lord, required, my lord, kindly, this man is taking all the goodwill, all the fame, all raw materials and money and the clients, my
So
lord.
this amount you are claiming the damages, 5,50,000
Yes,
5
sir.
crore
Five-
damages.
No,
For the damages, how the injunction can be granted at this stage? Let them know. You go for that.
No, madam.
That's how the injunction can be granted.
my lord, injunction petition is ready, my lord.
Correct. But you are claiming the damage.
Yes, my lord.
Damage, how the injunction can be granted?
My lord, if the defendant has not registered, my lord, my bank account will be flushed.
I am not satisfied with the 12A, sir. You
My lord,
come
what-
with a good case, I will allow. With 12A, nowadays it is very strict.
I know, my lord.
Then,
Whatever may be the question, kindly look at it for a moment, my lord.
if you want, I will allow you to withdraw and go to the mediation and use the court fee.
My lord,
That I can grant you
My lord,
for the
kindly,
time being.
my lord, kindly look at for a more kindly look at my lord. What happened?
It
The
is damaging our total entire business, my lord.
But the court cannot
my lord, paragraph,
claim the damage.
my lord, kindly allow me to read for paragraph 4 and 5. Nothing more. After successful running of the restaurant business in the year 2018, the plaintiffs and the defendant decided to expand the business whatever may be the bottom from the business account. He has defendant has casually a systematic fraud defendant 26 lakh something 70 lakh something etc. So what happened, Miller? What happened? If the defendant has not been restrained, all lakhs of rupees will go.
I appreciate, but
What I appreciate, Miller.
there is some
What I appreciate, kindly look at my.
there is some law. There is some law for granting the 12A. You satisfied that condition of the 12A. Regarding injunction is different thing. Whether the court can grant injunction, that is, I am not on injunction. Now at this stage, 12A, what is the how the 12A can be granted?
Each and
Tell
everything.
me, what is the urgency of it?
Urgency, madam, bank, urgency, defendant be restrained from use the money from bank. Nothing more. Urgency this. Bank.
He wants to, my lord, now he wants the
My lord, kindly appreciate my position. At the puja, at the ensuing puja, my lord, my restaurant will be going to be closed.
File the present suit,
in the
paying for a
in
decree
the
for sum of interest 55 crore 55 lakhs. Along
To avoid these circumstances, they file a resignation letter, which cannot be accepted.
12% per annum. Plaintiff has also prayed for leave under clause leave for dispensation of the provisions of section 12 capital A of the Commercial Code Act. It is the case of the plaintiff. If you want I pass an order on merit or you want to withdraw the matter. I am giving again you liberty. Then I have to file then order on merit. Then it will be difficult for you.
My lord, may I submit one thing, my lord? Huh? May I, my lord, kindly keep it, and I will, in the meantime, I go to meditation.
No, that is not.
That
I am allowing you. You take back. I will allow the court fee also. Go to the mediation. Come
Yeah.
after 3 months. That will be better.
All right.
Okay, wait for so na. Good. Now the plaintiff prays for leave to withdraw the suit so as to enable the plaintiff to institute pre-institution mediation process. Accordingly, plaintiff is granted leave to withdraw the suit, liberty to file, liberty to take appropriate steps for pre-institution mediation process. Accordingly, CS Com 143 is dismissed for default, but it is made clear that this dismissal will not prevent the plaintiff to initiate a further suit if the matter is not settled in the mediation. As the suit at the time of admission, the suit is dismissed as withdrawal. According, the department is directed to refund the court fee to the plaintiff. What the correct? Item number 5. Yes.
Please, my lord.
My lords, on the last occasion, my lords had directed contender number 4 to be present before my lords at every hearing. Contender number 4 is present today, my lords. He had surrendered on the last occasion also. And contender number 2, which was his son, my lords, he had appeared before my lord yesterday. And my lord had kept his arrest at abeyance, subject to a payment of 1 lakh rupee bail bond, which was accordingly done. My lords, on the 18th, when we were last before you, there was an application, my lords, which was not signed then, but it has now been filed, and GA number 2. My lords, this is the application on behalf of contender number 4, whereby he seeks permission from this court to sell one of his properties to this company, Mark AB.
Have you got the copy?
Yes, today we have.
Sir.
Yesterday.
My lords, I understand it was served yesterday, my lords. It could not be served physically because the offices were closed due to the heavy rains, but it was served by email. So the total sale consideration for this property, my lords, is 5 crores. 50 lakhs by way of demand draft was already made over to the other side on the 18th of September, which was the last date of hearing. And the remaining 4.5 crores, my lord, will be made over on or before 120 days, subject, of course, to my lord granting permission for the sale to go through. And the contender number 4, that is, I making over the conveyance and handing over the physical possession of the property to the those are the broad terms and conditions of the agreement. And I understand, my lords,
if you will not execute the deed, then what will happen? If this contract will not complete, what will happen?
my lords, there is an affidavit on record. This affidavit has been filed by the director. I understand Mr. Dave is also appearing over virtually today. So he's one of the directors of Mark AB, also signatory on behalf of Mark AB ATS.
Yes.
Because my instructions are that the agreement between the two parties, that is contender number 4 and Mark AB, is already in place. It is just a question of procuring the funds, because Mark AB, I understand, my lord, they need that much time to arrange.
So how much time he
120 days, my lord.
Huh?
120
120 days on the last occasion. Now the 1 week is over.
From the 18th of September, 120, not from today.
So when the part payment will be made?
Well,
Next part payment?
Part payment of 50 has already been made.
Now, with regard to this 5 crore, 4 crore.
The 4.5 will be made as
when it will be paid?
At the time of the conveyance, my lord. When the property on the date of the registration, that 4.5 crores will be paid. That entire money will be paid as a one-shot payment on the date of the registration.
So what are the requirements for registration of sale deed in Andhra Pradesh? This is Andhra Pradesh or Tamil Nadu?
This is Tamil Nadu, my lords.
Tamil Nadu. What are the documents is required for transfer of or execution of the conveyance deed?
One of the deed of conveyance and the query which we generally generate in Calcutta as well. They also generate one government report. E-assessment slip, my lord.
That's why how much time you record? 120 days, 100 days, whatever it means. So how the payment
they are
will be
also
made?
taking some bank finance. That is the reason 120 days is required.
So have you instruction when this amount will be paid? That is to be paid in the.
Hello. By 15th of January 2026, we will make the payment through RTGS, sir.
Today we are on September. October,
As
November, December.
of the 18th of September, 4 months or 100. As of the 18th of September, my lords, 120 days or 4 months is the time period that has been agreed between the parties, because I understand that is the time that they need to procure the funds.
So in the meantime, some further payment be made. Okay, that is the 5. Okay. So what is the further remaining amount?
My lords,
1 crore 92 was further remaining as on 15th of
So 1 crore, what about the other amount? Okay, this 5 or okay,
now,
no problem.
Now they have paid, my lord, 50. So deducting that, it is 92 lakhs, which is outstanding on account of interest as on 15th of September.
my lords, the only request that I can make, my lords, this my lords had earlier directed or ordered 18% interest. My lords, this property that I am selling, is it as it is, my lords, with a great amount of difficulty, I've finally managed to find an investor. It is any which way in the nature of a distress sale, my lords. The only plea that I have, and I bow down and I concede, my lords, that yes, there were a number of assurances that I've given to this court, and I could not keep up with those assurances because of the financial constraints that I was facing. Today, my lords, because I'm so close to consummating this deed, my only request is that if that 18% interest, my lords, if not completely waived, at least a reduction may be considered. To give me
What deduction?
12%, my lords, because at least some
You are not carrying out the order and you're asking for the reduction now. They were admitted on the earlier first occasion itself that they will pay the interest if there will
lords,
be delay. Now, court has not imposed the 18%. They have agreed for
They have
that.
filed their affidavit saying that I will pay.
Undertaking they have filed.
Which ultimately, my lord, subsumed into a court order. So,
How it can be?
So
Whether the court can review the order, then that too in undertaking. Okay, 4 crore 50 lakh, no problem. Okay, I am fixing on January, no problem. That will be if they are undertaking. But what about the interest portion? You paid that. In the meantime, I am fixing in November or middle of November. Pay the interest part.
My lord will at least consider some reduction.
Pay the interest part.
18%.
One other submission, my lord. We had consented to reduction of the amount from 13 crore to 8 crore.
Correct. That's why
13.5 crore was our claim in the suit. We said very well, it fell from your lordship, we bowed down to it. We said, okay, we want to settle.
So the total 13
further
crore.
we cannot.
It was settled before this court on 8. Again, you are
my lords,
intending to
my lords, those are the bare facts, my lords. I am only making this plea with folded hands because genuinely, my lords, I'm in extreme financial constraints and hardships.
So why you are agreed for? You could have been contest. Why you are agreed
my
for?
lords, at that point of time, perhaps it was the situation was different.
No such situation. They came and they.
Because the company
That time there was no more.
Company also, my lords, CIRP is on the head of the company. Any day that CIRP order can be made.
Yes.
Not interest, my lord, we are.
No, I am not passing any interest order. What about this 4.5 crore? They want the January 15. But January 15, you all persons will be busy in your festival of the Sankrant.
No, that is not the question, sir. We will make the payment.
And you will take the plea. Yes, there is Sankrant, our festival.
No. What we commit, we will honor that, sir.
Not only one thing, my lord. Not only one thing. But if your lordship kindly to ensure that there are sufficient checks and balances, kindly also indicate to him, subject to what falls from your lordship, that if he commits, he has already sworn an affidavit before your lordship.
Yeah, that's what
so he should be, my lord, responsible for that, and the consequences would be. The other thing is, my lord, the amount, my lord, would be, my lord, paid directly to the petitioner. So it is not that routed through their bank account. So whatever amounts they paid, either by way of a demand draft or a bank transfer, directly to my client. So, my lord, these possibly two, my lord, otherwise we have no option but to wait till January.
You are intending to make the payment, you
Sir,
mention the matter before this court, then the payment can be made in the court.
My lord, the agreement to sell, which has been placed on record, that agreement to sell records that the payment of 4.5 crores will be made over to this party.
Where? Which clause? Then when he come, paragraph 16, dispute in the arbitration, then he will be tagged with the arbitration.
My lords, these are
then
the
section 9, section 8.
It is at the end of the day an agreement, my lords, between a party that is involved in this matter.
So it will never be ended matter.
My lords may have clause 4 of page 18.
But Mr. Gupta will be happy for that.
No. My lord, my clients have suffered a lot, my lord. It's my duty to put an end to that sufferance, my lord.
Clause 4, my lords, page 18. That the balance sale consideration of rupees 4.5 crores will be paid directly to Terai Overseas Private Limited, creditor of the vendor, simultaneously at the time of execution of the sale deed and handing over the vacant physical peaceful possession of the property. So to that, my lord, there is no contest. I'm not contesting my learned request.
Yes, sir, if they transfer and we get the possession of that particular land, we will definitely make the direct payment to the party.
Have you verified the property whether it is free from all encumbrances?
Yeah, we.
It is free from all encumbrances. Then tomorrow he will say it is not income. It is not possible to pay the amount.
No, no, my lords. It's free from.
Lordship is contemplating from all possible.
My lords, my
Because
lords,
it is.
my lord, you will all, my lords, 50 lakhs, my lord, has already been paid by this same party to Tera
Well,
University.
now I am not on that.
So
maybe 50 or 60,
my
but
lords,
tomorrow he will say
as an independent purchaser or investor, my lords, they would only pay that even 50 lakhs, my lords, is not a small amount. So they would pay that significant amount of money having done that.
not with regard to payment, whether the land is free from all encumbrances so that the deed can be executed.
Very well, my lords. So the 50 lakh payments, I'm saying this, and I'm assuming Mr. Dave would also say this. I mean, he would concur with me that it is only when they satisfied themselves in all respects as to the property that they have made out this payment.
But only thing, my lord, your lordship would kindly not vacate any injunction order or anything. It restricts it particularly to Mr. Dave and that company.
This particular land.
This particular.
But
land. Otherwise, my lord, let the restrictions be there, and my lord, the interest your lordship would keep it open.
Alleged contemner number 4, namely Sudalaganta Jairam Chaudhary, has filed an application praying for allowing the alleged contemner number 4 to execute sale deed of the property as described in Annex A of the present application in favor of Mark Mark AB Capital Investment India Private Limited, so as to enable the alleged contemner number 4 to pay an amount of rupees 5 crore to the petitioner. Full stop. In the said application, the alleged contemner number 4 has also disclosed the copy of the agreement for sale dated 17 September 2025 entered between the defendant number 4, the alleged contemner number 4 and Messrs. Mark AB Capital Investment Private Limited through its director, Mr. Atul Dave. In the said agreement, it is mentioned that in the said agreement at clause
4, my lord.
Clause 4.
Clause 4. Clause 4 of the ATS.
But could I take your lordship's leave, my lord? My learned junior is him.
At clause 4, the following clause 4 of the said agreement read as follows. Clause 4 of the said agreement read as follows. Date of provisions, page number 18. The alleged counsel for the alleged contemner submitted to complete the negotiation and for registration of the conveyance deed will take about 4 months. Accordingly, he prayed for 4 months to complete the registration of the conveyance deed so as to enable the alleged contemner number 4 to pay rupees 5 crore to the 5 crore, out of which 50 lakhs has already been paid and 4 crore 50 lakhs shall be paid to the petitioner. Mr. Dave, being the director of the proposed, being the director of the proposed purchase company, has also filed an affidavit stating that filed the affidavit stating the following. Filed the affidavit wherein in paragraph 4 the paragraph 4 of the said affidavit that says for it appears then. Considering the affidavit submitted by considering the application submitted by the alleged content number 4 and the affidavit filed by Mr. Dave, who is the proposed purchaser of the property in question, this court has allowed the alleged content number 4 to complete the sale of the property in question. That is which property? Where is the schedule?
My lords, it is at Exhibit A,
Which is Annexure A of the present application. Present application within a period of 4 weeks from date, 4 months from date, but it is made clear that no payment, it is made clear that the proposed purchaser, namely AB,
Mark AB Investments.
Mark AB Capital Investment.
Mark AB
Capital
Investment Company
India
Private Limited through its director. क्या बोला? Purchase namely concession through its director concession, so shall not make any payment to the alleged content number 4 with regard to the sale of this property to the alleged content number 4, and shall pay the said amount directly to the petitioner. Directly to petitioner. Let full stop. The petitioner,
My lord, it is at the time of execution of sale deed.
Directly to petitioner at the time of registration of the conveyance deed. It is made clear that the alleged content number 4 as well as the proposed purchasers shall make necessary arrangements so that the registration of the conveyance deed be completed within a period of 4 months from date, and for payment of the balance sale consideration of 4 crore 50 lakhs to the petitioner. This is the full stop. Who has filed the report?
I believe the
special. A report has been issued from the police station, Tirupati.
Sir, namaskar, sir.
Yes.
Sir, namaskar, sir. This is Srinivasan, sir, East Inspector, sir, SHO East Police Station, sir, Tirupati, sir.
You do one thing, but the other contempt number 2 has already surrendered before this court, and this court has released on interim bail.
Yes,
with
sir.
regard to the lady, they have stated that she is the bedridden.
Yes,
Correct?
sir. Yes.
Only you do one thing, you go and check if whatever the medical documents, if she is bedridden, please submit the report. So that
Yes, sir. Yes.
you need not to, submit the report, then I'll pass appropriate order with regard to that warrant against
Yes.
the correct. You submit the report whether she is a bedridden or not, and what is her condition.
Yes, sir. Definitely, sir. A small submission from police side, sir.
Yes.
Sir, all police personnel are engaged in a Srivari Brahmotsavam, sir, with the VIPs and VVIPs, sir.
I know how much time you required to submit the report. Tell me this count.
Sir. After October 2nd, we'll be free, sir. They are definitely after October 2nd, it will completed, sir. Please, sir.
So I am fixing this first week of November. You file the report on that day.
Yes, sir. Please, sir.
Okay. The officer in charge of the Tirupati police station, Andhra Pradesh, has submitted the report stating that I am praying for some time for execution of the warrant against the alleged contender number 1. Considering the
My lord,
error made by
can
the
I-
officer in charge, Tirupati Police Station, the officer in charge is directed to submit the report before this court on 6th of November 2025.
My lord, may I make a request?
On the said date, the alleged contemner as well as the proposed purchaser are also directed to submit the report, submit and supplementary affidavit with regard to the status of the process of negotiation and registration of the conveyance deed.
My lord, may I make a request? On the next date, my lord, at least contender number 4's appearance.
Now his appearance is required. That I cannot.
Virtually, my
Or
lord.
virtually, maybe he may be.
Tomorrow he will withdraw but he will remain. You can withdraw your wakalatnama. I will allow your wakalatnama, but he has to appear. This court has no faith on him.
My lord, three things to be pointed out. My lord has indicated in the order that the schedule is as per Annexure A. My lord, perhaps paragraph 3 of the affidavit of the proposed purchaser has a better description of the schedule, because here in Annexure A, all the taluka and the moza numbers are not mentioned. So, my lord, perhaps that is a better detailed reflection of the schedule. Page 7, para 3.
ऊपर schedule बोला ना, annexure बोला ना, of the property in question, which is the details of the property mentioned in paragraph 3 of the affidavit submitted by Mr. Dave.
And one more issue with regard to the previous day's order, which my lord had passed on 18th of September. My lord, at para 7 of the order, perhaps, my lord, there is a requirement of correction. My lord, the order at the last word, it says that monthly payment as per the undertaking given by the petitioner. My lord, perhaps it will be the contemner's undertaking. So, my lord, the word petitioner may become contemner, my lord. Paragraph 7, page 3. The last word, my lord. And my lord, may I
Paragraph?
Paragraph 7.
7, my lord, last. Petitioner director serve the copy of the chart to the counsel for the contemner, alleged contemner director to make necessary arrangement for monthly payment.
As per the undertaking given by the alleged contemner.
Holy court. The counsel for the petitioner had drawn the attention of this court to the order dated 18 September 2025 at page 3, paragraph 7. The last word shall be read as alleged contemner instead of petitioner. Okay.
Well, two other things subject to what falls from your lordship. Your lordship had indicated that some balance should be paid in November.
No,
So
so November they submit the report. What is the status they are going?
that is that is. But with regard to payment, because interest around 1 crore would be
Yes,
due.
what about the interest?
As on that date.
Pay the some interest.
My
On
lords,
that.
I'll have to take instructions on this.
Come on that day, so with some interest.
Kindly indicates that in the order.
This court, the contemner is directed to make some, and the counsel for the petition submit that other than the principal amount of rupees 4.5 crore, interest of rupees
92 lakhs was due as on 15 September.
Interest of rupees 92 lakhs.
92 lakhs.
92 lakhs is due was due as on
15 September.
15 September 2025. Accordingly, the alleged contemner is directed to make some of the payment of interest on the next date fix. Let the matter appear on 6th of November.
And an injunction on him to sell the property to anybody else barring Mr. Davis.
Only this property.
Only this. Great.
I am appearing for contemner number 5, 6, 7, and 8, Lordship.
I'm so grateful.
Who deposited? What check? What amount? 5 lakh. No, I have not listed. If they violate, then he has to deposit. Release.
Last order आते थे जैसे.
क्या है ये?
Number 6.
Well, in this matter, I am appearing for the alleged contemner number 1 and 2, my lord.
Appearing for the first time, it's appearing for the second time. First time after notice.
Yes.
Lordship will kindly allow me to file my show cause, my lord. File my show cause, my lord.
Would like
On
to
behalf
file
of
an affidavit in opposition. I'm
opposition, my
standing in the way. Let them file an affidavit. Contempt of your lordship's order dated 8th of August 2020.
Counsel for the alleged contender, press for time to file affidavit compliance. Let affidavit compliance be filed
my lord, after vacation.
by 2 weeks.
2 weeks after vacation.
After ensuing puja vacation. 2 weeks after ensuing puja vacation. Reply if any there to be filed within a week.
2 weeks.
Within 2 weeks thereafter. Full stop. Release the matter on 3rd December 2020.
Great.
May I just say this, Malad? Next item, Malad, item number 7, Malad. Malad, first it should appear as an adjourned motion. Next, Malad, the point is, Malad, the defendant number 2 has appeared today, Malad. It is my application, Malad, for transfer from the commercial to non-commercial.
Yeah, it's
I am for the defendant, Malad, whatever the matter is. And defendant number 2 has not been served with anything, Malad. So he will be asking for a service, Malad. So if your lordship takes up the matter and passes.
What service?
I'll indicate it is
Well, I have
it's not permitted. I'll indicate why, my lord. This is not an application, my lord, for transfer to commercial division. Lord, it's an application, my lord, for recalling of an order
I don't have a
by which
problem.
this honorable court has, my lord, suo moto transferred the matter to commercial division. It's for recalling of that order. So
But
it's
I will
not
come to that.
really,
I am-
it's
I am
not
quite
really an
aware.
application, my lord,
I'm
for
quite-
transfer from commercial to non-commercial. That's
I'm
number
quite
one.
aware.
So, my lord,
Mr.
adjourn motion, let it come up as motion, my lord.
Yes, let it come as
We will,
motion.
and
But I'll only
secondly, my
ser-
lord, defendant number 2, every aspect of the matter is closed for defendant number 2. I'll indicate when the matter is taken up, my lord, for consideration. So
asking
nothing
for a service,
really,
I
my lord.
have to serve
It is not really, my lord, a case where kindly keep it, my lord. Any day we'll come and
I
argue the
serve
matter.
him. That's only what I said, Malad. Mr. Bagh is
Yes, they can serve definitely, but
want to serve.
they didn't. Of course, but they can. They have the, my lord, all the
If
liberty.
you accept, then I will direct to serve.
The difficulty is not if they want to then again file an affidavit to this, then we are in trouble.
That is
Because
their
that is the
problem,
reason. It's
but-
our suit, my lord. We want the proceeding to
Malad, he
continue.
came
That's the
up to
reason.
me and said you have not served the application.
Okay, you take care. You have received the application.
We are the plaintiff. We have it.
Mr. Bagh,
Whom you will serve?
Malad, defendant number 2.
Defendant number 2. We are the plaintiff, my lord. Defendant number 1 and defendant number
He's
2.
wanting a service. I said, okay, I'll give it to you. I did not think that he was entitled to. He came up. That's why I thought I'll just.
What the
start it
dependent number 2 will do?
Indeed.
Nothing,
Indeed,
Malad.
my lord. They don't
Absolutely
really
nothing.
have a role at all in the matter.
Nothing, Malad.
It's plaintiff and defendant number 1.
I don't even have a copy of the amended plaint, my lord. So
That's not required. I'll indicate why.
We recorded, my lord, that.
All the orders? No, it is not. My lord,
Ah.
we'll indicate when the matter is, my lord.
Defendant number 1. Defendant number 1 has filed an application being GA-Com 8 of 2024, praying for recalling of the order passed by this court, wherein the case has been transferred from the non-commercial division to commercial division. The defendant number 1 has already served the copy to the learned counsel to the plaintiff, but the learned counsel appearing for the defendant pressed for a copy of the same. Accordingly, the defendant number 1 is directed to serve the copy along with the documents of GA-Com 8 of 2024. The learned advocate on record of the defendant number 2 in course of.
We'll give it to him today, Malad.
By
The copy of the unamended plaint, my lord, that also.
That's not on me. That's on him.
That we
That is
won't,
the
my lord. I'll
plaintiff.
indicate why.
that by 26th September 2025, release the matter on 11th November.
11th November. I'm very deeply obliged.
And he got so excited, Malad.
I had to, my lord. Mr. Rai is arguing. I have to. He wanted to place this in adjourn motion.
Puja is going on. Huh? That's.
Yeah, but I thought he's getting ready for some kind of a music conference. He's getting ready for it.
That's why he has mentioned.
That's the reason. My lord. That's the reason. I'm very deeply obliged. My lord.
Copy of the plaint.
No, they can't. my lord. It's an
Right to him, maybe they give, then they will say to them.
We can't. I'll indicate. Very deeply.
Come.
Item 8, my lord, the
Ah.
very next matter. My lord, this was Mr. Mitra was arguing this matter, my lord. Because of waterlogging, my lord, he could not leave his home today also. My lord has requested if it can be on Friday.
Tell Mr. Mitra to change your residence. Why are you residing that area?
More shady of
Still stuck at home because of waterlogging. Even all the cars are floating.
After vacation?
Either Friday or after vacation.
Friday it is.
Then after item 8.
Plaintiff. You are for the plaintiff.
Well, I'm the plaintiff respondent.
Counsel for the plaintiff. Press for. Fix the matter after puja vacation. According cases adjourned, let the matter appear on 12th November.
Grateful, my lord. Deeply
Yes,
obliged.
call the fixed matter.
And I am appearing, my lord. I was fixed for my reply, my lord. Your lordship will recall, my lord, the partition suit, order 7 rule 11 has come. And that too, my lord, this order 7 rule 11 was argued for days together. I will try and complete it within half an hour. It's very short, my lord. Only thing is that I will have to deal with their judgment. That might take a time, but I have, for convenience, I have prepared a short note also, dealing with their judgment, my lord, so that it is easier for your lordship, my lord. Kindly see, my lord, 3 points have been taken in their argument in order 7 rule 11.
Yes.
First is, it is ex facie barred by limitation. Then number 2 is, substantial part of the allegations are barred by the provisions of the Companies Act 2013. And the third and the first are actually overlapping. They are saying that there is no cause of action since there is a settlement you have pleaded. There is no disclosure of cause of action, and you have asked for declaration. I do not. Now, my lord, let me show your lordship the plaint. Now, the basic principle, my lord, which your lordships follow is that, my lord, one cannot take one line out in isolation.
As a whole.
As a whole, it has to be taken. But if your lordship sees the partition suit, what is the nature of the partition suit? Well, your lordship will kindly see. It is saying that my father started a business. If your lordship comes to paragraph 6 at page 22.
Yes.
Kindly see, Radhesham Gupta, sometimes in the year 1972, started a timber manufacturing unit by the name of National Industrial Corporation, which was a sole proprietorship concern. Thereafter, name of National Industries changed to Bihar Plywood. Proprietorship business commenced from a rented business at Ranchi. Business ran for 30 years, ultimately closed. Timber and next line. Timber and plywood manufacturing, which in time started flourishing, for which Radhesham Gupta purchased the aforesaid rented premises, which consisted of 1.0 and a house property thereat. Later in the course of time, plaintiff and defendant number 1, 2 sons, also joined late Radhesham Gupta in such business, helped and assisted him in running and expanding the same. Defendant number 2, who was still quite young, later on joined the said business. So, nucleus of the family is the father's original business. 3 sons later on joined, the business expanded, diversified.
Yes.
This is the case, my lord. Kindly see paragraph 8. This is an usual family business, my lord, plaint. Nucleus and or corpus of the joint business further increased. Subsequently, out of such corpus, further properties and assets were purchased. And next line, new companies were taken over and floated, which were dealt with, which also dealt with same as above, by which an empire was created by the Radhesham Gupta and his 3 sons. Such properties and assets were purchased and acquired either in the name of family members or in the name of the companies and other entities belonging to the family, or by acquiring the company owning properties. Defendant number 8 to 15 are some of the entities, kindly note, which have been created and taken over out of funds generated as aforesaid. So, my lord, this is the foundation. All these companies which we have implemented, we are saying that those are family companies. So, my lord, even if this company, only elder son and younger son is the director and shareholder, but it is the nucleus from which it has grown. So, therefore, my case in the plaint is, as one son, I am entitled to 1/3 of all shares. There may be, say, 10 companies which have floated. You may be shown as the shareholder in those 5 companies, but it is in your name. It is in essence a family company. I am entitled to 1/3 of all the shares in all the companies. This is my case in the plaint. So that has to be tried on evidence, whether I can establish this, that the other companies have grown out of the family fund. That will be an issue in the suit. So therefore, there is nothing wrong in joining these companies as defendants, because partition will be claimed of the shareholding, not of the company.
Yes.
This is very basic, my lord. Then, my lord, your lordship will kindly see paragraph 11. I am just showing your lordship, my lord, the important paragraphs. After death of Radheshyam Gupta, plaintiffs and defendant numbers 1 and 2 continued to carry on business as aforesaid, jointly, each having 1/3 share or interest. So your name is immaterial. All of us are carrying on all the businesses jointly. Then, my lord, 12, joint businesses of the plaintiff and the defendant number 1 and 2 extended rapidly. And with the passage of time, income from such business was used to acquire various other business properties and assets, and ultimately keen to include inter alia assets, properties, business, firms and companies. All the family business was started and or acquired with the funds of provided by joint business. So this is the foundation. Now, my lord, thereafter, your lordship will see again, paragraph 13 is same. Plaintiff, defendant 1 and 2 continue to expand joint.
So as per your case, it is the acquired property.
Acquired property. My lord. Now, my lord, kindly see paragraph 15. So that is why I have included everything in the schedule, whatever has been acquired subsequently. Now, my lord, kindly see the paragraph which my learned friend has relied upon. Then paragraph 19, I have said some of the misdeeds which the defendant number 2 has done in relation to the companies.
Yes.
Transferring of shares and whatever it has done. These are my allegations. Most important is, lordship will kindly see, paragraph 21. This is what my learned friend is trying to say. Fact that the properties, businesses and assets were joined between plaintiff, defendant number 1 and 2 were and are not in dispute until 2011. However, taking advantage of commanding position of defendant number 2 by using a chartered accountant and being blindfoldedly trusted by the plaintiff, and also the fact that the registered office of most of the company was situated in Kolkata, where defendant number 2 was located, defendant number 2, who was in concert and collusion with the defendant number 1, has altered the position and is now alleging that some of such companies are not joined. So this is the issue in the suit. This is not an admission that it has ceased to become joint. This we are saying that your misdeed, you are contending it. That is why I've asked for a declaration. If there is no threat to my joint ownership and or joint existence, I would not have asked for the declaration. I could have simply asked for partition. But because of this threat under section 34 of the Specific Relief Act, I am asking for the declaration. Now kindly further see thereof, my lord. Yes. Kindly see the last 2 lines of this paragraph, and is now alleging. So this is their stand now,
yes,
that it is not joint. Para 22. It is thus clear that companies, properties, assets and business were joined between the 3 brothers, each having equal share. Defendant number 1 and 2 has altered the structure of shareholding as also the composition of board, in which 3 brothers owned and controlled the said properties, assets and business. Plaintiff states that such alteration is without authority and not binding upon the plaintiff. So I am not accepting this. Plaintiff further states that by reason of such purported alteration, nature of ownership has not, it could not have changed. Such properties business continued to be owned by 3 brothers in equal shares. So it is still my case that despite you having changed the composition, it still continues to be joint. In view of the above, a decree for declaration declaring that such alteration are without authority are not binding of the plaintiff, and further declaring that by such purported alteration, nature of ownership has not changed. Such companies continue to be owned by the 3 brothers in equal share.
So his contention is that this has been changed in the company.
These have been changed in the company.
So if it is company, why the civil suit?
Yes,
Why?
that is my answer.
Yes.
The answer is, my lord, your lordship, I will show the judgment that a company court cannot decide title or case of inheritance. Suppose, my lord, it is a question of non-transfer of a share where the title to the share is admitted. There you go to the Companies Act. That despite my
share, they are not included.
or there is no dispute to my title.
Correct.
But where the court will have to issue a declaration, am I the owner of 1/3 or he continues to be the owner of the shares which is registered in his name? This is a title dispute arising out of a inheritance case. It is beyond company court's jurisdiction. And this is what, my lord, the issue will be. Kindly see the last line of this paragraph 22. Plaintiff states that irrespective of shareholding and directorial pattern of the companies, such companies, including properties, business assets, will continue to remain joint. This will be the issue will be decided. It will not be decided that because you are holding a majority share, you are the owner of those shares. That will be the issue. Are you the owner of the shares? Or am I the owner of 1/3 shares? Because those have come from the nucleus of the family. So therefore, this is beyond company court jurisdiction. Then your lordship will kindly come to straight away this paragraph 29. At page 32. The defendant number 1 and 2 is seeking to deny the plaintiff's lawful shares in the joint companies, properties, business assets on frivolous and
Which paragraph you are reading?
29.
Yes.
The defendant number 1 and 2 is seeking to deny the plaintiff's lawful shares in the joint companies, properties, businesses, and assets on frivolous and baseless grounds by contending that defendant number 8 to 15 are juristic entities and cannot be the subject matter of joint property, cannot be subject to partition. Defendant number 1 and 2 are also illegally contending the independent right, title, interest of the family members, some of such companies, business, properties, and assets which are in fact jointly owned by the plaintiff and defendant number 1 and 2. These are issues in the suit. In addition, now this is the important, defendant number 1 and 2 are taking shelter of an advice of a mediator, namely Saurav Jalan, which has been communicated to the parties by way of an email dated 24th November 2012, which is not at all binding upon the plaintiff. So, my learned friend wanted to say that, look here, you have referred to a mediation settlement, therefore there cannot be a partition. Correct. So, my case is, this so-called settlement is not at all binding upon the plaintiff. This is the issue again. I am saying there is no settlement.
So you are disputing the settlement.
Exactly. Thus, the question of acting in terms.
Where is the settlement? Any document?
Well, I have pleaded in the plaint that they have given it by way of an email dated November 24, 2012, which is not a. Thus, the question of acting in terms of such email does not and cannot arise. That means I have not acted upon it. Next line is also important, my lord. Plaintiff states that until and unless the properties, companies, business, and assets are partitioned, the parties shall be pushed into further multiple litigation in order to avoid further it is necessary appropriate order. So that means 2012, whatever document you are showing, that has not resulted in the severance of the joint status. Parties have continued to be joined. Otherwise, paragraph 30 will not come. Until and unless the properties are partitioned. That means the properties have not been partitioned by a single document. In any event, well, if it is a case of immovable property,
yes,
by a simple document that cannot result in partition.
Yes.
Then, my lord, paragraph 31. Defendant number 1 and 2 have refused to account for profits, gains, and income arising from the joint properties, business, and assets. Plaintiff has called upon the defendant number 1, 2, 6, and 7 to submit full and correct accounts relating to joint business, assets, and properties, including that of Radhesham Gupta. Plaintiff has raised such demand by way of a legal notice. Now, my lord, your lordship will see. So, therefore, my cause of action
the legal
is from the legal notice, because I am saying even after 2012, I have carried on jointly. I have asked you for the accounts. You have refused to give me the accounts. You refused to give me the particular. Then I am asserting my right that now you give me the share. So therefore, for a partition, 2022 legal notice is the cause of action.
Yes.
But that legal notice is part of the plaint.
Yes.
I think the plaint has been given separately. Lordship can see from the plaint also. This is the
No, that
document.
is there for page 46. Page 46.
Okay. Yes, I'm sorry. So 46, your Lordship will see 13th of May 2022. Subject is misappropriation of fund. I have narrated the entire thing.
Yes.
Then kindly see page 49. 49, 3 paragraphs from the bottom. That my clients further state that all of you in collusion and connivance with each other remove jewelry, cash and other assets left by deceased Radheshyam Gupta and has taken all his other documents, files and other important papers in your custody, refuse to share any information. With the object to resolve the dispute, a family meeting of the successors of Radheshyam Gupta was held, and one of the brother-in-law, Saurav Jalan, expressed his willingness to take charge as mediator, and my client on good faith agreed to allow Mr. to act as ultimately he had sent an email on 25th November, wherefrom it appears, kindly note this line, Saurav Jalan has not dealt with all the properties and companies belonging to the deceased and his family and has not acted impartially. That in the said email, it appears Saurav Jalan divided 5 companies amongst addressee number such and such and my client inter alia such and such. Then, my lord, I think
that
one
last page is missing.
I think your lordship can
Yes,
take.
no, 51 after that.
But there is one more.
After that.
Oh, acha, acha.
Back pages come then again.
Yes, yes. Whereas one company, namely Olympia, along with its property at Howrah, remains as joint, but surprisingly, he kept silent in regard to 7 other companies. It has been further mentioned in the email that the individual family shares in such and such, and ones will be remitted from Kolkata office to my client, and 210 lakhs to the wife of the deceased. Further appears Suraj Jalan allowed addressee number 2-3 to enjoy major benefits. Surprisingly, Saurav Jalan did not disclose how and where from he determined valuation, and also failed to disclose which properties and assets have been taken into consideration their valuation as such. 9C. Dispute is still subsisting. So therefore, that is not a settlement or partition.
Yes.
Then on 9th May, wife of deceased, namely such and such, also expired. After her expiry, the allocated alleged share of her in the said email has also been grabbed by addressee number 1 and 3 and removed all her movable assets, jewelry, shares, bank balance, cash, etc. without knowledge and consent, without accounting for those to my client or without making appropriate division. It is also curious enough to note that addressee number 3 operated HDFC bank accounts in Calcutta in the name of my clients, Manoj Gupta, and the daughter of my clients by forging the signature and fraudulently remove the fund from the said accounts and also mutually. It may be stated that addressee number 1 and 3 are withholding all necessary documents in regard to the company's properties, and my client reason is all of you are in collusion to commit further fraud. You are hereby requested to provide detailed information as well as property and to restore the share of my clients and directorship, to provide financial details of HUF trust and individual account, and to allow me to enter into the property at Ranchi. All should be resolved within fortnight, failing with a legal action.
Yes.
So therefore, this is my categoric case in that letter that there was no partition.
Yes.
Whatever settlement you are throwing at me, that is a unilateral settlement, and I have never accepted it. And this, read with paragraph 30 shows that the properties have continued to be joint.
Yes.
So, my lord, if This is now, my lord, the scheme of the plaint. Therefore, my lord, we cannot say that since I have made a reference to a 2012 settlement, the right to first sue accrue from there. My lord, detailed submissions have been made on right to first sue. When the right to sue first accrues. I mean, this is not that case. You will have to read the plaint. 12, I have not said that 2012, I have said it is not binding. So therefore, if it is not binding, I have said the property has continued to be joint.
Yes.
So therefore, my lord, cause of action, if any, will arise only from 13th of May 2022.
Yes.
When you have refused to give me my share. Paragraph 32. Despite such demand, defendant number 1, 2, 6, and 7 have failed, neglected, refused to furnish the true and proper accounts. So this is, my lord, the first point. Now, if this is the first point, now, my lord, kindly see my learned friend was making a submission that I cannot ask for a declaration in respect of joint ownership. That is the basic declaration in a partition suit. Unless the other side admits that the property is joint. But they say that you have X share, I say I have Y share. If it is only a dispute regarding share though, then you straight away ask for declaration as to your share. Suppose the dispute is wider, like here, I am saying it is a joint family business, it is a joint family property. You are contending, no, it is my own. So therefore, first the declaration has to be that the property is joint.
Preliminary decree.
Preliminary decree. Of jointness, then preliminary decree as to shareholding.
Yes, sir.
So therefore, prayer for declaration is a must in this kind of a suit. Otherwise, my lord, I won't be able to raise an issue at all before the court. If I straight away go and ask for a partition of my, say, declaration of my share, there they will raise, definitely, my lord, written statement comes saying, no, this is my own property. You are not entitled to any share. So then an issue has to be framed. Section 34 is very clear, my lord, of the specific relief act. So, my lord, declaration, that is why the declaration has been sought for, because I have never accepted any settlement of 2012 and it has been pleaded in the plaint that the properties have continued as joint. So, my lord, now the last point is the allegations regarding the Companies Act. My lord, that straight away I show your lordship the judgment of Aruna Oswal. Judgment about that 2028 SCC. SCC 79. Kindly see paragraph 3. But a little bit of the fact will be necessary.
Yes.
Mr. Pankaj Oswal, respondent number 1, filed a partition suit being CS number 53 of 2017, claiming entitlement to 1/4 of the estate of Abhay Kumar Oswal. He claimed 1/4 of the deceased shareholding, who was holding shares to the extent of 39.88% in Oswal Agromills Limited. Deceased also held 11.11% in Oswal Green Tech. Respondent number 16. Partition suit was filed on 3rd February 17 by respondent number 1 for 1/4 each of 39.88% shareholding in respondent number 2 company, 11.11% shareholding in respondent number 16 company. This was the partition suit, my lord. Then, my lord, prayer for interim injunction in civil court. In civil suit, High Court by order directed parties to maintain status quo concerning shares and other immovable property. As on 8th February 2017, shares stood registered in the ownership of Mrs. Aruna Oswal, who continues to be the owner of the shares. Then, my lord, will kindly see paragraph 5. Mr. Pankaj Oswal, respondent number 1, the same plaintiff now files a company petition.
Yes.
Alleging oppression and mismanagement in the affairs of respondent number 2 company. Prayer was also made against Oswal Green Tech, respondent number 1, Oswald Greentech. Respondent number 1 claimed eligibility to maintain the petition on the ground of being a holder of 0.03% shareholding and claiming entitlement and legitimate expectation to 9.97% of shareholding of Oswald Agro Mills Limited by virtue of being the son of Abhay Kumar Oswald. So, my lord, when my partition suit is pending on the basis of inheritance, I am claiming shareholding in the company, then filing a company petition. Para 6. An application was filed in the NCLT by the appellant challenging maintainability of the petition on the following grounds. Now, they are saying that I do not hold these shares. That one of the ground is respondent number 1 holds 42,900 shares to the extent of 0.03% share of the total paid off capital, which were acquired in June 2017. The claim made by Pankaj Oswal to 9.97% out of 39.88% held by Abhay could not be made basis to maintain a petition under 241, 242. So this is the shareholding dispute on the basis of which they filed a maintainability application. Kindly see below 6.6. Main dispute raised as to the inheritance of the estate of deceased is a civil dispute, could not be said to be an act of oppression and mismanagement. Such a dispute could not be adjudicated in a company petition filed during civil suit's pendency. Company petition deserves to be dismissed. This was the point, my lord. Then, my lord, kindly come to para 8. NCLT by order dated such and such dismissed the application including CNM challenging the company petition's maintainability. NCLT held respondent number 1 as legal heir was entitled to 1/4 share of the property. Aggrieved thereby, 3 appeals were filed which have been dismissed such and such. Now, my lord, the Supreme Court kindly come to paragraph 24. At page
94.
Yes. 94. Sangram Singh Gaikwad case has been referred to. In Sangram Singh Gaikwad, it was held that the dispute as to inheritance of shares is eminently a civil dispute. Cannot be said to be a dispute as regards oppression and or mismanagement so as to attract company court's jurisdiction under 397, 398. Adjudication of question of ownership of shares is not contemplated under section 397. Now, my lord, that paragraph has been quoted, 143 and 144, then para 25. In view of the aforesaid decision in Sangram Singh Gaikwad case, we are of the opinion that the basis of the petition is the claim by inheritance of 1/4 shareholding so as to constitute 10% of the holding, which rights cannot be decided in proceeding under 241, 242. Thus, filing of the petition under 241, 242 seeking waiver is a misconceived exercise. Firstly, respondent number 1 had to firmly establish his right of inheritance before a civil court to the extent of the shares he is claiming. More so in view of the nomination made as per provisions contained in section 71. This is what I have done. I have come before the court to establish my right that I own 1/3 shareholding in all these companies. Then I will go to the company's court and say that this wrong recording of shares, this has to be altered in my favor. Kindly see, my lord, paragraph 29 also. It is my lord, the 28 also. In the instant case, considering on the anvil of the aforesaid decision, we are satisfied that respondent number 1, as pleaded by him, had nothing to do with the affairs of the company. He is not a registered owner. Rights in estate / shares, if any, of respondent number 1 are protected in the civil suit. Thus, we are satisfied that the respondent number 1 does not represent body of shareholders holding requisite percentage of shares in the company to maintain such a petition. It is also not disputed that High Court in the pending civil suit passed an order maintaining status quo concerning shareholding and other properties. Because of the status quo order, shares have to be held in the name of Mrs. Aruna Oswal until the suit is finally decided. It would not be appropriate, given the order passed by the civil court, to treat the shareholding in the name of respondent number 1 by NCLT before
ownership rights
are finally decided in the civil suit, and propriety also demands it. The question of right, title, and interest is essentially adjudication of civil rights between the parties. As to the effect of nomination decision in a civil suit is to govern the parties' rights. It would not be appropriate to entertain parallel proceedings with waiver as claimed under 244 before civil suit's decision. Respondent number 1 had himself chosen to avail remedy of civil suit. As such, filing of an application 241 is nothing but an afterthought. So if I go to the company court, this contention will be raised that how can you come? So, my lord, this is first answering my learned friend's submission of
regarding company
part of 430 of the Companies Act. My lord, kindly, he has referred in this connection one judgment. Lordship will kindly take that judgment which he has referred.
Which one?
On this issue, 2019, volume 18 SCC 569. Very short judgment on it. Short
judgment rely
Did he rely right now?
No. He has given only 3 judgments.
Then let me check with your lordship.
2011 volume 9.
Just one second. 2011
volume 9 SCC 126.
Yes.
And 2004 volume 3 SCC
Yes.
376.
Yes.
And 2020 volume 7 SCC 366.
Very good.
These
So
are
then
the
I am
three.
not placing. I am not.
These are the 3 there.
Very well. If they can show, then I will.
If you rely another from book, I don't know.
বই থেকে রিলাই করেছে কপি দাওনি but the citation must be noted somewhere
because these are the 3 noted here. Let me see.
Very well. Now next
2011
actually relied upon it, but I had actually handed over the to your lordship.
Those Xerox down.
2000 what is the citation?
1918 SCC 569.
Yes, I have noted it.
Yes, so I'll just
section 430.
Yes,
paragraph
430.
6 paragraph 6.
That is why I am citing the distinguishing this now just after my judgment on this one. Kindly see, it's a very short judgment, but main issue is not. Kindly see paragraph 3. The learned counsel for the appellants says that the issue raised by the appellants for the transfer of the shares, whether done rightly or wrongly,
has to be adjudicated by.
So what is the issue? Whether the transfer was done rightly or wrongly, not a question of title to the shares. That is what I am also submitting. If there is no dispute as to title, only issue is whether the transfer was done rightly or wrongly, then it has to go to the company forum created by 430.
Yes.
That is what this judgment says.
Thank you.
Next, my lord, kindly see on limitation. Limitation, my lord, my learned friend had cited.
Limitation, they have cited.
But on limitation, my lord, I am citing 2 judgments, my lord, which are very usual judgments, nothing very new, but for the sake of records, it should be there, my lord. 2117 SCC 100.
2021 volume 17 SCC
100. No, copy nahi. Kindly come to paragraph 4.
Yes.
And kindly come paragraph 8. Paragraph 4 is just giving the plaint case. Paragraph 8, insofar as the rejection of the plaint
Yes.
On the ground of limitation is concerned, it is needless to emphasize that limitation is a mixed question of fact and law. It is the case of the appellant plaintiffs that only after making inspection of records in connection with the suit land available in the office of defendant number 3 court receiver that they came across the correspondence and documents relating to transactions and the proceedings before ALT were collusive, fraudulent, and null and void. The appellant plaintiffs have even questioned the authority of the court receiver to represent them in the tenancy proceedings. The averments may or may not be true, but if the plaintiffs succeed in establishing the averments, the issue of limitation cannot be put against the plaintiffs. Generally, a party who never had any notice of a particular proceeding before a quasi-judicial authority is entitled to approach the court upon gaining knowledge of the proceeding. Limitation cannot be put against such a party. We are not dealing here with a case where notices were ordered to be issued but were not or could not be served on necessary and proper parties. We are dealing with a case where the plaintiffs assert in no uncertain terms that notices were never ordered to them nor served on them. Therefore, the answer to the issue regarding limitation will depend on the evidence with regard to issuance and service of notice and knowledge of the plaintiffs. Hence, the trial court as well as the high court were not right in rejecting the plaint on the ground of, especially in the facts of this case. So, my lord, here also it's the same thing. The evidence will have to be gone into to show how the parties treated the properties.
Yes.
If there is a jointness in the property, because you cannot produce any deed by which partition has taken place. Immovable property cannot be partitioned orally or by an email or by exchange of correspondence. So therefore, it is this issues will have to be gone into. Your Lordship just can note the few paragraphs. I am not going to place in detail. Paragraph 14, where it has been said that defendant in a suit cannot pick up a few sentences here and there from the plaint and contend that the plaintiffs had constructive notice of the proceeding and therefore limitations started running from the date of constructive notice. In fact, plea of construct is raised by the respondents. Then, my lord, so this is one judgment on limitation that it has to be read as a whole. Then, my lord, 2015 8 SCC 331. This is, my lord, paragraph 1. Paragraph 9 and 11.
What proposes?
Well, that, my lord, on the plea of limitation, that kindly see paragraph 9. Plaint case has to be gone into. Both the suits were filed in July 2002, which is well within 3 years of date of knowledge as claimed by the plaintiffs of the fact that the property had not been transferred in the name of plaintiff number 2 by defendant number 1 and 2. Aforesaid averments made in the plaint will have to be accepted as correct for the purpose of consideration of application on Order 7 Rule 11. If that be so, averments in the plaint would not disclose that either of the suit is barred by limitation so as to justify rejection of the plaint under Order 7 Rule 11. So, my lord, my plaint case has to be accepted. That the settlement was never accepted by me. It is not binding on me. Then, my lord, এটা দেখিয়েছেন? Now, my lord, if your lordship comes to their judgment on limitation, 2004 3 SCC page 376.
Yes.
Just 1 second, my lord. This is, my lord, kindly see, this is nothing to do with, my lord, first of all, it is not under Order 7 Rule 11. And issue of limitation was decided only after taking evidence at the stage of trial. And it is based on the case of adverse possession. Plea of adverse possession was set up, and that is why explanation to Article 65 of the Limitation Act was concerned, my lord. If your lordship kindly sees, kindly come to paragraph 5. And 6. This is what he has relied upon. Paragraph 5 says, we do not find merit in the above argument advanced on behalf of the appellant. In the case of such and such, it has been held that the right of the reversioner to recover possession of the property within 12 years from the death of the widow is not only based on Limitation Act, but on the principles of Hindu law. This does not apply in my case. Then, my lord, paragraph 6. At this stage, it is important to bear in mind that partition is really a process by which joint property enjoyment is transformed into an enjoyment severally. In the case of partition, each co-sharer has an antecedent title, therefore there is no conferment of a new title. In the circumstances, the appellant cannot be heard to say that they became owners of the property only when the partition deed was executed on such and such. Lastly, the facts above mentioned show that the appellants had asserted not only their own possession, they had also asserted the possession of Prahladji and prior to his death. So, this therefore, like last 3 lines, in the present case, starting point of limitation for adverse possession cannot be taken as 29th November 1965, and one has to take the date when the respondent's possession became adverse. Well, you cannot apply the case of adverse possession which was being set up here. Here, my lord, we are only on the question whether your lordship will take into consideration 2012 date or not.
Yes.
Nothing more, nothing less. Then, my lord, the other one was also not in the context of Order 7, Rule 11, that is 2011, Volume 9, SCC 126.
Yes.
Here, my lord, my learned friend placed this judgment particularly for that expression in Article 58 of the Limitation Act, right to sue first accrue. Kindly come to para 30. While enacting Article 58 of the 63 Act, legislature has resignedly made a departure from the language of Article 120 of the 1908 Act. The word first has been used between the words sue and accrued. Next line. This would mean that if a suit is based on multiple causes of action, my suit is not based on multiple causes of action. If it is based on multiple causes of action, the period of limitation will begin to run from the date when the right to sue first accrues. My suit is simply based when you have refused to give me the account.
Yes.
After my legal notice.
Yes.
2012, I have not based my case on 2012.
Yes.
And 2012 does not alter the status because it's just a simple document. A document cannot result in severance of a joint family status.
Yes.
So, my lord, this is 2011, Volume 9, SCC 126. Then, my lord, I think he has shown 2027 SCC 366. তাই তো বলছি আর নেই আর কেউ মুভ করে না my lord, kindly see this judgment, my lord. This is clearly distinguishable on fact, my lord. Your lordship will find here the suit was filed on 15th of July for cancellation of a sale deed of 2nd July 2009. Kindly see paragraph 7. এটা হচ্ছে 2027 SCC. Kindly see on 15 December 2014, plaintiffs filed civil suit 2027 SCC. তোমার judgment. Plaintiffs filed special civil suit number 718 of 2014, such and such. Third line. It was inter alia prayed that the sale deed dated 2nd July 2009 be cancelled and declared as being illegal. 2009 deed is being filed in 2014. Next, kindly comes to para 15. Trial court noted there was no averment in the plaint that checks had not been received by them. Once the checks were received by them in the normal course, they would have presented the checks for encashment within 6 months. The court held that the plaintiffs had not been able to encash 30 checks. A complaint ought to have been filed or proceedings initiated for recovery. There was, however, nothing on record to show plaintiffs had made any complaint in this regard for a period of over 5 years. Plaintiffs have also failed to produce the return checks, their passbook, bank statements, or any other document to support their averments. Notice for transfer of the suit property was served on the plaintiffs, to which no objection was raised. So, my lord, they are trying to say that you had knowledge of the deed in 2009. You are challenging it in 2014. Therefore, it is ex facie barred.
Yes.
So on this principle, my learned friends have relied upon paragraph 23.5, 23.6. These are general observations with regard to Order 7, Rule 11. Then, my lord, now, my lord, lastly, my lord, my submission is, I had shown your lordship that 430 bar will not apply in this case. It is a title dispute. Worst situation, I am submitting a judgment, my lord. Even if your lordship sees the prayer, ultimately in the partition suit, my lord, kindly see the prayer. Only prayer B is what my learned friend is contending that could have come within 430. My submission to your lordship is it cannot come within 430 because without prayer A, C and other prayers, title being decided, B cannot come in. B is only a consequential relief to prayer A. Until and unless this is declared, joint ownership is declared, the question of getting prayer B will not arise for changing the shareholding pattern. So this is only consequential to prayer A, and a consequential relief will not be barred because 430 as it is, 430 principle is not applying. Here my submission, alternative submission is partial rejection of plaint is not permissible. But for that, your lordship just keep one judgment, 2019 7 SCC 158. Paragraph 10, your lordship can note it, my lord. But I have prepared a very short note dealing with my learned friend's judgment also. I'll just hand it over to your lordship.
Paragraph 10, this one?
Yes, paragraph 10.
Yes.
Kindly see, we do not deem it necessary. We are inclined to accept the objection of the appellant that the relief of rejection of plaint in excess of Order 7 Rule 11D cannot be pursued only in respect of one of the. In other words, plaint has to be rejected as a whole or not at all. In exercise of power under Order 7 Rule 11D, indeed, the learned single judge rejected this objection by relying on the decision of division bench of the same court. We find that decision of this court in Sejal Glass is directly on the point. In that case, an application was filed by defendant Order 7 Rule 11 stating plaint disclosed no cause of action. Civil court held the plaint is to be bifurcated as it did not disclose any cause of action against the director's defendants. On that basis, High Court had opined that the suit can continue against defendant number 1 company. Question considered by this court was whether such a course is open to the civil court in exercise of powers under Order 7 Rule 11D. Court answered the said question negative by adverting to several decisions which had considered plaint can either be rejected as a whole or not at all. The court held that it is not permissible to reject plaint qua any particular portion of a plaint, including against some of the defendants, continue the same against the others. In no uncertain term, the court has held that if the plaint survives against certain defendants and or properties, Order 7 Rule 11D, CPC will have no application at all. The suit as a whole must then proceed to trial. But these are my submissions.
Thank you.
But I would be praying my lordship will give a short date immediately after the vacation so that my learned friend can get. Then my application for injunction is pending for a long time. Because the properties are all going. This, my lord, we have indicated. This is all dissipated. Practically, he will get nothing. But let us see, my lord. Court's powers are wide enough to bring back properties which have gone, my lord.
Yes.
I'll take your lordship.
Counsel for the plaintiff has concluded his argument. Counsel for the defendant prays for time. Case is adjourned. Let the matter appear on. Date है? नवंबर में है 11:30. कब है? 3rd November.
3rd November.
3rd
Look,
November.
this is what
11th.
happened. This suit is nothing but a brother's greed. Partition happened 2012. He's got everything. Now he wants even more.
3 brothers greed.
2 brothers on the same court and one.
Unfortunately, the suit is by one.
11:30.
3rd November. That was okay.
3rd number 11:30.
Great, great. Oh.
Yes, next.
Number 9, the commercial.
Lordship, I appear for the respondent.
Lordship, I'm appealing for the plaintiff. I'm praying for a short passover, Lordship. This matter.
Lordship kindly keeps it after the vacation. The appeal is pending. Lordship.
Lordship, my counsel, I'm led by Mr. Jishnu Shah, Senior Counsel, and Mr. Ratnanko Banerjee. They'll be appearing virtually. I'm praying for a short passover, Lordship.
Raman. Yes.
I am praying, Lordship. Lordship may kindly consider keeping it after the vacation. In any case, Lordship, I am being led by Mr. Krishnaraj Thakkar. I have an order, Lordship, of the division bench of Honorable Justices Shobhoshachi Bhattacharya and Justice Uday Kumar. They have fixed a matter today specifically for Mr. Thakkar to address, and he is on legs before that division bench because it's a Supreme Court remanded matter, and they have been directed to dispose of it expeditiously.
Which one? This matter?
No, not this matter. Some other matter. So Mr. Thakkar is before that division bench on legs today. So today he will not. I have been instructed to seek a not today on his behalf.
Yes.
Yes, place the order.
So you are appearing for whom?
Lordship.
You are appearing for
I
whom?
for respondent numbers 1 and 2, Lordship.
1 and 2. Yes.
Lordship, my counsel is on the way. Just give me a Lordship. I'm praying for a short passover, Lordship.
Or they are telling the appeal is pending. They are telling the appeal is pending. What has happened to appeal? Today is fixed.
Appeal is running in the list, Lordship. It is item number 2 in the division bench of presided by Honorable Justice Arijit Banerjee.
Yeah. Just show the directions at the end.
Why it is mentioned?
He's coming. Just placing the order.
Yes, what is the submission?
Lordship.
And next installment because the other side not ready to comply with the order from the CFO.
I'm so sorry, my lord. This is my application, my lord. Kindly gives me 1 second, my lord. Lordship, if they are submitting in that case, kindly keep it not today only, Lordship. Kindly.
Why? It is the appeal is pending.
My lord, it's nothing to do with the appeal court.
What application you are moving now?
My lord, I was paying them. I have been paying them the installment. My lord, July was paid. Now, my lord, October installment I started paying.
October?
Yes. Which is falling due on 5th. Now, my lord, 12 crores 75 lakhs is to be paid for principal. And my lord, the interest on that, as it will stand on 5th, my lord, that I have to pay. My lord, I have paid 10 crores and odd. My lord, now what they say is,
and the payment was tendered with a notice under section 59, my lord, as was done in the previous occasion. Now, my lord, now what they do, kindly takes the, my lord, application.
What, new file a new application?
Yes, my lord.
What application?
Yes, my lord. J2, my lord. I'm so sorry, my lord, I did not indicate, my lord.
What application you filed?
Yes, my lord. Kindly
Let
takes
the
page
injunction be-
226.
Huh?
My lord, kindly comes to page 226, my lord. Volume 2, my lord.
Hmm.
My lord, after we start making payment for the month of October, my lord, what do they write back? May I place this, my lord? The date is very important, my lord. 22nd August. And my lord's order is of 19th August. And my lord, we are without affidavits till date. And no extension has been sought. My lord, what do they write? Dear Pratik, we are in receipt of a sum of rupees 1 crore 9 lakhs and odd on 19th August 2025 from Money Realty, purportedly paid towards the installment falling due on 5th October 2025 under the terms of the loan agreement dated so and so, executed by and between Money and Piramal and other obligers. In this regard, kindly note that we unequivocally deny any and all assertions of the aforesaid sum having been paid towards 5th October 2025 installment under the loan agreement or any other installment whatsoever. You are well aware that the loan has been recalled by our trustees pursuant to written instructions received by them from us, and as such the entire outstanding loan amount has fallen due under the terms of the loan agreement. In such circumstances, there arises no question of aforesaid payment being made adjusted against the 5th October installment or any other installment whatsoever. Accordingly, the said sum of rupees 1 crore odd is adjusted against the total outstanding loan amount, and as on date, a sum of 63 crores remains due and payable by you to PFL under the terms of the loan agreement.
19th August order stays the record.
My lord, the 19th August order, my lord, firstly stays the loan recall notice. So, my lord, there is no loan recall. The entire amount is not due and payable. Secondly, my lord, 59, section 59, my lord, is extensively considered, my lord, which clearly says that if I tender payment for a particular payment, either you don't accept or you appropriate towards that. My lord, they have refused to return it to me. They have refused to appropriate in terms of section 59. They say, no, I have received, I will keep it and I will use it for the sum that I decide to be, my lord, applied for. Now, my lord, 5th October, I had to pay 12.75 crores.
No, what you want?
My lord, kindly see, my lord, for the ad interim, my lord, all I am saying is, my lord, I am willing to pay the balance money. But, my lord, I want to put it in court.
You're,
My lord, with
you're
the registrar.
paying it, they're not accepting. You file an application, let it be decided.
My lord, in the meantime, my lord, I will be again a defaulter.
Why
My lord, 5th
defaulting?
October.
You have made an application, they are not accepted. You have requested to accept. They
Yes,
are not accepted. Now you file an application.
My lord, there is an escrow account. There is an escrow account, my lord, wherein the money is lying. Now, my lord, I want to, my lord, put that money in court, my lord.
No,
Or, my lord,
in the application, by way of this, court cannot go for the execution of the order, sir.
no, my lord, then kindly allow me, my lord, to only say this, my lord, that, my lord, these payments that I make, let them accept, my lord, without appropriating in any other manner.
See, as per the order, this court has
Yes,
stayed the
my lord.
further of the
My lord.
determination notice. Correct. That is to be decided in affidavit. Now they have preferred an appeal. That is.
My lord, that's
is up
neither
to
here
the
nor there,
applicant.
my lord.
Now, as per the order, as per the agreement, you have making the payment.
Yes, my lord.
But now they are not accepting the payment.
Yes, my lord.
Correct.
My lord, they are retaining the payment, but appropriating it differently.
Correct. Whatever it may be,
My lord.
appropriately or whatever it may be, you have made the payment.
Yes,
in terms of the agreement, month by month or week by week
Yes,
or
lord.
day by day, whatever it may be.
My lord.
You are doing your duty.
My lord.
What they are doing, that is their own business. Correct. And you file the application before this
My
court.
lord.
It is pending. So that will not go against you.
My lord, kindly, my lord, observe that much, my lord, will pay.
If you want to file affidavit, let them come.
My lord, in the meantime, my lord, whatever payment we make, my lord, has to be subject to outcome of this application. My lord, kindly.
How? In this type of the application, how the court can allow this?
My lord,
Yes.
my lord,
With your lordship leave, may I only make one
for plaintiff number
suggestion?
2.
If your lordship will kindly take the 19th August order once, if I may request your lordship, my lord, it is annexed to our application itself, my lord. It is at page. My lord, it is at page 197 of the application. If your lordship will kindly take that once. From page 219, paragraph 41.
219.
Yes, my lord, of the application. That is part of your lordship's 19th August order. If I may just place, upon reading the said clause, it is clear that if the petitioners fail to pay the outstanding amount on its due date, the petitioner is liable to pay penal interest along with actual interest of the outstanding due amount. In the said clause, there is no such provision that if the outstanding amount is not paid as on its due date, loan will be recalled. Then my lord has the operative portion of lordship's order is at paragraph 45, which is at page 221. All I want to indicate, my lord, is there is a provision for penal interest. The interest that they are charging is dehoards the contract and exorbitant. There's something called a, my lord, pyramidal prime lending rate, which is completely arbitrary. They do not disclose the basis of this prime lending rate, which is a mystery to everybody but themselves. Now, my lord, I am paying into an escrow mechanism. I have to give them the instruction, then they will appropriate it as per my direction under section 59 of the contract towards the upcoming installment only. Next installment is due on the 5th of October. 12 crore odd, I have already paid 10 crore odd, my lord. Only 2.5 crores is remaining to be paid for the upcoming installment due on 5th of October. Now, my lord, what is happening is I have deposited the money in escrow because of the dispute on how it is to be appropriated, despite your lordship's order, staying the, my lord, the recall of the loan, which means that they only can appropriate as per the upcoming installment and not otherwise. My lord, since they are not accepting it, despite me tendering it into escrow, they will start charging the penal interest on it. This is the detriment that I will suffer. That is why, my lord, I am beseeching your lordship to kindly allow me to deposit it in court.
They may ask for the penal interest, then you can reply it, and that will be decided in the application.
What they also do not very
court
craftily
at this
disclose with
stage-
your lordships.
Because that has been filed under the interim order.
But my lord,
That
they are
is not
acting contrary
not
to
after
lordship's
the
subsisting
affidavit.
order, which has not been stayed.
Not
There is
state.
no
That's why not state. Okay, you are paying, they are not accepting, or they are misappropriating. But by this order, how the court can say at this stage unless the opportunity is given to them?
Lord, it's dereliction of lordship's order. Lordship says loan recall is state. They are still saying the entire amount is due.
This is not with regard to contempt or execution. This is you want another prayer for the interim order. How it can be?
My lord,
Time and again.
I am only asking that they, my lord, appropriate as per the agreement, or my lord, allow me to deposit in court so that they cannot charge penal interest against me.
So you are not filed the contempt. You are not filed the contempt because in spite of this, they are
I shall
charging.
do that, my lord.
So how this is this is again you are asking for the interim order.
My lord, if I am allowed to deposit to the court, my lord, nobody will be prejudiced in any way, and my lord, my interest will be protected. They will not be able to levy any penal interest on.
No.
Otherwise, my lord, to challenge that, I will have to make a separate application again. The subject matter of the suit already, my lord, alleges that they are levying and recovering excess.
Sir, you are paying your request, the mail which you have sent to the defendant. It is shown that your intention that you are paying, but they are not accepting. So where is the question of penal interest if the court helps in future?
Kindly make one observation, my lord, that the payment will be appropriated as per the outcome of this application. Only that, my lord, will
No such
serve my
objection is required, lordship. It will be ultimately subject to the outcome of the appeal and whatever happens before this.
But even if this submission is recorded, my lord, I think will be, my lord, greatly, my
Nothing is
lord.
to be recorded.
Of course,
My lord,
And
they
this
will try to steal a march. That
this
is what I am, my
PPLR
lord,
issue,
apprehensive
lordship,
of.
they do not even disclose. They have already, before filing the suit, complained to the RBI about this. The RBI is sitting on it. Blatant forum shopping they are engaging in. All these
Records
issues
this
are
also.
open.
Are we sitting on it? Let it be recorded.
All these issues are open.
What have I done before the RBI? I have, my lord, challenged the rate of interest they are asking for. That's for the ombudsman. Completely different thing.
No, but that's disclosed in the plaint.
It's disclosed in the plaint.
The RBI complaint is disclosed in my plaint. Now, where is the question of suppression? But all I'm saying is, my lord, despite, my lord, having an order, my lord, they are still, my lord, representing, my lord, to everybody, my lord, that 65 crores is due. But that's the only, my lord, trouble, my lord, at this stage.
It is due, but your intention you have shown by your letter dated 22nd August.
Yes, my lord.
And you come to 226, you have shown your interest.
Yes, my lord.
But they have denied that.
Yes,
Okay, they cannot take that you are not paid. Can they say they are not paid? Cannot say.
My lord.
So
But Kyle, because, my lord, what, my lord, my
why
lord
the court is and court will enter into the dispute between the parties at this stage, because the court has already passed an interim order. If they are not accepting, then you take appropriate. So how the court can say no, you accept it? It is under challenge in the appellate court. How the court can at this stage enter into the directing to accept the amount?
No, my lord, I was beseeching, my lord, if, my lord, we can put in the money with the registrar of this honorable.
Why? Why the court should be a party between you?
No, my lord, just to, my lord, protect, my lord, the interest of the parties, my lord. Again,
You have shown the interest.
my lord.
So the The defendant has filed the present application, praying for a direction upon the respondent number 1 to appropriate the payments of sum of rupees 10.54 crore made by the petitioner on 29 July 2025, 19th August 2025, and September 11, 2025. Defendant has prayed for. No, plaintiff has prayed. Directing the respondent number 1 to appropriate the payment so and so under the cover 11/22. Counsel for the plaintiff has relied upon. I draw the attention of this court to the email dated 22nd August 2025, wherein who has sent this note? Who has sent this email?
My email is at 225, my lord. 224 and 225. The reply is what I was showing your lordship at 226 and 227. But my letters are 224 and 225. How much it is?
Email dated 22nd August 2025, sent by the defendant to the plaintiff. 1 and 2 to the plaintiff, wherein it is mentioned that wherein the defendants are denying all the assertion of the amount which the plaintiff intend to pay towards the 5th October 2025 installment under the loan agreement or any other installment whatsoever. The plaintiff prays for a direction upon the defendant to accept the said amount or a direction upon the plaintiff to deposit the said amount before the court, before the registrar of this court, registrar of the original side of this court. Learned counsel for the plaintiff and defendant number 1 and 2 raise objection and submit that the order passed by this court is under appeal and is pending for hearing. Considering the above, this court find that the plaintiff has making endeavor for making the payment to the defendant number 1 and 2 in terms of the agreement, but the defendant number 1 and 2 are not accepting the said amount. Full stop. Considering the above, this court find that the plaintiff considering the above, this court find that this court has already passed an interim order staying the operation of the termination of the agreement.
Loan recall.
Termination of the loan recall of the defendant number 1, and the same is pending before the appellate court. And at this stage, if any further order will be passed, it will be multiplicity of the proceeding in future. Accordingly, the defendant is directed to file affidavit in opposition within 2 weeks after puja vacation. Reply, if any, there to be filed within a week thereafter. This is the matter on 25th of November 2025.
This is GA2, my lord. GA1, my lord, is already, my lord.
Okay. Next. क्या है? None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of December 2025. Next.
Number 11. Well, item number 11, I appear on behalf of the plaintiff petitioner. I have taken out an application under summary judgment, but my lord, on the last occasion, on the 2 occasions, my lord, the defendants are not appearing, and my lord has asked for a report from the sheriff. My lord, this is the deputy sheriff's report. It says door is locked. My lord, this is the second occasion that this is happening. But firstly, the suit was tried to be served. They were not appearing. They were keeping their doors locked. My lord, as on the last occasion, I had paid for paper publication, but now, my lord, I make a submission before your lordship that, my lord, it is deemed good service. But every time, if they're keeping their doors locked, my lord, and this is, my lord, the affidavit of service of the.
Yes, door lock. They were not in the how you
My lord,
can
two
say?
times, my lord, the summons was served.
Maybe. It's out. There is email. There is no. It is a company.
Yes, my lord.
So there is no email. There's no email.
My lord,
Email of the company.
but I have to find out that
Then
they keep changing, my lord, because I only had one email of the company, which was the representative of this defendant. But we were sharing all the emails with her. And now she has stopped replying, and also that email is, my lord.
Yes, there are so many emails. Why you not send the emails?
My lord, then should I send the plaint along with the copy of the application, my lord, to the defendant's email, and on the next date come back with the delivery?
Yes.
And then, my lord, will hear out my summary application.
The counsel for the plaintiff has handed over the service report, wherein it reveals that twice the writ of summons was issued, but the same could not be served upon the defendant and written with the endorsement door locked. Counsel for the plaintiff prays for allowing the plaintiff to serve the writ of summons through the email address of the defendant. Accordingly, where is the writ of summons filed? No.
Yes,
according the plaintiff is directed to take his appropriate step for service of notice upon the service of writ of summons upon the defendant.
That has already been noted with the,
to the email address of the defendant within a week from date, and to file affidavit of service on the next date fixed. List the matter on 12th of November 2020.
I'm great. My lord, 1 week after the vacation, my lord, because, my lord, it is already
yes, 12. Okay, oh, not 12.
My lord, that time to
after the puja vacation. List the matter on 12. No, not 12 karo, 18 kar do.
I'm grateful.
Yes.
That matter, defendant number 6.
This matter is concerned, insofar as defendant number 6 and 7 is concerned, your lordship has already vacated your lordship's order of injunction. But the order of injunction is subsisting as against the other defendants. I am representing 11 and 12, your lordship. So Mr. Thakkar was supposed to conclude his arguments insofar as 11, 12 and other defendants are concerned who have filed their written statements.
Yes, yes.
So, my lord, may I? Or we can trouble your lordship that side of the vacations also whenever.
10 minutes only there.
Yes, I understand.
Come after vacation.
The only thing, the interim order is till today. So if that, our job is now much more difficult. Now we have to satisfy your lordship out of that order also for the other defendants. So
your lordship might not be inclined to extend the interim order in that.
That would be our endeavor.
But I understand.
Please say mine.
Yeah, we are 6 and 7.
Is
Pending order would kindly specify that it is not for 6 and 7.
Reimpose.
Reimpose, yes.
In
Puja is there.
Puja
Can I reimpose? Because you are
now the horse is gone. The cart needs to be pushed.
Interim order kindly specify it is not for 6 and 7. So he
reimpose.
Reimpose.
It deserves the reimpose.
Now, your lordship, the horse is gone. 6 and 7. Now only the cart remains, your lordship.
No,
My lord, so far
main horse is here. Where is 10? One. Where is 1?
My lord, 1, 2, 3, and 5.
Yes.
My lord, by order dated 31st of July 2025, my lord has directed, in view of the above, the department is directed to place the written statement if submitted. So my lord will kindly see that has come
आया क्या? Written statement आया क्या?
in GA 10, my lord.
GA10 return statement.
Yes, I filed my
Oh, extension of time to return.
extension of master summons and affidavit in support. Yes, excellent.
Different application.
We can get these applications done away and then come back.
Nah,
There would
that
be
if
two
it does come,
principal
it is-
applications remaining. And one
recorded now. The counsel for the plaintiff press for time to give reply to the submissions made by the counsel for the defendants, except defendant number 6 and 7. Full list. In view of the submission made by the counsel for the plaintiff also prayed for extension of the interim order. In view of the submission made by the counsel for the plaintiff, case is adjourned. कोई डेट है क्या? देखो नवंबर में 17th November at 11:30 p.m. Noon, 11:30 a.m. Interim order is extended till 17th November or until further order, whichever is earlier.
Deeply obliged, Your Lordship. Deeply obliged.
That's why I'm thinking we are not submitted anything.
everyone.
Number 8, 9, 13, 14. Regarding record,
Extended, na interim order is extended, except the 7 and 8.
You can have 6 and 7.
6 and
6 and
9, 13, and 14. There is a record vacating application on which affidavit received. May that also be heard?
That is the same. I am hearing all.
Obliged.
It's until 17, except defendant number 7 and 8.
6 and 7.
6 and 7. Sorry.
6 and 7.
6 and 7.
But he wants a reimposition.
Yes.
My lord,
Item number 13.
I will consider on
Lordship. Get for.
Item
Item
number
number?
13. Item number 13, my lord. This is my substitution application where, my lord, in another matter, your lordship has already reserved it for
Let
orders.
it complete, then
No, my lord, kindly do not. Kindly do not.
let
my lord.
that judgment come, then you can complete here.
My lord, I have
As,
already, my lord,
as it's been done by Mr. Bose in the earlier matter.
my lord, what had happened is really, my lord, we are the ones who have asked for substitution a year and a half back. And
I don't understand. They can proceed with the surviving partner. Why are they insisting? If they do not insist on impleading the heirs, they can proceed with the suit.
my lord, what has
Now, if the moment they insist, I have to object. I have no other choice.
But that objection was not there in the affidavit file. But nonetheless, the prayer made in the suit specifically says, apart from the fact that there are averments galore, specifically says that it is the defendant and each of them. So, the private estate of the heirs, Section 45 of the Contract Act will be applicable, and Order 30 rule for exception. Order 30 rule for exception has to be.
But unfortunately, Supreme Court says otherwise.
Supreme Court, none of the
I have my
prayers were sought for against the legal heirs or against one
I have
individual
all my
partner.
sympathies for my learned friend, but Supreme Court in 2 judgments are saying otherwise, and the judgment that they have relied upon, I will distinguish each of those judgments. Now, kindly keep it any day after the vacation.
Let the matter appear on 13th November. 13th November?
Any day,
any 13th. Great.
Yes, next.
14. My lord, item 14. My lordship allows me to join virtually, my lord.
Yes.
I appear for the defendants. We had concluded submissions in IA2.
But Mr. Shuddha Banerjee has concluded. I was to commence the reply. But 5 minutes remaining, my lord. It would take some time, my lord.
Let the matter appear on 11th November 2025.
My lord, one request, lordship, since lordship has heard this substantially, my lord, if lordship is pleased to mark this as part heard, my lord. This is a request because we had concluded submissions.
Come.
My learned friend does not oppose.
Come on 11.
All of us are fearing that the determination might.
Come on 11.
This is a request, my lord. My lord, kindly.
No. I am not keeping any part here. Yes.
But 15th also same, my lord.
15 also same?
Yes, my lord.
Same. 14, 15 same.
Wait.
11 November.
Wait,
Huh?
my lord.
So grateful.
Number 16, Millard, I am for the plaintiff, Millard. There are two application, Millard. One order 7 rule 11 application being GA2, Millard, and one application for judgment upon admission, Millard, GA1, Millard. Millard, in this application, Millard.
I'm for defendant number 2. I'm being led by Mr. Shashwat Naik. He's not in court.
Who?
Mr. Shashwat Naik. Lordship, can it be taken after the vacation, Lordship? Pleadings have been completed in
As per
both
the
the
prayer
GA.
made by the counsel for the defendant number 2.
Defendant number 2, Lordship.
Case is adjourned. Let the matter appear on 18th November.
Grateful, Lordship.
Next.
My lord, in item number 17, I appear for the defendant number 1. So we had filed a section 8 application for saying that the dispute is covered by the arbitration clause. Mr. Ratnanko Banerjee had made his submissions, and which was followed by the plaintiff making their submissions in response. So we are left with the rejoinder. Mr. Banerjee is not there today, your lordship.
The prayer made by the counsel
Could
for
it
the
be put
defendant.
after the vacations, because my advocate on record
Let
is
the matter
actually
appear on
in Delhi.
19th November.
My lord, 19th November. So grateful.
Next. Give the appearance. Give the appearance.
Number 18.
Sorry, my lord, one indulgence. The Banerjee just checked his diary. It's not available on the 19th. So it could be put on any day after the 20th November, maybe 21st.
21 kar do. 21.
I'm so grateful, your lordship.
Yes, next. Combined monthly list of December 12, 2020.
My lord, I appear for the my lord respondent. This is my lord the order 11 rule my lord 1 sub rule my lord 4 sub rule 5 my lord application for disclosure of documents. Mr. Jishnu Chaudhary had concluded his arguments. There was one document which they are seeking to rely upon, but this was in their power, possession, control, custody, and there is only one paragraph in the application which according to me was not my lord reasonable cause. My lord, kindly.
Who is for the other side?
Mr. Jishnu Chaudhary is my lord for the applicant.
Acha, he has argued that he wanted to satisfy this court.
No, he tried to, my lord, but lordship was possibly not convinced with the arguments when he ended.
That's why he wanted further.
If he wants to continue, then I will not start, my lord, but he's not here today.
Come after vacation.
My lord fixes it any day after vacation, my lord, in that case.
None appears on behalf of the defendant. For the interest of justice, case is adjourned. Let the matter appear on 14th November.
Well, it should be plaintiff. None appears on behalf of the plaintiff.
None appears on behalf of plaintiff. 14th November.
Lord, item number 20, my lord, my application, my lord, I had completed my submissions, my lord, so far as my application is concerned for a demo application, my lord. My lord, Mr. Rohit Banerjee had appeared on the last occasion. Yes.
What is the point?
My lord, whether
what was the issue there?
My lord, the point was, my lord, that whether, my lord, it should fall under, my lord, a commercial dispute or not. To recap, put it down on my brief task.
Yes.
Yes, I am ready. Just
You're in commercial or in
my lord, we have filed this particular matter, which is a simpliciter matter for recovery of money lent in advance. My lord, the contention of the defendant is that this should be a non-commercial suit. Now, my lord, of course, this is not a ground for rejection. So this is the prayer which they have sought is rejection of the plaint. Certainly, it is not a ground for rejection.
Return.
It can be returned following the principles of order.
So you are agreeing with that? I will return.
No, I do not agree to that. My lord, the first paragraph of the plaint says that now, my lord, the defendant is a partnership firm consisting of two partners. The plaintiff did have a personal or was acquainted with the partners, but the loan has been given to the partnership firm.
Loan utilized in the firm, in the business.
Yes.
Amount received by you, utilized by the defendant in.
The loan has been given to the partnership business.
Correct.
And for what actual purpose they have been using it is a question perhaps triable. And at this stage, my lord, I would only restrict myself to the averments which have been made by me in the plaint, as which they have disclosed along with their application. So may I invite your lordship, my lord, directly at page 12.
Just a minute, मनोज उसको बोलो साहब आने से बताना, जज साहब आने से बताना, डिवीजन है ना, आ गया, सब आ गए, division bench is there. Learned counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 7th November.
Kindly keeps it as part heard, my lord. Kindly keeps it. But kindly keeps it.
No, I am not keeping it.
My lord, one prayer before Lordship rises. Item number 25 may it be after vacation. It is the Section 8 application which Lordship was
That
reading.
one.
That one, my lord.
So that I am keeping part word.
Part heard. Kindly keeps it part heard, my lord. I'll do it before your lordship. I don't mind that. Mr. Shaurojit Dasgupta is, my lord, there for the, my lord.
As per the prayer made by the counsel for the plaintiff, let the
My lord,
matter.
in item number 26 and 27 also may it be, my lord, taken after vacation, my lord. I am anyway going to lose this matter, my lord. I have taken the instruction, this, my lord, the petitioner is not in a position to, my lord, secure the money as suggested by your lordship. But, my lord, I would like to lose it after vacation, my lord, if it can be taken, because there is no 26 and 27, my lord. There is no, my lord, stay in the execution. They are proceeding with the execution, so their rights are not, my lord, at stake.
Yes, your learned friend is opposing. He wants that before puja only it has to be decided here.
Lord, his execution is going and that is fixed after vacation, my lord. And only tomorrow, my lord, I have some matter other.
Not a single.
Let it be after vacation, my lord.
After vacation.
His rights will not be prejudiced.
Vacation.
Immediately on reopening, my lord.
दोनों करते हैं. As per the prayer made by the parties, let the matter appear on 11th.
For mine be, my lord, 10th or 12th.
November is the execution case is fixed.
Okay, let the come execution case if there are matter. 6th. Oh, 6th.
6th is okay for me also, my lord. 6th is okay.
Obliged.
Deeply obliged.
My lord, in this matter, I have. Well, if your lordship recollect, my lord, your lordship was pleased to issue a rule. Rule is made returnable today. Well, I am sure the report has come, whether the rule has been served. And if it has been served, my lord, each of the contemners are required to be present in court, personally present in court.
My lord, I have, they are required to be present in court if they have been served on the individuals concerned. And secondly, they are required to be present in court tomorrow.
Tomorrow?
Yes, that is the date. But I have filed an application, my lord. My lord, it was made returnable 24th. Sorry. I'm sorry. Today itself. My lord, I have filed an application, my lord, for 3 applications. My lord, one.
With respect, my lord, applications can come as many as they want, but the rule compliance has to be there. That is the paramount consideration in a contempt proceeding. Rule has been issued. So
Well, they are not
if
there.
the report is there, if they are not there, warrant of arrest is a matter of course.
Yes, except, my lord,
if the High Court rule is not followed, if you have been served with the rule and your lordship is satisfied that the department has served the rule,
my lord, serve the rule on the person concerned. Will not.
So that is up to the satisfaction of the court. That's
Yes.
not my learned friend has no right of audience so far as the service of rule is concerned.
Let one advocate complete the submission, then I will hear.
So my respectful submission is that your lordship has issued a rule. Now, my lord, the report has come from the department
whether the rule has been appropriately served on all the respondents. Now, my lord, if your lordship is satisfied that the rule has been served, they are required to be personally present before the bench which has issued the rule. Now, lordship will kindly ascertain whether these contemners are present in court. Well, in the event the contemner not present in court, then your lordship is aware, my lord, what is the next course of action.
Okay.
A warrant of arrest has to be issued for the purpose of ensuring their physical presence in court. Now, these are my respectful submissions so far as rule is concerned. And my lord, also, my lord, in the event the rule has been served, they are required to answer to the rule by way of an affidavit. This is the procedure contemplated under the, my lord, contempt of court rules of the Calcutta High Court.
Okay. Yes, Mr. They are present or not?
My lord, the respondent number 9, although, my lord, he is stationed, he's in Rajasthan, my lord, which is name of respondent number name is Arpit. My lord, the affidavit which, can you please sit down, please? I mean, or you want to stand up and interrupt?
Have I interrupted?
No, please. It's very disturbing.
Why can't I stand?
Very well, you
stand.
stand.
Interruption.
Because my application, my lord, now, my lord, so far as the respondent number 9, you can see it's some Tiwari, Mr. Tiwari. My lord, he is presently the for LPG territory manager in Rajasthan. The person to who has replied to the contempt notice, Mr. Nishant Kumar, who replied to the contempt notice served by them, had affirmed this affidavit. Unfortunately, my advocate on record was not present to point out the same. But whatever it is, your lordship has issued a rule, my lord, against finance director, some people who have retired, some people who are not existent. I can assure you, none of them have been served personally as such. It's just a service, and it has been dispatch section receives it. Now, my lord, whatever it is, since it's a rule issued, and because of my fault of my advocate in record who was not present on that day, for whatever reasons, I have ensured that the person, my lord, respondent number 9, who was really the person, territory manager responsible for allotting the petrol pump, is present, leaving aside all his duties. My lord, from Rajasthan, he has come, my lord, my lord, his lordship, if you want to, as per the procedure, he has also filed an affidavit. Also, although he is not presently the area manager, he had left, and when the matter was passed, someone else had come in, and he had filed the compliance report, for which I have filed these applications. My lord, you can ask his, well, he can tender his what?
Where is that affidavit?
Yes. Now, my lord, he has the person, or this Tiwari, Mr. Tiwari, has now filed an affidavit. My lord, although he is no longer responsible for this matter, and I will show to your lordship one thing which is very important. My lord, the contempt notice was served, my lord, dated 3rd March 2025. It was replied to by Nishant Kumar as territory of Durgapur, my lord, which ought to have brought to your lordship's notice that this person has left and is now for LPG, not retail. Now stationed, my lord, in Jaipur, but he has left aside all his duties and come because, my lord, it's a rule which has been issued. With regard, my lord, I filed applications. Now your lordship can do what is the needful. Will you please, my lord, take for, my lord, GA3 once? I can explain to your lordship what has happened, and your lordship will take appropriate steps.
Mr. Bose.
Yes,
my lord.
This Arpit Tiwari.
Yes, my lord.
Number 9.
Yes, my lord.
What is the designation in the original writ application?
Territory manager.
Retail.
Huh?
Durgapur. Territory manager, retail, Durgapur. Because the retail outlet is to be allotted in Durgapur. He was the only person, the retail manager.
He was the respondent in the writ application. So.
No, respondent was retail manager.
Okay. Who is the respondent number 9?
Yes. Territory manager.
Territory manager. He was the respondent number.
Yes.
He was the territory manager of that area at that point.
At that point of time,
Then
he
kindly come to the paragraph 2
paragraph 2
of your affidavit.
yes, madam. It is stated alleged contemners are not parties, correct. By name, alleged contemners, he is no longer.
Mr. Bose, you are the senior advocate. Contemner, by name, any written.
No.
How you can say maintain? Kindly see read the total paragraph.
Yes,
you
well,
want to accept this? I will accept this, but I will not leave this.
No.
Kindly read the paragraph.
Well, sorry.
See that?
Yes, it says what he means to say is alleged contemner.
I don't know what he means.
No, Milord. Yes.
We can say he was not a party to the writ petition.
No. The chief retail was a party. No. Oh, Milord, territory manager was not even a party in the writ petition.
Party?
No, I find the writ petition. So anyway, Milord, we take it he was wrongly described, but in the contempt notice, if you really want to know, which was issued, Milord, there are two notices. One is of November 2024 that was directed against, not by name, to a person, to the entity, which is retail, which I told you, territory manager. I can tell you the date, it's November 2024, it was. Then, Milord, the main one is 3rd March 2025. It was directed against Arpit Tiwari, but it was answered by Nishant Kumar, because by the time, Milord, this gentleman had been shifted to LPG of Rajasthan.
Whatever it may be.
Yes, but in the writ petition, Milord, he was the territory manager retail.
What is your duty? You could have been mentioned before this court in the name.
Milord, he was not. That is, Milord, that is the problem. Milord, it was fixed on a particular date, and it's a fault entirely of the advocate that he was not present to apprise your. Okay, will you see the order? Will you see the order which your lordship passed?
I know he was not present. I know he was not
Milord,
present.
what can I do? I was not briefed. And because of all this debacle, I have been briefed.
What about the other contemners?
Yes, Milord, I have filed this application.
What about the other contemners?
Milord, I will say, Milord, GA3 I have filed. Yes. Will you no, GA2 is for what? Oh, yes, sorry. Take the GA2 our application है कागज
GA2 GA3 सब यहाँ ला के रख दिए थोड़ा GA1 है GA2
Milord, will you please take GA2 once? Hey, sorry, GA or can 2. Can 2.
Yes.
My lord, if you please take.
Who filed this?
My lord, this gentleman who is in charge at present, the retail territory manager, Nishant Kumar, my lord, he has filed this, who answered the contempt notice. Now, my lord, if your lordship kindly see, my lord, R6, firstly, let us go one by one. So, let us take R1 first. My lord, R1 and 3 have superannuated. My lord, R1 is the probably managing director. My lord, will you take the cost title? My lord, I stated that in paragraph 23.
Krishna Kumar Gopal.
Yes, he is the managing. My lord, he
retired.
My lord, he has superannuated and he is not there.
Okay.
Para 23, I stated that.
Para 23 of GA2.
GA2.
Can 2.
Yes, my lord.
Sorry.
Yes.
But that finance 1, 3, 6, and 8 have superannuated.
Yes.
Yes.
No, my lord, 1 and 3 have superannuated, which I have said in para 23. Both are directors. My lord.
No, you stated that the alleged content number 1, 3, 6, and 8.
Yes, that I will come one by one, because 6 and 7 are of the locality. Therefore, I have more duty to answer your lordship, my lord. So I have said, my lord, 1 and 3 have superannuated, And if your lordship kindly takes, as far as respondent number 2 is concerned, my lord, he is the finance director, my lord, and the finance director, my lord, kindly see para 28, my lord, 20, my lord, 28 in more details. And also 23 also I have said that he is the finance director.
28.
Yes. 23 and 28. Now, my lord, in the writ petition, finance director was not made a party. But nevertheless, in the contempt notice, he has nothing to do with the finance director of a company stationed in Mumbai. My lord, in writ petition, finance director by name is not made a party, but by designation also. Now, my lord, we come to respondent number 4. My lord, para 27, I have said he was an independent director and he is no longer associated with the company.
Mr. Bose, sorry. Concern that notice was issued, it is the duty of the contenders to come to the court and explain they are not the party, let the court will decide.
My lord, that with respect, my lord, this, my lord, one thing, my lord, may I cite a Supreme Court judgment, my lord, the SOP recently directed by the, my lord, Chief Justice, Supreme Court. My lord, just take this. It was, my lord, just para, my lord, 4 and page 29. The Uttar Pradesh state of Odisha made an application for recall, highlighting legal obstacles complying with directions of High Court. And my lord, the SOP, which has been directed by the Supreme Court, my lord, is at page 29. Personal appeal. The court should exercise caution. Preliminary determination for in a proceeding instituted for contempt.
Which paragraph?
My lord, internal page 29.
Which paragraph?
My lord, para 5.
Yes.
My lord, personal appearance. The court should exercise caution and restraint when initiating contempt proceedings, ensuring a judicious and fair process. Then preliminary. In a proceeding instituted by willful, court should ordinarily issue a notice, to the alleged contemner seeking an explanation for their actions instead of immediately directing personal presence.
You mean to say that this has not been followed?
This, my lord, the note
not been followed.
No, the notice which has been
5.2 is followed or not? You tell me, sir.
The notice has not been.
Sir. Kindly say, ask your. I think you have not been properly advised.
My lord, they were given the compliance. The direction was to give compliance affidavit.
Yes, they appeared. He has appeared. Kindly.
My lord, he has appeared, but the.
Of course, again, I am telling, please, making a submission before this court, be cautious. If you have not been advised properly, he has appeared on the very first day and stated that he is appearing for all respondents.
My lord,
and he has asked for the time for the affidavit of compliance.
My lord, as an advocate, he
may be advocate, but you take the proper instruction from the otherwise you will be in difficulty.
No, I am instructed that basically, my lord, he got instruction, did not get instructions from.
What instruction? He had appeared.
He has
the court is specifically, and you know you are appearing before him for the last man. Specifically, I ask, yes, I am appearing for the order. Kindly see the order there. Order sheet.
Your lordship has asked, I mean, there is nothing more. I mean, if he has said, I am appearing.
25th of July, 2025. Kindly have a look at this order and paragraph 3 of this order.
Oh, he has said, I am representing the contemners.
Yes.
Now, my lord, kindly see 5.4 in the SOP.
An advocate appearing for the alleged contempt has handed over the bunch of document. He has appeared, he filed the documents. This court was not satisfied and he have directed to file the compliance.
Yes, my lord, kindly see 5.4 of that SOP, please.
So 5.2 has been complied.
My lord, very well, my lord. Then notice. Yes. Then, following the instance of notice, court should carefully respond of based on their response or absence thereof, it should decide on an appropriate curve, depending on severity, may direct personal appearance of contender. Then 5.4, procedure when is directed. In cases requiring physical presence of a government official, it should provide advance notice for an in-person appearance following ample time for preparation. However, the court should allow the officer at the first to appear before it through video conferencing. Millard, my humble prayer, I filed this application. Millard, this is
Whether they are appearing today video conferencing.
No, they are not appearing, Millard. So that leave also has not.
It could have been appeared through video conferencing. You take the leave. They may be allowed to.
Millard, the respondent number 9 has appeared. I'm just telling your lordship, one person does not exist. Millard, although I believe, Millard, kindly see, Millard, respondent number 5. Millard, sorry, respondent number 7, para 23. There is no such person in that name. So how? So I'm Millard indicating. Millard, the rule has not been served personally on any person.
Who has received?
The stamp dispatch section of the company.
Why you received the
Millard, that is for the company. No, that Millard, with great respect, this is the contempt jurisdiction. It must be received by Millard, the person, and your lordship can check.
So you should not appear. They are not received the notice.
No, but it's Millard, matter has come. I have been engaged on behalf of Bharat Petroleum.
You have notice.
Your notice.
Your client has.
No, not my client. Client in the contempt is not my.
I appearing or not?
I am appearing on behalf of the person who has affirmed, respondent that.
Only one you are appearing.
Millard.
You are appearing for only one person.
No, Millard. Today, the rule has not been served. I am not appearing for one. I am appearing.
You tell to whom you are appearing.
Millard, I am appearing for respondent, this number 9 who is present here.
Nishant Kumar.
Yes.
Yes.
And for the others, for whom another person has affirmed an affidavit. The reason why another person has appeared, Millard, has filed an affidavit is to file an application. He has filed an application as authorized representative of Bharat Petroleum, saying this is the position. So, because the rule has not been personally served on anyone.
This point has been taken in that affidavit or
in this application.
Yes.
Yes, application. I'm pointing out.
That personally, why not personally served? Personally.
Millard, it has. It's nobody's case. The records will show. The records will show.
How you came to know that it has not been personally? It is to
because I know the dispatch section.
Which dispatch section?
The Millard, the head office dispatch section.
Dispatch section. So
yeah, just receives it, Millard.
Who kindly then you kindly identify who are in service in the said section, in the said department.
Yes, yes.
You identify the persons,
Millard,
officers.
As I told your lordship.
You identify the persons who are still in service and working in the said office.
Right. Millard, as I told your lordship, I said in paragraph 23.
One has gone.
1 and 3 have gone.
1 and 3 are retired.
Millard.
Okay.
Then para 23 also. Millard, this is of course the Calcutta, the local office, Goriahat, who technical.
I don't know. Only I'm telling you are telling that this has been received by the department of the dispatch.
Right.
They have not received personally. So that's why I'm telling who are the person still in service and working.
I am
attending the service.
I am telling your lordship, Millard. Just a minute. 1 and 3. Millard have superannuated. Yes. Yes.
Then why
Millard,
department has received on
that Millard, anything comes with the name of the company, they receive. Millard, I cannot vouch why they have received. I am for the contemners. I am for the contemners right now. This is contempt jurisdiction. Right. Now, Millard, contempt as it fell from Justice Rao, it is contempt jurisdiction. Now, respondent number 4, para 27. I have 7.
Yes, tell me.
Yes. So para container 4 is no longer. Now, Millard.
Container 4 is no longer.
No, para 27. I've Millard, it says no longer associated. He was independent director. My lord, like
Director of what?
of this company at one point of time, independent director.
Government nominated.
Government nominated independent director.
Mr. Bose, instead of all these things, instead of this confusion, kindly tell this court.
I'm telling one by one.
No, leave aside. Okay, retired. I will take care with this court. Will take care.
So another person.
Care of it. With regard to the others who have received, I kindly tell whether they will appear before this court or they will adamant to appear before this court.
My lord, may I tell your lordship? May I tell you?
Whether they are.
I'm telling you who are not there, as it fell.
They are not there. We'll see to
So,
that.
so
Kindly first you give the answer who are in service and the office has received the notice, whether they are intending to appear before this court or not in terms of the rule issued.
My
This
lord,
question you answer that, thereafter the who died, who retired, who left, then we'll see to
my lord, as far as my instructions are concerned,
so they will not appear.
the respondent number 9, rather as implemented, although he is not the retail, is present in court and will
Okay, who present in court will take care of.
so
it.
he has appeared, respondent number 9.
We'll take care
So
of
far as the others are concerned, none, my lord, my instructions are, none of them personally received the rule. The company dispatch section received it. Now, out of them, some of them are no longer also in the company.
Again, you are not giving answer to the court, sir.
My lord, I have no instructions.
No, again, you
He
are
has not
giving
filed.
answer to the court.
My
Who retired, who left, I am not on that. Who is in service out of this?
Right.
Give the
My lord, I'll just say that one. You want to know who are in service. My lord, the contempt number 2, my lord, 2 is the finance director. Finance director. Nothing. Huh? He is there in service.
Okay.
Now, 1. Contender number 5, my lord, is director human resources, HR. My lord, he is there. No, 5. He is there. Now, my lord, I have pleaded in paragraph 28 and 29, the finance director or the HR, they were not parties in the writ petition. They had no involvement. They don't.
Mr. Bose, again you are telling once you are telling that you are not appearing for the other contemners. Now you are making a submission for the contemners. You first made up your mind whether you are appearing for the contemners or not. You are telling that you are making.
No, they have not been served with the rule.
So you are making submission how to whom?
Because someone else has affirmed on behalf of the company, the authorized representative.
So he will take the he will take the responsibility.
My lord, he has filed that.
Mr. Bose, it is a contempt proceeding. Whether the one person can give the affidavit to the all persons in the contempt proceedings.
No, my lord, but someone.
Whether it is possible.
No.
Please tell me this court. Tell this court.
But they are not in. So let me tell you first
First, you tell me specify whether you are appearing for all contemners or not.
No, I cannot.
So why you are making submission?
Because someone has filed the application on behalf of authorized, my lord.
Who has filed the application?
My lord, the application is on behalf of BPCL, the respondent number 1.
So BPCL is taking care of all. But, BPCL has given the advice not to appear before this court after the receipt of
No, BPCL has not advised anything. BPCL has
responsible person of the BPCL.
My lord, the BPCL has advised the authorized representative with this person. This is 1. Let me tell you first who are not there, right? Then you will do, my lord. Then para 30, respondent number 6, although he is this Goriahat office, he is not there in service. Right?
Number 6.
6.
Retired.
Right. Not in service. Para 30. Respondent number 8, my lord, he superannuated paragraph 31. Also Calcutta office, I must also disclose, my lord, in their designation are parties in the writ petition. My lord, R7, there is no such person.
No such person means?
I mean.
So how your office has received the notice?
They received, my lord, because it was stamped, my lord.
Who has received?
With the dispatch section, my lord. My lord, he is not, he was not such a person, never existed. Huh?
Then why it has
Why your office has received?
My lord, office has received.
No, it is a
Right, contempt rule, my lord, anything which is served, in the name of it, it is received. That's what I am saying. None of these people have received. Then, my lord, kindly about the yes, also contender number four.
Who has affirmed this?
My lord, the same person, Mr. Who is the territory retail manager.
Who has affirmed the
My lord, the Nishant Kumar.
What
His designation is, my lord, the same designation as this Mr. Tiwari. Nine. My lord, that is, he is the present territory manager, retail, and he say he.
One thing. You serve the scan number 2 to the Mr. Bose.
Yes, everything, sir.
Mr. Bose, you got that?
Yes, yes.
Please go through who is not there and clarify on the next day. If not there, you take appropriate steps. And with regard to the other persons who are not appear before this court, I am issuing the warrant.
Very well.
My lord, I humbly submit that none of them have been served with the rule. Your lordship, they have been served.
Cannot record submission.
Yes.
Cannot record his submission.
Because you are not appearing.
No, I am appearing on behalf of respondent number 1, BPCL, to apprise your lordship of.
Recording here this. With regard to the other, you are not appearing.
May I just indicate only one thing based on their affidavit? Your
My
lordship
lord, I don't know what instructions. Please, I am a creature of instruction. What do you want to say?
We are representing all the contenders.
Then how can you represent this person who are not there? Can you represent them?
No.
My lord, he will give him the liberty to make, because I don't take responsibility of making this something which is not there, but he gets a vokalatnama or anything to appear. Because he hasn't.
That's why
So correct, but he did. He did on that day, and contempt jurisdiction is not to be. People don't understand the implications. My lord, I can't do anything. My lord, so you please ask him, because I am a creature of instructions. I've told whatever the facts are. I have been engaged not by any person, I've been.
We want to allow him to make some.
Yes, on the who wants to appear, whether someone who has left, also he is appearing. Let him make his submission. Someone who does not exist also, he says, whether he has vakalatnam also, I don't know. But he did, as your lordship pointed out, for all the contemners I am appearing. So your lordship will.
We have been instructed to represent all the contemners because the law department has a copy of the contempt application, my lord. The law department of the BPCL of the local office of Kolkata regional office has got a copy of the contempt application, and accordingly we have instructions to appear on behalf of all the contenders, because at one point of time they were all there in service. At one point of time they're all there, because
except one person,
except one, seven was never there. So at one they were all in service, because BPCL is BPCL was the respondent in the writ petition, and since all the parties were separate designatories of the BPCL, the then designatory as well as present designatory, that's why we have been instructed to represent all from the law department, of the corporation.
So when the order was passed, at that time they were in their post.
Absolutely, all of them.
All of them.
In 2022.
No. Talking about 25.
When this specific order was passed by the Honorable Justice Subletting Talukdar and
2022.
Yes, at that time they were in the post.
Service.
Yes, and they did not comply with it.
No. With great respect, they were not parties to the writ petition.
The company was a party.
Company.
Yes, they were not parties to the writ.
So we are.
Please, Mr. Bose, you take it. Let your colleague submit.
My lord, contender number.
BPCL was a company.
BPCL was the respondent. The other two general manager as well as chief manager was the respondent in the original writ petition. Now, out of all the 9 contemners as on December 2022, where except 7 was not there, and except 4, all others were there in service.
Except 4.
4.
4 and 7.
4 and 7, all others were there in service. But so far as 4 is concerned, we're not sure.
No, 4 I'm not sure. So this is also wrong.
No,
name.
4 I have to take instructions because my instructing officer is also is not aware as to whether respondent number content number 4 was there in service or not. And
it cut short the matter.
Yes.
Cut short the matter. Who are not there, you already filed the affidavit. Mr. Arpit has filed Nishant has filed the affidavit. You serve the copy. Mr. Bose will take care of it, and will after the reply or anything, then this court will take care of it. Correct.
Yes.
And with regard to the other persons who are in service and your office, as per the submission of the Mr. Bose, the office has received the rule. Correct. Office has received. What the court, what you want now? If they have received the rule, or office has received the rule, what now the court will do if they are not appearing even through virtual mode?
If losses may kindly give one more chance to appear at least virtually on the for the 2 other containers who are still in service. Container number 2. No, they were.
Let they appear before this court when the court is reopening.
If losses may permit. Oh, no, if losses may permit to appear virtually, because they
should now you can. If we could have been allowed, if today they could have been appeared through virtual mode, we can come. But today they are not appearing. Adamancy. They are not appearing through virtual mode. Why now we can recall our our order?
What is the issue?
And you mentioned that when you mentioned, Mr. Bose has mentioned, on that also you are not mentioned that they may be allowed to appear through the virtual mode.
Well,
if they wanted to recall the order.
Well, since there is an application also filed, for expunging.
That will be decided subsequently. Once the court has passed an order for issuance of rule, you have to comply with. You have to appear on 29th of October in person.
Millard, may I make some submissions? Millard, so far as these gentlemen, how many people are there? We have found out.
Total there are 3. 2 are here. 2 persons are there in head office.
Right.
R2 is there.
Two and
2 is there.
R2 and
4 is there.
R4.
For your no knowledge.
No. I have knowledge. Millard.
He is no more there in service as of.
No, you have received the notice on their behalf, but you did not deliver. Why not? Even
that is more
even they are retired from their service. You have received their notice in their name, but you did not deliver to their address. Why? That you should have informed them. Yeah, we have received your notice on your behalf. Now, please take care of it. Give appropriate instruction or take appropriate steps before the Honorable High Court. Why you have not? You have received the notice on their behalf. Now you are saying that though we have received the notice, we did not deliver it. Why not? Answer: our order is not being complied by BPCL. That is the main thing.
The person concerned.
No, we shall not tell.
Is responsible.
Let them appear all appear in person.
Yes.
And my lord, your lordship will be surprised to know none of the applications, not one sentence on compliance. Nothing.
So, Millard, regarding compliance, also we have filed, Millard, now the application for compliance through the respondent number.
How, Mr. Bose, you're senior person, how you can say through per one person?
No, not through, also individually. We have circulated. The respondent number 9, who was then, who has come down.
We are taking care of it. Respondent number 9, we are taking care of. He's not appearing in person.
And also filed an affidavit. Yes.
We'll take care of
and
it.
Also filed an compliance affidavit.
That will take
that the order has been complied with on behalf by BPCL. Well, there are 3 more applications.
What applications?
One is the expunging these names. that is GA2. Respond.
Just a matter. Who has filed an application for expunging the name, Mr.
Melod, the BPCL has filed. BPCL has filed.
And who is the
authorized representative?
Who is the authority of the main authority of the BPCL?
The authorized representative.
Who is the main authority of the BPCL?
Respondent number 1. Respondent number 1.
I am leaving all.
Respondent number 1.
Liability.
And my lord, kindly see the affidavit. Your lordship is looking at CAN 2. Kindly see the affidavit page at page 21. Kindly see the affidavit page. It specifically records, I am the territory manager, Durgapur, and constituted attorney of Bharat Petroleum. I am well acquainted.
Paragraph?
My lord, the first paragraph at page 21, the affidavit page.
That's what I said.
Kindly look at the second paragraph, first paragraph. I have been duly authorized and am competent to affirm this affidavit on behalf of the respondent number 1.
That is respondent number 1, Manoj.
And kindly see who's the
respondent number 1 in the read pitch.
No, this is a contempt jurisdiction. Respondent number 1 is the chairman.
No, the chairman is no longer there.
So then what? You are filing an affidavit in a contempt proceeding. Wrong. Then you have to suffer the consequence. Wrong. Everything is wrong. 3 orders have been passed in the contempt jurisdiction. 3 orders. Your lordship passed the first order. I insisted on rule. Your lordship said no. Serve notice. Notice served. My learned friend appears. Thereafter, lordship gives them an opportunity to explain. They produce documents. Thereafter, when they failed, then your lordship issued rule. So the SOP has been complied with.
By an order dated.
May I explain the 2 applications?
Huh? Yes, I will give them, serve the copy. They will file their opposition.
No, the other application, Miller.
Yes, all applications serve
No,
the copy.
and GA1, what?
Can 1
is about.
Whatever it is, serve the copy. I will let
Miller, Can 1 is for addition of National Highway Authority.
Let the file affidavit. Let the file affidavit. How in the contempt application, whether the
whether that is no, whether
NHI will come and say, I was not the party to the main
so
order.
we have also filed a writ petition against NIHF for their no objection. Where because Union of India is
by an order dated 4th September 2025. This court issued rule upon all the alleged contemners. The Assistant Registrar Court has filed a report dated 20th September 2025, wherein it reveals that the
my lord, one thing, just my lord, in the order which you directed issuance, will you just look at the order once, my lord? Just that order.
Yes.
My lord, on that order, if you can read entire thing, my lord, your lordship, my lord, on that day, it was not the date fixed, but 4 days later, the matter appeared. The advocate on record missed the list and couldn't come. And my lord, therefore, you can read the order, my lord, and because you found it was represented by them that because Nishit Kumar is not an impleaded party, he cannot affirm affidavit on behalf of the respondent. My lord, to that, the answer which has been given, and I must tell you that the contempt notice was served and replied by Nishit Kumar, which was not annexed not drawn to your lordship because he is the person who is dealing with the matter. Okay, that bit, my lord.
By an order dated 4 September 2025, this court has issued the rule against all the contemners, full stop. The Assistant Registrar Court has submitted the report wherein it reveals that rules issued against the contemners have been duly served. Third, after the receipt of the rule, only one contemner, that is a contemner number 9, namely Arpit Tiwari, has appeared before this court in person and has filed affidavit in compliance of the order dated 22nd of December 2022. Let the same be kept with the record. Full stop. None of the other contemners have appeared before this court in spite of the issuance of rule. Full stop. Net Senior Counsel Mr. Tilak Bose submits that the submits that the rule has not been served personally to the alleged contenders. But the report submitted by the Assistant Registrar Court reveals otherwise. The one application is filed being CAN number 1 of 2025, praying for addition of party. I'm praying for National Highway Authority of India be added as contender in the instant contempt. CAN number 2 of 2025 is filed by one Mr. Nishant Kumar, praying for expunging the name of the alleged contender number 1, 2, 3, 4, 5, 6, and 8 from the contempt application. Any other application is filed?
Yes, 3.
What is the
For recalling of the order which was
application
passed
being CAN 3 of 2025
because of failure he couldn't appear.
Praying for a recalling of the order dated 4 September 2025, wherein the rule has been issued against the alleged contempts. Full stop. As regards the CAN number 1 of 2025, Learned Counsel for the petitioner prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 1 week after Puja vacation.
Yes, sir. And my lord, kindly keep the point of maintainability open.
A reply, if any, there to be filed within a week thereafter. The counsel for the petitioner challenge the maintainability of the CAN number 1 of 2025. The same is kept open. As regard the CAN number 3 of 2025 filed by Mr. Nishant Kumar. We can recall. Filed by one Nishant Kumar, claiming to be the territory manager within bracket retail Durgapur, constituted attorney of the Bharat Petroleum Limited. And he has also stated that he has been authorized by the competent authority to file this affidavit. This court finds that rule has already been issued and is already served upon the alleged contenders. Thus, nothing remains in the present application for recalling of the order dated 4 September 2025. Accordingly, CAN number 3 of 2025 is dismissed. As regard CAN number 2 of 2025.
My lord, will you be pleased to note my contention that personally my cases, they were not received.
2025 is affirmed by one Nishant Kumar, being the territory manager within bracket retail Durgapur, for praying for expunging the name of the alleged contender number 1, 2, 3, 4, 5, 6, and 8. This court finds that rule has been served upon all the alleged contenders. But in spite of receipt of the rule, none of the contenders even choose to appear through the virtual mode. And this application has been filed by Mr. Nishant Kumar. Thus, we are of the view that the application filed by Mr. Nishant Kumar at this stage, after the issuance of the rule upon the alleged contenders, is not maintainable, and the same is dismissed. This court finds that the rules have been issued upon the Mr.
Kindly
Tilak
record
Bose,
respondent
Learned
number
Senior
9
Advocate.
is present.
Mr. Tilak Bose, Learned Senior Advocate, has relied upon the judgment in the case of State of Uttar Pradesh and others versus Association of Retired Supreme Court and High Court Judges at Allahabad and others, and pointed out clause 5 of the said judgment and submit that the notice prior to issuance of the notice, prior to issuance of the rule for personal appearance, notice is to be issued, but no notice has been issued. He further submits that the contenders should be allowed to appear through virtual mode, but this court has directly pass an order for issuance of roll for personal appearance. Consider the submission made by the counsel for the consider the submission made by Mr. Bose and peruse the judgment. This court finds that the submission made by Mr. Tilak Bose that the notice prior to issuance of the notice, prior to issuance of the rule notice is not issued is not correct. When the matter was initially listed before this court on first day, this court has directed the learned counsel for the petitioner for issuance of notice upon the all respondents. Accordingly, the petitioner has served the notice to all the respondents through postal services and, on the returnable date has filed the affidavit of service. On the returnable date, one Mr. Amit Kumar Nag had appeared on behalf of all the alleged contemners and submitted that he's been authorized by the all contemners to appear before this court. And he has also submitted the bunch of documents containing 74 pages. Taking into consideration of the documents, this court directed the alleged contemners to file their affidavit of compliance by 28th of August 2025. Though this court was not in session on 28th of August 2025, but this court taken up the matter on 4th of September 2025 by publishing the matter in the cause list. And on the said date, the learned counsel for the petitioner has appeared, but none appears on behalf of the alleged contemners. The learned counsel for the petitioner has also pointed out with regard to an affidavit filed by Mr. Nishant Kumar, who was not the contemner in the present case. Accordingly, this court has not accepted the said affidavit and issued the rule against all the contemners. Thus, the submission made by the counsel for made by Mr. Bose is not acceptable before this court. In view of the above, full stop. Considering the above, we are of the considered view that after the issuance of receipt of the rule, the alleged contemners failed to appear before this court, even virtual mode. Accordingly, this is the fit case where the warrant can be issued. The petition is directed to take appropriate steps for issuance of filing requisite.
My lord, I am humbly praying that an opportunity.
Any ladies there?
My lord, an opportunity be given
I'll just check,
to these people
I don't think there's
to appear once again.
No,
The persons who are present for others. My lord. My lord. My lord,
there is one lady. R4 is a lady, my lord. Kamini Chauhan.
My lord, respondent number
All the contender except the contender number 4.
My lord,
Yes,
I am
four,
humbly
four,
praying,
four.
my lord, that for respondent number.
S is the lady.
Kamini
S is a woman.
Yeah.
S is the woman.
My lord, they will, if necessary, appear. My lord, I'm praying for extension because it's a misunderstanding or whatever. My lord, please allow at least respondent numbers 2 and 4 to appear, my lord. Virtually, if possible, they will appear.
Counsel for the petition is directed to take to file requisite in the department within a week for issuance of the warrant, and the department is directed to issue warrant against the alleged contemners. Except respondent contempt number 4.
My lord, I am humbly yes.
After the order passed by this court for issuance of warrant, Mr. Tilak Bose, learned advocate appearing for the alleged contemners, submits that
upon instructions, my lord.
Upon instructions, submit that the alleged contempt number
2 and 4.
2 and 4 will appear.
Oh, sorry. 2 and 5. Taito. देखिए भाई, just.
Photo lady है जो तो
My lord, yes.
Who?
Yes. Sorry, 2 and 5. 2 and 5.
Submit that alleged contender 2 and 5 will appear before this court in person on the next date fixed. Accordingly, no warrant. Full stop. As Mr. Bose has given an undertaking.
My
before
lord,
the court-
undertaking upon instructions.
Hmm.
My lord. I
Given
cannot
undertaking
personally
before this
undertake.
court on instruction that the respondent number 2 and 5 appear before this court in person on the next date fixed. Accordingly, no warrant be issued against the respondent number alleged content number 2 and 5. 2 and 5. And let the matter appear on 29th of October 2025 for appearance of the alleged content number 2 and 5 in person and returnable of
warrant করলাম না কিন্তু ফোরকে তো আসতে হবে
for appearance of sensation. So this is the matter on 29th.
My lord, with regard to 9, please
Acha,
exempt.
the respondent number the content number 9 is present in person and filed the affidavit of compliance. Accordingly, for the present,
should
his
appear on
appearance
29th.
his personal appearance has been dispensed with.
No, he should also appear on the 29th.
His personal
Very
appearance is let you go
very
consider
very,
the
very,
reply.
very.
For the present, his personal appearance is dispensed.
My lord, instead of person, your lordship will not make it video conference.
Sir, not in this matter. My
If the officer not
Today you very first you can make this submission, the court of
one
law.
over. Grateful.
that's a prayer, my lord. That's
granted, my lord. This is with regard to a disposed of application, my lord, which was disposed of a company winding up in 2002, my lord, when this honorable court had jurisdiction. Now, my lord, scheme was framed, and subsequently thereto it shows that the matter was disposed of. As we inquired, my lord, the records had been sent to the NCLT by this honorable courts department. But, my lord, when we went to the NCLT, we find that the records are not traceable, my lord. Or rather, they say that no such records are there. Be that as it may, my lord, we have taken out an application, my lord, for making certain modification in the scheme, because we are for the workers of the company who are not being paid any dues, nothing. Now, my lord, the land is there. We are praying by way of judge's summon, my lord, for a receiver to be appointed, and, my lord, the land to be sold out. But, my lord, until and unless, because, my lord, as far as the bar in the Companies Act is concerned, my lord, it is with regard to the pending applications. This matter was disposed of, my lord. So, my lord, just if my lord is not satisfied on my application, my lord, may pass necessary orders, but, my lord, I am unable to file, my lord, without
if it transferred,
my lord,
then how this court is having jurisdiction?
My lord, my understanding, my lord, subject
it is
to
transferred
whatever
by an order.
My lord, here, my lord, the honorable court's case details shows that it has been sent. No order has been uploaded, my lord, and this is what the NCLT, my lord, show it to my lord. My lord, no details are find out. Please enter, my lord. That is what the NCLT says, my lord.
Transferred. Nature of disposal transferred. Order আছে না 2017 order আছে আপনার থেকে আছে কি? You are having this order.
My lord, what I'm humbly submitting, my lord, without wasting my lord's time even further, my lord, let me inquire. Otherwise, my lord, I
do one thing. You tell your advocate or
yes, my lord,
to go to the
yes, my lord.
office. If there is an order, then you make a put.
Then, my lord, I have no. But, my lord, if there is no order, my lord, then again I will try to come to my lord again tomorrow. একবার দেখে নিন, একবার সাহেব ও দেখে নিন, my lord.
In company matter. When you receive the writ of summons, but nobody is in.
13th of June 2000.
13th of June you received. Within 120 days. Affirmed.
Before my lord takes up the fixed matter at 2 p.m., would it be my lord's pleasure to take up item 6 of your lordship's daily list, my lord? It's a 10F appeal, my lord, of 2015, my lord, pursuant to an order of my lord August 20, 2025.
Company matter.
Company matter, my lord.
6.
Yes, my lord. Item number 6 only, my lord. I will only take, my lord, 2 minutes of your lordship's time, my lord. Pursuant to last day's order of my lord August 20, 2025, my lord, a direction was given for inspection of documents, my lord. It's an old case, my lord. This 10F appeal, my lord, has roughly 6 interlocutory applications, my lord. ACO 2, my lord. And, my lord, ACO 6 is where, my lord, our records, my lord, from our and I pay for the petitioner, my lord, is incomplete, my lord. Leave be granted, my lord, to have an inspection of, my lord, ACO 2, my lord, and leave me may kindly be granted to reconstruct, my lord, the affidavit in reply filed in ACO 6, my lord. That's only
Once the record is will come here, then I'll pass an order for accepting your reply, then reconstruction.
Very well, my lord.
ACO 6? What? Already inspected ACO 6.
My lord, ACO 6 has been inspected. My lord, the reply, my lord, to ACO 6, my lord, it's not with us. So leave may kindly be granted. So it's not with record, my lord. So leave may kindly be granted, my lord, to reconstruct that.
No, that's why if it is today, if matter is taken today, you give the then I will pass a judicial order.
Very well,
by keeping the same as a part of the record. Then no problem.
Very well, my lord. And leave may kindly be granted, my lord, to inspect ACO 2, my lord.
ACO 2 record is there.
My lord, I've been instructed, my lord, those records have been, it's been located, my lord, by the department. That's what I've been instructed.
Okay. Grant.
I'm deeply obliged. My lord,
the no effective purpose would be served, my lord, because the papers are yet to be, my lord, organized. We also don't have copies of papers, my lord, on the last.
So that's why once the matter is taken up, then if the not paper, then it can be reconstructed. If it is not there, then all the parties, you are having affidavit, they are having replies, so that will be reconstructed. The matter can be taken up.
Very well.
So now Mr. Sen is taken the source of that all.
I'm grateful, man.
He is busy person, my lord. He was trying to get himself freed. Because I understand, my lord, the earlier fixed matter would continue for some time.
I'm grateful, my lord.
I agree with what you say. And I have reasons to agree that I will tell you next.
I appear for the applicant, my lord. May I beg to submit only one thing, my lord? My lord, today's matter is sixth matter, my lord, adjournment 2. And it's order dated 10th of September, order, my lord, kindly see once, my lord. The second last page, last paragraph, paragraph 23. There is direction upon the bank. I am appearing for Punjab National Bank in the matter, my lord. There is direction upon me to pay the value, my lord.
Huh? Pay the amount, huh?
Or paid value.
Paid.
Okay. Value is there, he will confirm that.
Okay, okay.
That
Thank you. Thank you for payment.
My lord,
Lord, may I
But
file
nowadays nobody complies with orders. That's the problem. Happy to see somebody has.
That's why. That's why the court has thanks him twice.
Your lordship was surprised. And it had in fact been compliant.
Yes.
Copy to these.
File the report.
Copy the
report.
But this report is in between the, this is an administrative matter, not in between the official liquidator and
What
the
has
court.
happened?
What is there is not, my lord, kindly see. My lord, I have, my lord, if your lordship kindly takes, my lord, 14th May 2013, my lord, the winding up order was passed. 1st July 2013, my lord, the possession was taken of the registered office.
1st July
2013. 1st July 2013, my lord.
No, kindly come. 1st July 2000. You have taken the possession of the entire assets were taken on 14 March.
Yes.
As stated in paragraph
Yes.
3.
Now, my lord, kindly see the 1st July paragraph 2.
Yes.
Paragraph 2. That pursuant to the order of the winding up, the representative of the official liquidator took possession of the registered office of the company lying and situated at 11 Pollock Street, 6th floor, Kolkata 7 lakhs 1 on 1st July 2013 and completed inventory. Then, my lord, on the basis of the report filed by the office dated 21st November 2023, this honorable court was pleased to pass an order directing the official liquidator to the secured creditor Oriental Bank of Commerce to hand over all the assets and properties of the company in liquidation to the official liquidator High Court Calcutta forthwith. And accordingly, official liquidator took possession of the factory premises of the company in liquidation situated and so and so, and the issued notice upon the ex-directors. The representative official liquidator posted security guards for round of the clock through CAT-I Security Services, a panel security agency for protection of the assets of the company in liquidation. The secured creditor agreed to bear the security expenses. The possession of the factory premises and the preparation of inventory of the assets lying thereat was completed on 14th March, 15th March, and 19th March. Most of the books and records of the company lying in the factory premises were inventories by the representative of official liquidator Calcutta. Then, my lord, a letter dated 16 June 2014 written by the security agency for the first time, CAT-I Security Service, that an incident of theft of the factory premises at Nasik, and consequently the security agency had lodged FIR before the local police station. Thereafter, receiving such letter from the end of the security agency, the representative of the official liquidator made an inventory upon prior notice to the secured creditor and superintendent of police of Nasik with regard to the missing assets of the company in liquidation on 27 June 2014 in presence of the police personnel and senior police station and proprietor of security agency. It is pertinent to mention that CAT-I Security Service failed and or neglected to provide necessary service for the protection of the assets of the company in liquidation. Therefore, the official liquidator, having no other alternative, engaged another empaneled security agency, Shiva Shakti Security Services, on 28 June 2014 for protection of the assets and property of the company, and after withdrawing the engagement of CAT-I Security Service on 27 June 2014. Now, my lord, if your lordship kindly turns to Annexure A, page 11 and 12. My lord, this is the FIR. My lord, CAT-I, they have intimated by their letter 16 June 2014, and my lord, this next page is, my lord, the FIR.
Yes.
Then, my lord, the minutes of the meeting, my lord, the next page, page 13, my lord, that is the minutes of the meeting. My lord, the official liquidators representative present therein and take inspection.
in presence of the, my lord, the superintendent of the police and, my lord, the security agency personnel. These are the minutes. My lord, details of the items, my lord, the details of the items has been given, my lord. Each and every items, my lord, given, my lord, it contains 11 to page number 11 to 22.
Yes.
Then, my lord, it is next, my lord, official liquidator issued a letter on 20th June 2014 addressed to the concerned police station, which senior police station, as well as the above said secured creditor, with a request to join inspection on 27 June 2014. The official liquidator then lodged a complaint regarding theft of assets with the superintendent of police, Nasik, by letter dated 11 July 2014.
What has happened to the complaint made by the?
Yes, my lord, I am coming to that. My lord, I have also mentioned in the report. My lord, kindly takes the page, my lord, 23, annexure B.
Yes.
Page 23 to 25, my lord, that is the complaint of
Correct.
the official liquidator.
Correct.
Then, my lord, kindly see next paragraph. The official liquidator filed a report being CA number 453 of 2014, dated 16 July 2024, regarding the above said theft, with a prayer to issue order to the superintendent of police to conduct a proper and fair investigation in time-bound manner and inform the progress of such investigation. While considering the report, this Honorable Court, by its order dated 25th July 2014, directed the concerned police superintendent to conduct the investigation of the complaint dated 11 July 2014 and intimation of the result of investigation be communicated within 8 weeks. My lord, that is the order. My lord, the page kindly turns to page 26. Yes. Annexure C.
Yes, this is a report.
Yes, my lord, this is the order, my lord, and my lord, the report also therein. Then, my lord, the next paragraph. The official liquidator issued letter to the concerned police superintendent dated 8th August 2014, followed by the reminder dated 22nd October 2014, together with the order dated 25th July 2014 regarding progress of the investigation as directed by the Honorable High Court. Copies of these letters, my lord, that is annexure D. My lord, page 74, 75. Then, my lord, kindly turns to, yes, 9. The official liquidator filed its letter dated 22nd October 2014, asking explanation regarding theft of the security agency, which Cat Eye Security Service. However, no reply was received from their end, and since the same is not available to file on record. On the official liquidator received prima facie investigation report dated 3rd September 2014 from the local crime branch, Nasik Rural, on behalf of the superintendent of police, Nasik Rural, wherein the police authority valued the theft property of rupees 42,000. But the basis of the said has not been explained and recovery shown as nil. The official liquidator further received a letter on 3rd November 2014 from the local crime branch. It appeared that neither the accused arrested nor the assets recovered. My lord, a copy of this, my lord, letter 3rd September and my lord, 3rd November. Those are, my lord, the annexure E, page 76 to 77. My lord, that was, if your lordships kindly see page 76 to 77. Yes. But the first, my lord, the letter, my lord, 3rd September, your lordships got it?
Yes.
And my lord, the second
So
one.
nothing was recovered, no person was arrested.
Yes, my lord, kindly turns to page 78. The another letter which was received from the 3rd November 2014.
Yes.
Where, my lord, the valuation has been made that what is the lost amount? 42,000 as above, my lord. It is mentioned there. Then, my lord, by an order dated 11th December 2014, the official liquidator engaged Mr. Somur Banerjee, valuer, to evaluate the assets and properties of the company. Accordingly, Mr. Banerjee, valuer, submitted a valuation report of the factory premises of the company to the office on 24th April 2014. My lord, the procedure which was adopted by this Honorable Court by an order of this Honorable Justice, my lord, the Vishwanath Samaddar, my lord, the official liquidator was directed, all the valuers were directed not to submit the original valuation report with the official liquidator, but before this court. So this report was also submitted before this court, and that is the reason for which it was not possible for the official liquidator to what was the valuation, my lord. So, my lord, this is mentioned in then, my lord, the
So once the report of the Mr. Banerjee was received, why the second report has been called for?
Yes, my lord, there are 3 attempts were made for sale of the assets. Not a single, my lord, attempt was succeeded. Then, my lord, it is the practice of the official liquidator's office. My lord, if further, my lord, the direction is being given by this honorable court to make a valuer, then, my lord, another valuer is being appointed. That is being done.
Another valuer can decrease the total value of the property?
No, my lord, this valuation, my lord, if your lordship see, kindly turns to, this is most important.
Because on the last occasion, it was submitted, though this court has not recorded and taken note of it. You have submitted that was before the theft, and this is after the theft.
Yes.
But as per this report is not before the theft, after the theft.
After
Banerjee's
the,
report is
yes,
also after
yes,
the theft.
after the theft, my lord, this report was done. Now, my lord, your lordship kindly see, my lord, the report was filed before this honorable court on the basis of the, my lord, the observations of the honorable court. A meeting was held in between all the valuers, all the impaneled valuers of the official liquidator. A meeting was held and the decision was also adopted. If your lordship kindly turns to paragraph, page, my lord, report, it starts from page 92. This is very important. Because in that meeting, Mr. Somor Banerjee was one of the signatories, and he knows what is the decision was taken, and when that was accepted by this honorable court, that report was accepted.
No, that's correct.
Now, my lord, how the payment will be made? If the company has got no funds, then, my lord, the payment will not be made. My lord, that is mentioned therein in each everything. Lord, kindly see the report. Then, my lord, kindly turns to page 97. This is the minutes of the meeting. And, my lord, in that meeting, my lord, what was the decision? And, my lord, item, Mr. Somor Banerjee, he has put his signature, is item number 5. He was present and he knows. And this, my lord, report was, my lord, affirmed by this honorable court. My lord, the order, my lord, is, my lord, page 99. My lord, kindly see page 99, my lord, the order dated 6 September 2013. May I place, my lord, the empaneled valuers have agreed to bring down their remuneration for evaluation to be made in respect of the company in liquidation. The report filed by the official liquidator shows the free structure that would be given to the empaneled valuers, which have been accepted in the meeting held by the official liquidator on 27th August 2017. The official liquidator is directed to pay remuneration to the empaneled valuer on the fee structure appearing in the subclause 6 of the report until further orders. So, my lord, the report which was prepared and submitted before this honorable court, including the minutes of the meeting, the decision, it was placed before the court, and, my lord, that was accepted by the court.
So today,
it is not the case.
Leave aside the Banerjee.
Yes.
Today, the valuation report has been filing here, and you are releasing in terms of this.
Yes, I have not paid any amount. I have not.
2-3 orders I find the valuation report has been, you have realized the amount from the company, but not in terms of this order.
No, after realization of
this has been revived.
No, my lord, my respectful submission, because my instruction is that in view of this, my lord, the report which was accepted by this honorable court, each and every case, my lord, the official liquidator used to pay, or, my lord, bound to pay the amount after the, my lord, the consideration of sale is being received. And, my lord, the invitation of the creditors is also being complied with.
So that's why in this case, what was the occasion to second report, and how the second report will be the decrease amount?
No,
the question is that only.
Yes, my lord, that it can be, my lord, it can both the valuers, my lord, let them both them be present before your lordship, and they said they should explain themselves, because I do not know what is the valuation of the previous also and the new also. Because your lordship has opened this valuation, accepted that valuation, and on the basis of that,
That was accepted that the earlier report was not placed before this court.
Yes. Now, my lord,
Mr. Banerjee report was not placed before this
no, my
court.
lord, earlier report is already on record before this court, not with the
You have
official
not,
liquidator.
whether have you mentioned in the report or whether it was placed before this court, because your neither your office nor my office is keeping any record intact. Today I asked the document, then it will take 6 months to search.
Because, my lord, the office,
whatever the document I am asking from the department,
right,
I will search.
My lord, original valuation report is lying before your lordships, my lord, for the acceptance.
Original is with the Banerjee. He has produced the original with him.
No, original is not. That is not the original. Original is lying with.
Where is that?
My lord, that must be with the record of.
Original है उसमें? वो तो उस दिन दिया वाला है.
No, previous report.
Banerjee का पहला report कहाँ है? So this all orders are no, because I don't. आप लोग orders को serially maintain नहीं करते. आज हम एक order किया, कल वो order कहाँ चला जाता? वो तो हमारा है. पहले का सारा, जब एक केस का सारा orders कहाँ जाता? अलमीरा खा गया चूहा.
My lord, your lordship kindly takes, my lord, paragraph 16 of the report.
Sir, आप लोग को वही वजह से होता. You are not keeping the order intact before the court. And whatever the official liquidator or the advocate selling, and it has been accepted. And now you are placed before this court with regard to this fees.
No, my lord,
but I think I have passed so many orders for release of the payment of the valuer more than this. And you have released that amount. You are not released more than this amount.
Only one case. This only one case. Corporate is only we have received.
So
only one case is saying.
One case, two case, whatever it is.
Right.
If it is your Indian knowledge, why you
absolutely correct, my lord.
And on that day when I pass the order, why you have not immediately brought this court to this order? All the thing you kept in the file or in Almira. And when the court has passed an order, you are coming with all these things now.
Kindly, my lord, comes to paragraph 16, my lord. Kindly. Your lordship kindly takes paragraph 16, my lord. May I place this, my lord? I say and submit that since the entire land of a leasehold land and application being CA number 105 of 2018 filed by the official liquidator, which was finally heard on 9th April 2021, when Honorable Court was directed the official liquidator to engage an empanel valuer for conducting a fresh valuation as to all property and assets of the company in liquidation which were available with the official liquidator to be put up for sale, and also directed the valuation exercise has to be completed within a period of 4 weeks, and liberty to official liquidator to approach this court for fixing a date of sale of the assets and property of the company in liquidation. Accordingly, the official liquidator engaged Mr. Alok Kumar Ganguly, valuer, by letter dated 23rd April 2021, with a request to evaluate the assets and properties of the company in liquidation in compliance with the Honorable Court's order dated 9th April 2021. Thereafter, Mr. Ganguly, valuer, took inspection of the movable and immovable assets lying and situated at so-and-so places, my lord. However, it may be stated that the learned valuer, due to outbreak of the second and third wave of COVID-19, could not submit his valuation report within the stipulated period for which leave was required. Then, my lord, the leave was granted, and my lord, ultimately your lordships was pleased to fix the matter for sale. Sale was conducted. Next paragraph, and my lord, the auction was held, and my lord, the two bids. One bid was, my lord, the highest bid, and my lord, the second bid, they are making they have made an application for fresh sale to accept their sale.
Well, may I just say one thing, my lord? My lord, there appears to be a lot of discrepancy in the report. My lord, kindly, my lord, there's a registered company court, who has all the records. My lord, kindly direct the registered company court to produce the record relating to the present company petition. When the company petition is admitted in winding up, the main CP, well, that file will be with the company registrar. So if that
here, nobody.
Usually the company registrar keeps all the records. They possibly do not send the entire records to the court. Only the possibly the applications which are on board, only those records are fine. Your lordship can direct or keep it anyway after 1 week after the vacation or the first Thursday after the.
Supposed to do, Mr. Both subject to the liquidator. There are two reports before.
Correct.
Okay, I don't know
Could
whether
be more.
So that's what I'm saying. Your lordship direct the registrar
And
company.
there are two valuer, and there are so many differences on the value.
Absolutely.
It is not the one or two. There are so many differences. What I propose that both the valuers have been appointed and compare with all this and file a fresh report. Nothing.
Very, very. And my lord, then both two reports, they have to be circulated to either of the, because both each other, and they should compare and say
compare and
correct.
inspect
Absolutely.
the premises first and to file a fresh report jointly.
Right. Absolutely.
Very well, my lord. No problem, my lord. I have no problem.
A little bit. That day when the submission was made with the landed advocate, he emphatically told it that the theft was occurred afterwards.
That's why I have taken note
But
of it.
it was occurred before my visit.
I already taken note of it.
There is a lot of
So, Mr. Banerjee,
I do not know how his
have you
interest
any
is being
difficulties?
prejudiced.
If you and Mr. Ganguly will be appointed as joint valuer, and your valuation report, Mr. Ganguly valuation, both sit together, compare it, again visit the premises in
Right,
question, and prepare a final report before this court with after puja vacation, then you file this. If you have no difficulty.
No, difficulty is, I can come every day, but who will just bear my appearance fee?
So now that has come before this court. I have no knowledge. Now it has come. What is the appearance fee here? Then it will be PO. You signed this. You know about this.
Inspection correct.
2013 you signed that.
No, it can be done. It has got a industrial town. It is,
Yes.
and moreover, it has got a 21,000 for
My lord,
243.
it can be done, or your lordships can also take the highest, my lord, the bid. That
No,
was the
that's-
reserve price. That may be the reserve
How
price.
is he concerned about highest bid? How do you know there will be not higher bid?
So that's
Very
why
well, my lord. No
let the
problem.
new report will come. Whatever it may, both sit together.
Right. Let them
First,
join.
first both calculate
Correct.
their
Absolutely.
own report. Then when
That
go
will be
to
the very fair approach.
go to the
Correct. Right.
Sale will not be
They'll not will take.
No.
it.
So then in that case, my lord, I will have the liberty of, my lord, encashing my demand draft and keeping it in a separate account.
May I indicate only one thing, ma'am? It is a request.
Or without
whatever.
prejudice, let it be taken by the official liquidator and he will.
I will object.
No. May I indicate only one thing? Let both the amount be kept with interest bearing known in account with the bank, with the secured credit to me.
Yes. I
So
think
that
that
can
is better, my
so
lord.
that can see
The bank will
Because
get
it
the
will better-
interest.
so that Malakali.
Here also you have come with a business mind.
Now kindly
They
see
do not
page
accept
6.
it,
My
then I will
views
get it
are.
back with interest. I will also get it back with interest.
I'm not saying
No,
anything.
already his amount has been invested in the amount. You do whatever it is.
My amount has been invested. It is there. I am not saying anything. They want to
Their amount has
But
been
come on the
invested in the
basically
interest-bearing. You
level
invest-
playing field.
Then my lordship will give that liberty because I have already annexed
Very
the
well.
demand draft in my
Okay,
application.
then we'll give it. Yes, any further?
No, my lord. That's
Because why you
my
are
lord,
selling now? Because
Correct.
if it is
Yes,
small amount, then
absolutely
the court
correct.
could have been accept this.
Right.
Absolutely.
But there is a big difference.
Difference, right.
Big difference.
5 crores and my lord, the
In the
12
amount, the tender amount is coming
Right.
something else. So if it is coming, if it is found that what they have quoted, then this the valuation is more high, then it has to be see what is to be done.
Correct.
My lord, let it be done, my lord, at the cost of the bank, my lord, because we do not have any funds. They are the secured creditors.
Now here,
Eventually, it will be the bank who will get all the money.
if I am having this determination in my tenure, I will dispose of this.
Right, very well.
that I can give the assurance.
My lord.
Well, with consent, your lordship can mark it as a part-heard matter. Yeah, your lordship can. So your lordship has substantially heard the matter.
But only one line that we have complied the order.
You have received the amount? Okay, thank you.
Grateful.
The-
May I take your lordship's kindly?
In terms of the order passed by this court dated 10th of September 2025, the official liquidator has filed the report disclosing several documents. Full stop. The learned counsel appearing for the Punjab National Bank submit that.
मैं सर श्री करनी डेवलपर से इसमें H2 पोजीशन पे हूँ तो मेरा EMD अमाउंट भी ब्लॉक है इसके अंदर तो काइंडली वो रिलीज कर सकते हैं
अब कौन है?
मैं श्री करनी डेवलपर H2 हूँ
second
bidder
auction purchase bidder.
That's why your amount has been invested in the. If you want to take back, I will allow, no problem.
take back
You want to
asking
take
for,
back?
taking back.
You want to take back?
Yes.
Okay. Take back. क्या बोला? Bank submit that. In terms of the order dated 10th September 2025, the bank has paid the remuneration of the valuer, namely Shama Banerjee, to the tune of rupees 2,19,569. The Mr. Banerjee has also agreed that he has received the said amount. Considering the report submitted by the official liquidator, consider the report submitted by the official liquidator and or the valuation report and the valuation report of दोनों report दीजिए गांगुली का और उसका.
But Mr. Banerjee's valuation is 2024. Huh? Hey, 2014. Sorry.
Of Mr. Sama Banerjee, dated. What is the date of your report, sir?
2015.
2015.
24th April 2015.
Dated 24/4/2015, wherein as per the said report, the total value of the asset is rupees 12,67,03,510, and as per the valuation report of Mr. Ashok Kumar Ganguly,
Alok Kumar Ganguly.
The value of the asset is rupees 5,74,31,247. 5,74,31,247. Full stop. Considering both the report, this court find that there are much difference between two reports, two valuation report, and as such, this court is of the view that both the valuer shall sit together and to consider their own report and also to visit the property in question and to file a fresh joint valuation report.
Yes.
Fresh joint valuation report on 19th November. It will be done 19th November
19.
or 26th November.
I think in between the intervening period, I think so. I will just go out of station. So if you just keep it on the December, I think it will be better.
My lord, may I only submit, my lord, when the valuation will be done by both the bank's representatives should be present, my lord, in presence of the banks.
Where you are going?
Bangladesh.
Abroad?
Bangladesh.
That is also abroad. So when you will be returning? When you are going?
I have to take the visa. So
Okay, I am fixing on 3rd December.
I think if your lordship declares, I can do it. I will postpone this one.
26 November you file. 26 November. Okay. What you are telling?
In presence of the, my lord, the secured creditor. Valuation should be done.
If both the valuers are directed to inspect the premises in presence of the representative of the official liquidator as well as the bank.
Secured, my lord.
Secured creditor.
My lord, with intimation.
Secured creditor. In presence of the automatically.
No, they will intimate that
the valuers are directed to inform the date of inspection of the property in question to the bank as well as to the secured creditor as well as the official liquidator in advance.
Only one request. Who will provide the fund? Who will provide the fund for going?
That will see. Let the report come. I will decide. Once you have been appointed by the court, then the court will decide. The applicant as well as the bidder. Or at the
Highest bidder.
You have submitted how much amount?
Only the H2 bidder, not the H1 bidder.
H1 bidder.
No, H1 bidder is not taking the amount back. It's
Okay.
the H2 bidder who has come to take back this.
तो H2 का तो वापस कर दो. The
Your
amount
Lordship,
of
can leave to the official liquidator to
the
refund.
official liquidator is given liberty. He is given liberty to release the amount of H2 bidder, namely
Sri Karni Developers.
C. Karni. Give the name. Karni Developers. Within a week. Within a week you will do.
My lord, not within a week. My lord, the puja vacation will start, my lord, from.
You are, what is the puja vacation? Is the office work?
No.
The bank will be closed.
Bank will be closed.
Bank will close.
Yes.
Puja.
4 days only.
Within 3 weeks from date. Within 3 weeks from date. The applicant is liberty to invest his amount in the fixed deposit, and at the time of hearing of the case, as and when required, the applicant is liberty to place the same before the court.
This fixed deposit with the secured creditor here. And only one request may I have, 26th November at 2 p.m. if possible. 2 p.m.
At 2 p.m. always.
2 p.m. 26 2
কোথাও রাখবে একই কথা I want to say back
appear on 26 November at 2 p.m. The official liquidator is directed to take appropriate steps to inform the valuer for compliance. Official liquidator is directed to inform the order to the valuer for compliance.
It is fixed.
Yes.
5 and 6, my lord. 6 to 3 সময় না?
5,
4 and 5 both fixed at 3
4,
p.m.
5, 6.
Yes, my lord. 3 p.m. fixed.
3 p.m. है ना?
Yes, my lord.
But next bolo 3 p.m.
My lord, my
Call the 6.
4 and 5, sorry. 4 and 5.
my lord, my 10F appeal, my lord.
Ah.
My lord kindly takes your lordship's order of my lord August 2025, my lord. My lord, direction was given for inspection, my lord, only in respect of ACO 6, my lord. There are 5 other applications, my lord. I am seeking, my lord, for convenience sake, my lord, an inspection be given, my lord, for all the interlocutory applications connected to the 10F appeal, my lord. And my lord, leave for reconstructing the affidavit in reply to ACO 6, my lord, which is not there in this court's record, my lord, because we had taken inspection and we discovered that affidavit reply is not there.
Inspection, my lord, I have nothing to say.
Reconstruction.
Reconstruction.
And my lord, subject to what Mr. Mitra says, my lord, if the matter could be kept 4 weeks, my lord, after the vacation, we'll come back, my lord, with the convenience index, my lord, of all the relevant documents, my lord. We'll exchange, my lord, before that.
Before that, my lord, may I submit this? My lord, lordship will kindly keep it sometimes after vacation, because after the papers are, my lord, really, my lord, rearranged, or then, my lord, we shall again pray for, my lord, supplying copies of the
Very well, my
papers to
lord. Very
us,
well.
So what I supposed to do, I will allow only to inspect, and I am fixing up to on 12th of November. To appraise before this, what the documents are not available and what are the documents are available with you. Then you submit this, and I will direct to taking the documents from the parties to reconstruct the project.
Very well.
That will be better.
Very well.
Because otherwise it will be confusion in the department in
My
document.
lord, we have taken inspection of ACO 6, my lord. That is
Only
for
2 you want, na?
only, my lord, 1 to 5, my lord.
1 to
Kindly
5.
respond.
ACO number 1 to 5.
ACO 1 to 5.
The counsel for the applicant.
Applicant, my lord.
Applicant. Submit that in terms of the order dated 2nd August 20th August 2025. The applicants have completed the inspection of record of ACO 6 of 2021.
Madam, led by Mr. Mitra.
2021, and press for leave to inspect the record of ACO number 1 to ACO number 5. In view of these, liberty to inspect the record of ACO number 1 to 5 within 2 weeks after puja vacation. Within 2 weeks after puja vacation, list the matter on 19th of November 2025. It is made the parties are at liberty to appraise the suit if what are the documents are not available in the record, so that the order this court can pass order for reconstruction of the record.
I'm deeply obliged. Grateful. Grateful.
Matter appear on 19th November 2020.
I'm deeply obliged. Grateful.
Next.
I am not the official liquidator.
Lordship,
Last
this is my
time-
application for disbursal, Lordship.
Last
Lordship,
occasion, direction has given to file a report.
Union Bank of India.
Lordship, my claim has been admitted for 4 crores 25 lakhs. Lordship desires to know how this amount has been achieved.
And my lord, affidavit already filed. Serve the copy in respect of the bank is concerned. Bank affidavit. In the report, my lord, directly, my lord, come to page 25.
26.
24, 24. 25. 25 and 26. And that is handwritten, my lord. And typed copy has been placed in the last. That would be better for my lord. Typed copy. At page 28 and 29. Typed copy page 28 and 29. Principal amount, then exchange rates, 8% interest as per the court order. The principal has come, my lord, 4, 14, 91, 450 and 10 lakhs 27, 6 for the interest. Page 28 and 29, my lord. Typed copy.
Principal as on 79,
Yes.
77, 7,007.
Yes.
1 lakh 70,000 USD.
USD. And my lord, interest as per the court order.
Exchange.
Have not changed.
Huh?
Interest, rate of interest admissible as per the honorable court order dated such and such.
8%.
8%. Have not changed.
The
Then
total
my
admitted claim is
principal is 4,4,149
crore 25 lakh 19,091.
and interest 10.
Interest to
Then
27 lakh.
Then 425. And 27 I have rejected.
So
Next
I have
page, 29.
If approved, that the following may be sanctioned in respect of the so trading.
Yes.
Claim admitted 4 crore 25. And interest
19,091 and rejected is, my lord.
What rejected?
Claim in respect of a high
Rejected of the high interest of 24 and calculate the interest INR exchange rate 18%.
18%. Hey, I
So total, what is the total amount?
total my lord, 4 crores 25 lakhs 19,091.
That's all.
Lordship.
Okay. Then
Other is they have not prepared any appeal.
so what is the amount is pending?
Lordship,
Here-
okay, liquidated have more than 1
Liquid-
crore 67 lakhs at his offer.
That I have another report I have filed before that with the FD number my lord asked. That is with my lord report. Report filed my lord earlier dated affirmed on 20th August 2025.
देखो दूसरा report है क्या?
Page 4 my lord asked last two occasion
Particulars of the
particular
FD.
TDS number and FDN number that I have given at page number 4 annexure E.
FD 1 crore 68.
Yes.
Lordship.
These are the amount pending.
Yes.
This 168 is pending.
Pending now is with us.
That's why
Lordship.
with you.
Yes.
1 crore. Now, what is the second? Closing balance is 1 crore 69.
69. Money current amount is 99 lakhs 208.29.
Where?
The total is this.
No, this is the FDR.
FDR.
FDR is 1 crore 68 68 lakh 35,700. And another one?
99 is my lord, the lying in the current account.
Achha, 99,200
Current
99,208 lying in the current account. So these are the amount. So what we will do?
Lordship, for dispersal of the entire FD amount.
You will not claim further amount.
Lordship, claim further assets are there not to be
Another amount is my lord,
pending with the
adjudication
bank.
has to be before lordship.
That
Bank,
adjudication has to be done.
that is separate. My lord, upon complete the adjudication, if any, then
Lordship, then again further application will come for further. This application will suffice with the dispersal of this amount.
What are the document you have filed?
Lordship, in my application, Lordship, annex page 8, Lordship, the
No, report. What are the report document you have you have consider? How you came to the 425? What are the document you relied upon? 4 crore 25 lakh?
My lord, that is at come to page number 18 onward, 18 onward. Anurag Bagadia, my lord, they has issued letter to the official with the documents we referred. Then the bank's document 19, 20, 21, then 22. We have details in hand. We have came to the office, we verify the documents. After verification, some amount has been admitted, some rejected.
Only
But
interest part has been rejected,
they
Lordship.
have not preferred in appeal within
Lordship.
21 days in terms of the quota. So
No, he is accepting.
Lordship.
then I'm not interested.
My Lordship, these are the details of the swift transfer that has been made to the company.
So what is your prayer now?
Lordship, for disbursal of the amount, Lordship, in my application, Lordship.
Where is the judges?
Judges summon.
Appropriate order be passed against the official direct.
Lordship, prayer B, Lordship, in the judges.
Appropriate order is passed against the officer liquid directing and forthwith disburse the adjudicated and admitted claim of your petition from the liquidation proceeding in line with them. Yes, record an order. The applicant you are the creditor company.
Lordship, I am the creditor, Lordship.
You are the creditor.
Yes.
The applicant is a creditor. Applicant namely Sonasa Trading Company LLC,
Lordship.
being the creditor, has filed the present application being CA 26 of 2024, praying for a direction upon the official liquidator for disbursal of the admitted claim of the petitioner from the liquidation proceeds laying with the official liquidated proceeds, okay, lying with the official liquidator. By an order dated 3rd September 2025, this court directed the official liquidator to submit a supplementary report disclosing the details of the admitted claim of the applicant. In compliance of the order passed by this court, the official liquidator has submitted the report. Wherein it reveals that on receipt of the claim of the petitioner, the official liquidator has called for the records of the documents from the petitioner, and the petitioner has disclosed the documents of his claim, and after considering the document, the official liquidator has come to the conclusion that the applicant, the claim of the applicant and the admitted claim of the official liquidator admitted the claim of the petitioner to the tune of rupees 4,52,
25. 425.
425.
Page 29. And B, annexure B of their petition. This is our document.
4,25, 19, 091.
Lordship.
Yes.
091 and had rejected the interest claimed by the petitioner.
Enhanced
interest at the rate of 24%.
Lordship.
24% is rejected by the official liquidator. Okay? The official liquidator has also submitted the report disclosing the details of the account, disclosing the amount lying with the official liquidator. It is found that one fixed deposit is lying in the scheduled bank, namely which bank?
Scheduled bank. Annex the document.
Scheduled bank, which bank? Scheduled bank?
Name of the bank, SBI, Brabant Road, Canada
Federal
Bank,
Bank, namely
Brabant.
SBI. One mat karo. So these are the
Name of the-
different FDs are there.
Yes.
क्या
The
बोला?
different FD number and amount. Page 4 of my report.
That 1, 2, 3, 4. That an amount of rupees 1,68,35,700 is lying in the fixed deposits of different banks and an amount of rupees 99,208.29 is lying in the current account. The petitioner submit that though the claim of the petitioner is 4 crore 25, the admitted and the 4, 25, 19, 091. But at present the official liquidator is only having the amount of rupees 1,68, 35, 700 and rupees 99,208.29 in the current account. According the counsel for the petitioner that he will be satisfied that for the present the said amount may be released in favor of the petitioner. Learned counsel for the official liquidator submit that the claim of the petitioner has been adjudicated by the official liquidator when
Lordship, page 8 of my application, Lordship.
When it was adjudicated.
Notice was given to them, Annexure B
Lordship,
of their petition.
6 August 2019 late.
6 August 2019. 6 August 2019. And the petitioner has not preferred any appeal. Thus, he submit that the applicant has
Rule 17.
Applicant has admitted the adjudication made by the official liquidator for a total sum of rupees 4, 25,
19,
091. Learned counsel for the petitioner further submit that he has agreed with the adjudication made by the official liquidator for the aforesaid amount. In view of the above, the official liquidator is directed to disburse the amount of rupees 1,68,
357.
68, 35, 700 as well as rupees 99,208.929 in favor of the petitioner after proper identification and receipt acknowledgement within a period of 4 weeks from the date of receipt of this order. CA number 7676.
Only one more. Allow us to premature in case of the FD. Given the amount pursuant to the order.
Yes.
Some amount be lying with us for liquidation process. What we have 1,69,000.
Lordship, there are other assets also, Lordship.
That I have not collected from the bank.
Huh?
Some amount lying with us.
Because for liquidation purpose.
So let this current account be continuous. Current
Lordship.
release बोला है ना? Release the amount of rupees 1,68,35,700. Not 39 mat karna. The amount lying in the current account, the amount of rupees 99,208.29, which is lying in the current account, be remain with the official liquidator.
Lordship.
Be remain with the official liquidator.
And matter will be fixed after vacation.
CA number 26 of 2024 is disposed of. Let the matter appear. 4 weeks, na? Let the matter appear before this court on 26th of November 2024 for filing report by the official.
No, report not. Where the bank has lying a crore of goods with them. We requested by them by letter. They said, no, I am not entitled.
Okay, you file the report.
It has been filed.
Where is that?
Is I have just filed. They reply not been filed. Don't know. That matter can be fixed any other day. We have filed.
Today, yesterday, I have received a copy of the affidavit in office.
Okay, that what is the CA number?
See, in connection with 26.
In my C only
Dispose mat karo.
Lordship.
Dispose mat karo. Let the matter appear on 26th of November 20.
Extension to file my affidavit in this matter, Lordship.
The
This is fourth prime extension.
the petition is granted with time to file affidavit in opposition within 2 weeks after puja vacation, after serving the copy.
One copy be given to me.
Official liquidator. Official liquidator and you are appearing for
the Union Bank of India.
as well as
Neither secured creditor, nothing.
and for the Union Bank of India.
Lordship, one request also. Kindly direct him to
Give
provide
it
the
for
account
copy.
number.
Yes, yes.
Lordship, we can
Yeah,
that will be
a reply if any there to be filed within a week. List the matter on 26. The उससे ऊपर में जब उससे ऊपर the petition open, the petition is directed to supply the account number of the petitioner for disbursal of the amount as directed.
Grateful.
क्या बोले, supply the account number to the official liquidator for
But
disbursal of the amount.
Your Lordship's last order, my lord, my name was recorded as official liquidator and my learned friend's name was not there.
Give. Correct करो. So देख लेना, नाम देख लेना. He is appearing for the official liquidator.
Official council appear, but Ronjit Chaudhary well.
Okay. Next.
Grateful.
4 and 5, CPL matter, Harmony project.
Me, please, minutes. I was to rejoin. Because I'll keep it very short and I don't want to repeat my arguments. Let's
Only question how you are claiming.
How am I claiming right? Yes, that's it.
That is the only
That's
question.
it. So, my lord, just wanted to three admitted facts. Admittedly, I am in possession of this particular property where my registered office is, which is why an application is made by my learned friends asking to take possession back.
This is not an admitted fact. My lord, I'm just
And then why the application?
because I'll tell you, my lord, the admitted.
She has made a submission on that day.
Yes.
My lord,
I have noted down.
My lord, my state, my lord, I'm just, I don't.
That master
intend
data
to-
does not indicate.
No, it is not about the master data also. My lord, I don't intend to interrupt my learned friend. But my lord, my main contention over here is that this cannot be the case that the possession is with him, because when I went to him saying that where is the possession and the whereabouts of the property, he said that there is nothing with me. Please go and approach the official liquidator. And when I
Correct.
went and approached the official liquidator, he told this honorable court that it is mistakenly I have taken symbolic possession of that property. It should not remain with me. I am ready and willing to hand over the property to me.
Correct.
So it is not an admitted fact that the
Ajay,
possession.
very well. I'll take back the word admitted. Let us assume two things now. Because the registered office of the corporate debtor of this particular company is located at the place where, which my learned friend has filed an application that she wants to take possession of. Admittedly, by way of a deed of conveyance, they are saying this. I am sure it's admitted. Deed of conveyance, they are saying that this property was conveyed by the company to Reliance. Admittedly, and I'll show why. These two dates are very important. The winding up order is dated, the admission order is dated 1st December 2017. Provisional liquidator is appointed on 7th September 2018. So, in law, under the Erstwhile Companies Act, the provisional liquidator will be in control and custody of all the assets, properties, statutory records, etc. Now, your lordship knows under the Companies Act, and it's very fundamental, which is why the list lies against any list against the company lies where the registered office of the company is usually situated. Now, and I say this with some sort of the registered office of this company is at the premise, at the address that is being mentioned, which my learned friend wants to take possession of. I get appointed, I'm as in the resolution professional, get appointed by the National Company Law Tribunal on 13/3/2019. Right? The fact that Reliance is aware that the CIRP is continuing and CIRP is going on and that the RP will hand over the assets in law, because that's the correct understanding, is evident from the fact, please takes up page 191, volume 2
of my application, that is CA 83. CA 83 volume 2.
CA 83?
Yes, Malad.
Page?
191, running page, Malad, handwritten page 19. It will be 191 or 215. Just say it's written 191.
Yes.
Annexure J, Malad. It's a letter from Reliance Capital dated 18th April 2024. Then, Malad, it will be 215. It will be 215, Malad. On the top, pagination perhaps is on the top.
Yes.
Lordship says Reliance Capital, letter dated 18th April 2024.
Yes.
Kindly sees to Mr. Ajay Agarwal, Resolution Professional, Avni Projects and Infrastructure, Kolkata so-and-so. Kindly see it's the subject. Request for handover of possession of RCL premises situated in building known as Avni Heights, lying so-and-so, 59H Orangiro district. Which is why I, with some sort of conviction, I said admitted fact, because she's handing over, asking for possession from me. So I was in possession. Now the dispute is here. Your Lordship knows under section 19, I'm sorry, under the Insolvency and Bankruptcy Code, plus when I am appointed, if your Lordship has the IB Insolvency and Bankruptcy Code with your Lordships, Lordships would see what are the duties of an insolvency resolution professional. That is given, under section 18 first. I'm sorry, section 17 first. Kindly see section 17.
Yes.
Let's kindly see management of the affairs of the corporate debtor 17.1 shall vest in the interim resolution professional. Powers of the board of directors so and so, so and so. Now kindly see C and D are very important. Officers and managers of the corporate debtor shall report to the interim and provide access to the documents and records of the corporate debtor as may be required. The financial institutions maintaining accounts of the corporate debtor shall, on the instructions of the interim resolution professional in relation to such accounts, furnish all information to the corporate debtor. Now, would your Lordship sees then interim vested with the management shall, then the other powers are given, have the authority, kindly sees D, 2D. Have the authority to access the books of accounts, records, and other relevant documents of the corporate debtor available with the government auditors, statutory auditors, accountants, as such persons other may be. Now, your Lordship knows statutory records are maintained within the registered office, share registers, all the documents are maintained in the registered office, which is at this particular premises. Now, kindly says 18. 18 is the same thing, Malod's duties of the interim resolution professional. And Malod's, would your Lordship sees 18 gives the power. So on the basis of 18, I write immediately, Malaz, as soon as I'm appointed, to the official liquidator, that please give me access to the, Malaz, the registered office of the company, which you say that you are in possession thereof. Now in law, they have to, Malaz, since before my appointment, they were in official custody of that. Well, the shocking part here is, and this is where the seriousness of the matter comes. Please see, Malaz, page 292 of volume 2 of the same application. When I write to him and he acknowledges that to the official liquidator, please see what he's writing. He's saying that I do not have, I have 292.
Yes.
Your Lordship, this is a letter written by the official liquidator, dated 24th July 2024.
Yes.
Kindly says who's it been addressed to? To Mr. Bhaskar Biswas, ex-director, Avni Projects in provisional liquidation. Now, kindly see, sir, with reference to the continuous pursuit, request of Mr. Ajay Kumar Agarwal, the insolvency professional of the company, which is me, regarding fixing the date of visit and inspection of the registered office of the said company, I am directed to inform you to provide us the keys of the lock on of the registered office, as they are in custody of the ex-management of the company. But how can in law that happen? It's a serious lapse on the part of the official liquidator then. And most importantly, an inspection of the registered office was conducted by Mr. Agarwal in December 2019. in presence of the official of this office and after locking the premises of the said company, the keys of the lock were handed over to Mr. Kaushik Shah, caretaker peon of the company, present at that time, and also his signature is recorded in the minutes. You are requested to cooperate in the inspection by providing us the keys of the lock of the said company within so and so to this office. Now, my lord, what I'll tell you, Lordship, so in effect, and there is another letter which says the official liquidator in symbolic possession, although the keys ideally should be with the official liquidator. Now, under section 19, your Lordship would see of the IBC, I have filed an application before the National Company Law Tribunal against the official liquidator that I am asking you, you are not giving me, well, because all the statutory records and all are there in the registered office. So, my lord, when I am asking, my lord, I'll show your Lordship's orders passed therein. My lord, repeatedly orders have been passed. My lord, I'll just hand up a copy of these orders. I don't know, 2nd September. Repeatedly, my lord, your Lordship sees IA 599 on the 2nd page. Notice was directed to be served upon the respondent by speed post. However, no notice has not been served. Registry is hereby directed to serve notice up by respondent so and so. List the matter for 15/9/2025. Now, this 2nd September 2025, would your Lordship says this is an IA of 599. They are not appearing there. They are not giving me the records. Now, my lord, how did I come to know about this order is being passed? Now, I came for recalling immediately. Well, that's why I say but that there is a jurisdictional bar. Would your Lordship once just from I have placed this that on last day, Malad, sorry, Malad, I was appearing virtually. Kindly come to section 14. Here it does not matter, Malad. So what I showed to your Lordship is my learned friend Miss Dalmia's client is aware of that CRP is going on. She is requesting to hand over possession from me. So, Malad, whatever symbolic possession through the official liquidator and all, the CD, the registered office is there. Now, please see 14. Subject to the provisions of subsection 2 and 3, on the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following, namely, Malaj kindly says institution of suits or continuation. Malaj, I'll argue because that's a point, Malaj, to be argued regarding the transfer of the proceedings. But Malaj, would Lordship says D. This is very important. Recovery of any property by an owner or lessor where such property is occupied by or in possession of the corporate debtor. So, Malad, let us understand one thing. 2015, my learned friend says deed of conveyance has been executed. My learned friends have approached your Lordship's court in 2024 after a hiatus of 8 years. Justification my learned friend has provided is between 2021, her clients was undergoing insolvency and a new management took over. But Malaj, one document has not been produced by your Lordships that what happened between 2015 to 2024. The reason is, Malaj, there was an understanding between the corporate debtor and the Reliance Capital that yes, you will be entitled to use this particular premises, for which, Malad, I said the statutory records, everything is maintained there, the registered office is maintained there. Because, Malad, your Lordship, my learned friend has to justify this, that if my registered office was, Malad, and she is aware, I am showing in the letter itself, that's why. The subject of the letter is request for possession of so-and-so specific details of the property. So, Malad, today to come back and say, I am arguing on a point that there is a jurisdictional bar. Why jurisdictional bar, Malad? Firstly, that today, Malaj, my first prayer is, and I've shown your Lordship the catena of decisions now, after action, Ishpat, Navin Chandra Steel, consistent judgments. In fact, Delhi High Court says, suo moto, your Lordships can transfer the matter to NCLT right now. First thing first is that, Malaj, my learned friend ought to have approached the National Company Law Tribunal. That's number one. For these reliefs, number one. Number two, Malad, today my learned friend's application, which is Malad CA 82 of 2023, CA 82 of 2023 is hit by the section 14(1)(d) of IBC. Because, Malad, let us understand, she is the owner. Admitted fact, not a problem. She has allowed me to be used under an agreement, a usage agreement, rental agreement, lease agreement, whatever be the terminology. 14(1)(d) says that today, if the corporate debtor, as I said, the official liquidator will take that stand. Now, official liquidator in the letter says, keys are with the suspended board of management of the corporate debtor, which should not have happened. Your lordships will ask questions to the official liquidator. How could you do that? Because when I am writing to him, because well, please appreciate, without access to the registered office of this company, any in an IRP who is required to do XYZ things, Malaj, under the provisions of the code, will not be able to, Malaj, perform its duties as well as stated in Malaj in the statute. So today, what I am saying is, number one, my prayers are twofold. I have given a compilation of judgments.
Judge's summons. Or 82 though.
Because, Malad,
so your main is a transfer.
Transfer. Number one, suo motu transfer, Malad. Your lordships can. Now, the biggest hurdle, Malad, your lordships will remember, as it's been a while that I've argued this before the summer vacation. Malad, your lordships would remember there was a confusion that because there's an order in this matter by my Lord Justice Mukherjee, my Lord Justice Mukherjee, which said that
continue with it.
If any resolution plan happens, then yes. But if the company goes into liquidation, then these proceedings will continue. Here. Now, Malad, that Malad I showed to your lordship is something, a position before Naveen Chandra Steel Action Ishpat came in. Because Malad, today, and I as an officer of your lordship's court, or anybody, can I today, if my learned friend's case is subsequently matter came up, RP did not raise any objection, so I may stopped. Well, today, greatest of respect, I cannot submit to a jurisdiction of a court if unless under law the court does not retain jurisdiction. I cannot by my consent or by waiver, let's take away jurisdiction of the court or confer jurisdiction on a court. So, Malad, today, and that also, Malad, I showed to your lordships, Malad, I think the decision was to compilation. Malad, I think 2013 10 SCC 136 I had relied upon that jurisdiction cannot be conferred by consent, waiver, or acquiescence. I think, Malad, that was Malad 2013 10 SCC 136 Jagmeet Singh Bhagat, Malad. It was Malad Justice Chauhan's and Justice Bobde's judgment.
2013 10.
Yes, 2013 10 SCC 136.
Yes.
Para 9. Perhaps your lordships have already marked it that day.
Yes.
Para 9. Kindly say jurisdiction cannot be conferred by consent, waiver, or acquiescence.
That's good. That is almost.
So today, so the point that my learned friend is saying that matter has come up before your lordship's court, before this company court. I have not raised any objection. The counsels who was appearing before has not raised any objection. Suddenly we are raising all these objections. Today, Malaj, let us assume very well they did not take that objection. It's a case, then they are arguing a case of a waiver or an acquiescence. Today, Malaj, what I'm trying to show to your lordships is today I cannot, it's a very settled principle of law. So today, Malaj, your lordships, Malaj, would only just see, Malaj, I have shown to your lordships subsequent recent Calcutta High Court order of my Lord Justice Kapoor. Malaj, it's also Malaj 2022 SCC Online 1409. That's Malaj Maheshwari Ishpat. In fact, your lordships have relied upon that order, Malaj. I've seen that subsequent orders. My 2022 SCC Online Calcutta 1409. I have shown, I've given my learned friends copies also before that. 2022.
खोला क्यों? चल गया कैसा? Yes, Ispat.
Yes.
Which one? Sponge?
Maheshwari, yes, Maheshwari Ishpat Limited versus Alakananda Sponge Private Limited. Or would your lordship just note down, Malaj, I'm not repeating because
that you have given that.
Yes, correct, Malaj. 4, 5, 6, 8, 9.
8 and 9.
Because in our matter, Malaj, there is also a Justice Kapoor's order. Same thing, Malaj, because they are saying that Justice Mukherjee has passed this order. So again, I am saying, Malaj, today the position of law as settled by the Supreme Court is because there is a resolution plan which is at a very advanced stage. But your lordship knows now in cases of insolvency and bankruptcy court, when it comes to a real estate company, plans are given on the basis of project wise. Here's a company who took hundreds and hundreds of crores from several home buyers and suspended board took away, and there was nothing that was left. Home buyers have come in and have given a resolution plan in which now home buyers are saying that we will pump in money and construct and develop the projects. In fact, my learned friends' clients, Reliance Capital, who is now been taken over by Autumn, has filed a claim in the same insolvency proceedings.
With regard to
this company.
My lord, I am not Autumn.
Mr.
And
Reliance Capital.
I am Reliance Capital. I am not Autumn. And the second thing is that, my lord,
Autumn
all
has
these
taken over
submissions
Reliance
which is
Capital.
coming up.
So, my lord, Autumn has taken over Reliance Capital. It's the key naam, bolo. Bolo? Huh? In the sense for what? Reliance Capital has been taken over by Autumn, right? By in the sense. Very well. Demerger, right? Well, ultimately, Autumn just. Very well, Malad. I'm not. Okay, I can show your lordship's orders passed against Reliance Capital by NCLT in this matter. And I'll show your lordship's claim form. Nevertheless, today, Malad, the question is this. Malad, I asked myself, and as I was saying, it's very awkward on the part of a counsel to say court never has jurisdiction. My seniors used to say that never argue this point that court does not have jurisdiction before the court. But today, Malad, unfortunately, with the law laid down by the Supreme Court now, and clarified by subsequent high courts. In fact, the Delhi High Court has gone one step ahead and said that suo motu it can be transferred. No need requirement of an application. So two things, Malad. Admittedly, I am showing that from my learned friend's letter, she is asking for possession from me. I am in possession of the registered office through the official liquidator, symbolic possession, whatever it is. The question is whether under the fiction of 14(1)(d), when the fiction of 14(1)(d), because 14(1)(d) prohibits, she has to wait till the outcome of the CIRP process. Today, Malad, she cannot bypass, because otherwise, Malad, the entire, and Malad, if my learned friend today comes and argues this proposition, that today it's also settled now, Malad, that IBC 2016 overrides the provisions
What is the actual person as on date of the property?
I'll tell you, lordships, it's under lock and key. So, official liquidator have filed an application I showed to your lordships. They are yet to give me the keys. All statutory records, everything is lying there. Everything is lying there. I have taken inspection of that. Of the property. Because that is recorded. Malad, would your lordship sees, Malad, once just comes back to 292 once. I'm sorry, Malad, 292 once. 292, volume 2. I'm sorry, Malad, of C83.
Yes.
Kindly, I'm just reading this letter once again. With reference to the continuous pursued request of Mr. Ajay Agarwal, insolvency regarding fixing the date for visit and inspection of registered office of the said company, I am directed to inform you to provide us the keys of the lock of the registered office as they are under custody of the...
Who is having the key?
So official liquidator says the ex-management of the corporate data, the suspended board of directors of the corporate data have the keys, which is more shocking. How did Malad, the official liquidator, hand over the keys to the suspended board of directors? And section 19 of the code, with your lordship sees, that's why I filed a section 19.
Official liquidator has filed affidavit, no? Have you filed the affidavit to this
In 83, no.
83?
83, you have?
Filed?
I haven't.
Where is that? Affidavit of official liquidator?
না আমার কাছে নেই তোমার কাছে আছে এফিডেভিট আছে ওটা আছে
What is the stand?
আছে
Whose possession the property is?
Yes, my lord, I'm sorry. Yes, they have. But I'm sorry, my lord. Yes. Yes, my lord. Kindly sees, my lord, para 3 onwards. That by an, I'm sorry, page 3, para 3.
Yes.
Now they say by an order of 7 September 2018, while appointing official liquidator attached to this honorable court, that upon receipt of the honorable High Court order, along with the copies of all pleadings so and so, initiated belonging to measuring so and so. Now, please see, yes, this honorable court passed an order dated December 14, 2018, directing this officer to take over actual physical possession of the vacant flats with the assistance of the local police if necessary. The official liquidator at the same time also dated to remain in symbolic possession of the flats over whose possession were claimed and made over by the company. Now, these are of the flats. Then kindly see 3, possession of assets, properties of the companies in liquidation. I'm just trying to figure out where he has stated about the registered office. Yes, page 11, subpara G. Upon observing the earlier, Lordship has got it. Upon observing the earlier direction of this honorable court, dated 7 September 2018, this office was required to visit the aforementioned premises, being the registered office of the company, to ascertain the records, bank accounts as also present position of the company. Eventually, an inspection of the said office was undertaken on December 27, 2018, along with the representative of the petitioning creditor, Reliance Commercial Finance Limited. During such visit, the inventory of the statutory books of records was made as per the company so-and-so identification, and same were also retained under their safe custody. The company also made over a cash amount so-and-so, which was subsequently further a list of bank along with available details are provided to and so-and-so. Comprehensive chart, my lords, then is given. Subject to correct. Yes, I'm sorry. Yes, my lord. Would your lordship see now para 13? Acknowledgement that, my lord, I'm sorry, page 13. I'm sorry. I'm so sorry. Page 13, subpara 10.
Yes.
Well, let's kindly see the acknowledgement that Ajay Agarwal was appointed by IRP by NCLT. And page 14, that in the aftermath of the said order of learned NCLT KB as sought by the said IRP, this office duly supplied the requisite documents and extended all necessary to the said IRP to prepare the resolution plan. Meanwhile, the said IRP filed an application before High Court for directions upon the provisionally to relinquish possession of assets, properties, and the available books and records of the impute in favor of the said IRP, following the mandate of the learned Kolkata NCLT KB's order dated so and so, so and so. Now, Malad, would your lordship sees the High Court's order is given? And thereafter, Malad, that's it, Malad. And then, Malad, several plats, Malad, intending purchasers and everything is given.
What happened to this property?
We have absence of the order. We have intended to hand over the property to the applicant.
No. At present, whose possession the property is?
We are in the symbolic possession.
It is under lock and key.
Under the lock and key, as it whatever documents I have, I don't have my own.
That's the serious part, because
that is the only thing.
Because if how can they have the keys to the suspended board of management and say that in symbolic possession?
At that point of time, notional possession was taken. No physical possession was taken. So that is the reason for which the.
By which order? By which resolution? By which minutes of the meeting you have taken the possession? There might be a minutes of the meeting.
Which, Malad, is recorded at page 292. Page 292, letter kindly sees. It says that an inspection of the registered office was conducted by Mr. Agarwal in December 2019 in the presence of the officials of this office, and after locking the premises of the said company in provision, the keys of the lock were handed over to Mr. Kaushik Shah of the company in provisional liquidation, present at the time, and also his signature is recorded in our minutes drawn at the same. How could this be done? That's what my question is. But nevertheless, they say they're in symbolic possession. Well, they are in symbolic possession. If they say they're in symbolic possession, I am clearly covered by 14.1d. I am clearly covered by 14.1d. Because the records are lying there. So today, I am saying that for the moment, I am not saying that my learned friend is remediless. But the mandate is because the provisions of the code overrides the provisions of the Companies Act. Number one. It's a special statute 238, your lordships have seen. It's a non-obstante clause. Process is going on there. Because your lordship sees why, which is why your lordship sees 60 subclause 5 of the code. And this code has now gone, and Supreme Court has now gone and saying, and this is very dangerous proposition of law. Your lordship knows Anand Rao Kurada judgment. Even writ petitions can't continue. Forget something here. Even writ petitions can't continue. Relying upon the clauses which cause that civil courts does not have jurisdiction, the other courts does not have jurisdiction, because everything will go to the National Company Law Tribunal. So today to come and say, I think I actually also have handed up Anand Rao Kurada. Kindly see if your lordship has it. 2020 14 SCC 198. 2020 14 SCC 190. Lordship has it, but
no.
But it was there in that compilation 2020 14 SCC 198. That they are Lordships had marked it also. Yeah.
Yes.
Yes, Lordship has.
Anand Rao.
Anand Rao. Would your lordship is para 6 to 14? Para 6 to 14.
Yes.
Is the ratio, and para 11 is very important. In view of the provisions of IBC, the High Court ought not to have proceeded with the auction of the property of the corporate debtor. Response 1. So once proceedings under IBC has commenced and the order declaring moratorium was passed by NCLT, the High Court passed the impugned interim orders after CIRP had commenced in this case. And then para 13 is also given.
Yes.
So today, and this was in a writ petition. The scope of 226 is very wide. We used to argue that 226 will not be covered by moratorium. But Supreme Court has gone to one extent and said that even in writ petitions, you cannot do that.
Yes.
Today, so my respectful submission is twofold. That these proceedings are required to be transferred to NCLT. Number one, there cannot be two parallel proceedings that are going on. Even if now Supreme Court, yes,
What the stage before the NCLT now?
Yes. As I told your lordships, there were several projects of the corporate debtor. In respect of one of the projects, which is the premier projects of EM bypass, there's a resolution plan which is being approved in respect of that. The plan approval application is pending before the National Company Law Tribunal. The court is hearing, the tribunal is now hearing objections to the resolution plan. That's number one. As regards to another project of the corporate debtor, that's in Howrah. Another group of home buyers have come and given a resolution plan. NCLT is considering whether to extend that time to give resolution, because liquidation should be the last resort. That's it is at that stage where proceedings are pending now, where plans are put forth. The reason we wanted to perhaps get done with the flats which were there, issue the conveyance, get the conveyance done, and your lordships will appreciate the resolution program has been superly cooperative to all of them. Whosoever has given money, we have conveyed the flat to them, and that's the mandate of the law. So today it's for a purpose, and the objective of the code is to restructure, not to liquidate. So today, to list liquidation proceedings to continue, it's in teeth of the provisions of the Insolvency and Bankruptcy Code. Two parallel proceedings going on. There can't be two liquidator. So, Malad, today, on one hand, let us appreciate, I am writing to the official liquidator. Official liquidator saying this, that, okay, now not. I would have taken custody of that property. I would have done so. Okay. So, Malad, respectfully submitting, Malad, these proceedings are required to be transferred. Her application isn't it is a jurisdictional bar. It is nothing but a jurisdictional bar. Once CIRP gets over, moratorium gets over with, completed, I will have no more submissions to make. She will have to get her possession back. But now to do that, yes, now, and in fact, I have done that matter. If today I want to voluntarily say, I can leave this property, if I have the statutory records, I can leave the property. Yes, then with the permission of the committee of creditors, yes, perhaps this can be done. But today, when Malad, I require that at least during the CIRP period, she has to wait. She has to wait. Okay. So, Malad, and your Lordship just wanted to see it, para 8 of the affidavit in opposition of the official liquidator. I'm grateful to my learned friend, Mr. Avasti, Malad. That is how the official liquidator has dealt with paragraph 9 to 12 of the application. Yes. So, Malad, respectfully, those are my limited submissions to Mrs. Dalmia's this thing. I sympathize with her, of course, Malad, because it's a property. But again, from 2015 to 2024, she has allowed this particular property to be used by the corporate debt.
How?
Your letter says that. Request for possession. How? That's what I'm saying. I need not explain anything. Your letter says it. Your letter at 219 asking for possession from me. So she acknowledges that CD. But even if she writes to the, very importantly, she writes to the official liquidator. So she acknowledges, who is the official liquidator? Let us understand. Official liquidator is the custodian and guardian of the property belongs to the company. So if that means that the company is in possession through the official liquidator.
So what is the CP1 here pending?
Well, at CP that is pending now, these two applications. Well,
this is the latest one.
Latest
what
one.
Is the CP1 originally?
Well, nothing.
That was the winding up.
That was in which the winding up order has passed. Subsequently, as I said, another CIRP was initiated there in light of the judgment. All the home buyers have filed a claim there.
There were several home buyers before my lord also.
Before your lordships, because of the conveyance, which now also they agree now.
They cannot ask for both ways.
That's right. I am not asking for both ways.
My lord, if I make
They are in favor of the home buyer.
So what is the stage of the CP? What is the
They have not sold any assets.
He is pending. The official liquidator was
sold the assets?
initially official liquidator was directed to take symbolic possession. Then subsequently the official liquidator was directed to physical possession. And not physical possession was taken. I have got the report of submitted to the losses in 2022. Whose what are the properties we have taken the physical possession? That has been mentioned in those reports. But it is there and that is in consonance with the.
What about this property?
So far in respect this property is concerned, I have in my report I have said 60 Baligon Circular Road, Albany, Oxford.
No, town.
Albany Estate.
59 Chaurangi.
No. Yes, Albany Heights.
No properties were sold by the official liquidator, which is why Navin Chandra Steel irreversible stage has not come in to the winding up thing. If the properties were auctioned by the official liquidator.
How can the property be auctioned today by the official liquidator because the CIRP process
That's
is
exactly my point. So it has to go.
That's why I am
So it has to go.
If the CIRP proceeding has been made and winding up petition is pending, how this court?
Correct. So this has to go.
I'll explain my. But if my learned friend has.
Justice Arinda Mukherjee.
But if
the CIRP proceedings let it be closed.
So in that case, let it be kept pending till the CIRP is over.
That's right. But today, let us understand that's what exactly I'm saying. But the ideal thing is, as I said, when we come and try to assist your lordships, and there's a change of law, let us understand that. When Justice Mukherjee's order came in, today Navin Chandra Steel Action Ishpat, Jaipur Metals was there, but Navin Chandra Steel Action Ishpat, these are subsequent judgments. Law has evolved now. When because initially your lordships would understand there were conflict of judgments among the high courts, whether to transfer the matter there.
That is the problem now here.
Yes. So your lordships have to today, I'm saying you are independently before your lordships. Your lordships have to independently today take a call whether in light of these developments that has come up and how the law has evolved, law has been settled by the Supreme Court and the other high. Now there is no conflict. There is no conflict now. So, Mullah, today to come and say that it has to be transferred on your lordships, we are here to just to assist your lordships. But ultimately, I am conceding to the fact that here in my matter, there are two judgments which are staring at my face. But the distinction is that, and most importantly, my learned friends and Mr. Chaudhury's vehement objection, as I said, that my predecessor, I'm not naming, had not raised an objection when these applications were moved. Why it was not objection was raised? Number one was because my learned friends wanted to assist the home buyers, like we wanted to do that. Assist the home buyers for conveyance. That's number one. Because your lordships would also know, because why did that? Now the Insolvency and Bankruptcy Code says for a real estate company, how home buyers' interest will have to be protected. COC has to be convened. If they agree, conveyance executed. That's the law now. Secondly, let us understand, if I was present in instead of my predecessor.
What your predecessor? Total application?
CPCS to be transferred to NCLT. That's number one. Number two is, Malaj, I am asking for recalling of the order which was passed, which is why, Malaj, there is an interim order also I am enjoying in my favor on there. Justice Mojumdar took it up, Malaj, when I argued the point of 14.1. His lordship was pleased to, because they were handing over the possession. So at least, Malaj, till the time the resolution stage is there, the moratorium is there, Malad, this order has to be recalled. And Malad, matter has to be transferred. My learned friend has to approach the NCLT.
One thing, Malad, I'm sorry. What your lordship, see the order dated 12/12/2019 passed by the officer, but in respect of that order, I shall have to. At the end, I hold that this court.
Page number.
My lord, I'll access my lord with the page number. The order starts at page 242, volume 2.
Yeah, it's there in my compilation. I'm
And
conceding.
It has been filed by Ajay Kumar Agarwal only.
Yes,
My
I am
learned friend's
conceding.
client,
I am
not with
conceding.
me. He was there since inception.
Correct.
ICP is pending. Paragraph 22.
Page.
Page, my lord, internal page, my lord, 47.
Yes.
Well, that is page 287.
284. In your.
In my application, Malad, it will
82.
be page 61, volume 1.
My lord is seeing, if my lord is seeing from 82, then I can give the 82.
83.
8361, page 61.
Page, paragraph 22, my lord.
Page 61, volume.
Page 61?
Volume 1, Malad.
It's actually at both the places.
Yes, my lord has 683. That's what I was.
No, it's at 83 also, it's there at
Achha,
multiple places.
Internal page 47.
47 is the last one.
Yes, last one. Well, the paragraph 22. Why this CP1 is pending? Malad, kindly see at the end I hold that this court possesses the jurisdiction to hear out the winding up petition being CP number 1 of 2016 along with all connected applications. However, the winding up petition and the connected applications thereto should not be proceeded with till NCLT comes to a conclusion as to whether the resolution plan in respect of the said company is either approved or rejected. In case of approval, further orders may be passed in CP number 1 of 2016 with regard to the revival of the company. In the event the resolution plan is rejected and such rejection order achieves finality, the said winding up petition shall be proceeded by the company judge under the provisions of the Act of the 1956 and the rules framed thereunder. For further course of action as to the winding up and resolution of the company, the official liquidator appointed as provisional liquidator shall render all assistance to the IRP appointed by the NCLT by giving inspection, supplying the copies of the documents and information as may be applied. So this is the reason for which my lord CP1 is pending.
And that's my prayer. I conceded
What
to
is the date of the order?
2019.
12th December 2019. 12th December 2019.
And I'll just give the dates of
After this, there is another order
of Justice Ravi Kapoor.
of 22nd.
Well, that's, just say, my friend. Action Ishpat is of judgment dated 15/12/2020, Supreme Court first. Naveen Chandra Steel is 1st March 2021.
Yes, madam.
And my lord, Honorable Justice Ravi Kapoor's order is dated September 2022. My lord will kindly see that order.
I'm saying that I'm conceding to
My
that.
lord, I am just handing over my tab.
It's not disclosed here.
My lord,
No, no, it
that's
was
not-
disclosed.
Citation.
No, no, it was there in the copy sheet again.
अरे अभी दिया नहीं जिसमें bunch. क्या है bunch?
This is Kapoor had relied upon this is Mukherjee's order.
Mukherjee order. That Maheshwari Ispat.
No, Maheshwari Ishpat is different. Well, that's the reason. Maheshwari Ishpat, this is also Malad quite.
That is 2022.
Yes. So, Malad, this court, the reason Malad Justice Kapoor said that because Justice Mukherjee has said, and then that point of time, of course, the law was not that much settled.
It was after the order.
Very well, Malad. Malad, my only humble submission is today.
No, action Ispat is considered.
Yes.
Justice Kapoor has
Yes,
considered.
Yes, correct. Your lordships are right. Kindly says in an earlier round of litigation, second page. In an earlier round of litigation by an order dated so and so.
Correct.
And there has been no challenge to,
the said order. Correct.
And the same has attained finality. Now, my lord, that entire series of litigation was initiated by my learned friend's client, Ajay Agarwal, who is still continuing to be the RP today. So when the NCLT order was passed, commencing the CIRP proceeding, at that juncture, my lord, he had filed an application before this Honorable High Court saying that the entire proceeding should be transferred to NCLT. There were 4 issues formed. My lord will once again consider the 4 issues. My lord will kindly take up the 2012 order once. 2019 order, 12 December 2019.
Yes.
My lord will see. My lord will see the issues are indicated at internal page 31 of the order. My lord is seeing C83. If my lord is seeing volume 2.
31, yes. Page 91.
Yes, my lord. My lord will see, does this court retain jurisdiction to hear the winding up petition and the connected applications thereto? If so, what are the provisions of law applicable to adjudicate the said petition? Should the provisional liquidator be released, discharged and directed to make over possession of the properties, assets, books and accounts of the said company in his possession to the IRP appointed by NCLT? This was a question. Should further hearing of the winding up petition along with all connected applications be stayed? Should the winding up petition along with all connected applications be transferred to NCLT to be further heard by it? Does NCLT have the jurisdiction to hear out the petitions filed by the intending purchasers? Are the provisions of IBC applicable to the instant winding up petition when the same has been filed on 4 January 16, much prior to IBC coming into operation? Now, my lord, in my understanding, at that juncture, when the IBC had actually come into operation, there were classes of winding up petition. And depending upon at the stage where the winding up petition is, it was decided whether to transfer it to NCLT or retain it with the High Court. My lord, this petition falls in the category of those cases which is to be retained. Now, my lord, when subsequently, after the winding up petition was admitted, the CIRP proceeding was initiated. That was considered by this honorable court. These issues were framed, and my lord will kindly see what is the analysis. The operative portion starts from internal page 42. My lord, I'll kindly place this judgment. After considering all the judgments cited by the parties and for the reason aforesaid, I am of the view that the company judge of this court retains the jurisdiction to try the aforesaid winding up petition falling in the category of saved petition, even if an insolvency proceeding is initiated against the same company before the NCLT under the provisions of IBC by another creditor like Devi Trading. The applicable law for the said petition to try out by the company code will be of 1956. Issue 2, 3 and 4 are taken up together and answered in the following manner. Since I have held that the company judge of this court retains the jurisdiction in respect of the said petition, there is no question of the provisional liquidator from being released or discharged as prayed for by the IRP in the instant application being CA 92 of 2019. So the relief which he is asking primarily in an application which he has filed for recalling of the order passed in my application, I don't know first how that sustains. Irrespective of that, this prayer was already made by the same person in 2019, considered, decided upon, no appeal filed. There is also no need in the facts and circumstances of the instant case to direct the provisional liquidator to make over possession of the property and assets, books of accounts of the said company presently in possession of the IRP appointed by the NCLT. But I had written to the IRP, whosoever he is, he has clearly made a categorical statement to be, I do not have possession of the premises which you are talking about. He pushes me to the official liquidator. Official liquidator says that I have taken symbolic possession of this property, but you have to seek necessary directions from this honorable court. Now, my lord, today the question is, when my learned friend is trying to argue this point that I should have actually filed this application before NCLT, can NCLT issue directions upon the official liquidator? No. Official liquidator is attached to this honorable high court. NCLT cannot.
Bar, and of course, official liquidator.
NCLT cannot issue directions on the official liquidator. Honorable NCLT can issue directions on the RP. He is the officer of the court, not on the official liquidator. My lord, then I'll continue to place the judgment. As I have held that the proceedings under Section 7 of IBC now pending before NCLT should be proceeded until the stage of resolution plan being either accepted or rejected, the said petition shall not be proceeded with till this stage is arrived at before the NCLT. Once the plan is accepted, further orders may be sought for regarding the discharge of the provisional liquidator depending upon the provisions of the plan. So the provisional liquidator is continue to act, because he will be only discharged once the plan, depending upon the outcome of the plan. So, my lord, if the provisional liquidator is continued to hold his office, to retain the possession of the properties, books, accounts, everything. So, my lord, any direction now which I am seeking vis-a-vis the official liquidator, I have to come before my lord. The winding up.
Okay, no problem. Okay, it's suppose no, as per the order of Justice Mukherjee and Justice Kapoor, if it is retained but pending CIRP, whether the order can be passed for handing over. That is the one question now.
Very well, my lord. My lord,
because
then
CIRP proceeding is pending.
Very well.
Let us segregate the transfer. Let us segregate the
very
transfer.
well, very well. So,
That's I'm telling.
That's right.
Leave aside.
Leave aside the transfer.
I accept the order of the
very well.
coordinate.
My lord, considering, my lord, that
pending CIRP, can the court pass an order for handing over the property?
I'll answer this question. So, my lord, assuming for a moment that there is no issue vis-a-vis transferring of this IA, that is 82, which I have filed, or any other matter, to Honorable NCLT. Now, coming to this question. Now, my lord, the entire genesis of my learned friend's contention that, look, do not continue to hand over the symbolic possession of the property to my client is on the basis that that premises is the registered office premises of the corporate debtor. Now, my lord, I have provided documents showing that the address, the premises which belongs to me does not match with the MCA records. Now, my learned friend has not provided a single document showing that the registered office premises belongs to the corporate debtor. The MCA record does not say so. He speaks about an understanding which was entered into by my client and the corporate debtor. My lord, there is no even pleading of such understanding. Forget about any document in support thereof.
She coming and approaching the RP and the official liquidator then?
It need not be the registered office. There is a distinction. My lord, one thing is that this pen belongs to me, rightfully belongs to me, but is in possession of my learned friend. That is one contention. The other contention is, which my learned friend is trying to say, that the premises does not only belong to me, it is being used by me as the registered office of the company. My lord, these two things are separate. So first, my lord, there are two limbs to it. First is whether at all it is the registered office of the corporate debtor. The answer is no. No document has been shown to in support thereof.
That is the because these are all disputed question of fact.
My lord, how can it be disputed? Because my lord, today, my lord will kindly see the reply affidavit which I have filed to CA 83. My lord, there's two documents. Because my lord, first time when I wrote to the RP also, I said that I am the owner of the property. This seems to be in your possession. Please provide me. What is the status? Provide me the possession. He does not indicate at that juncture that, look, you cannot actually take the possession of the property because this is the registered office premises. He simply says to me that I have nothing to do with this property. It is not in my possession. You go and approach the official liquidator. This is what the RP has to say. So he is blowing hot and cold. At one juncture, he is saying that I do not have any possession. He does not mention that you cannot even ask for this property. This is the registered office premises of the company. Even in 2024, he is not able to take a stand. Suddenly today, he is realizing that no, okay, let me take the stand that it is the registered office of the company.
Okay.
My lord will see two things. My lord will first see my reply affidavit.
Of the 82, 83.
83, my lord, which is his recalling application.
Give the reply. This is opposition.
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 My lord, it's my mistake, my lord. My lord, opposition, page 35.
Yes.
My lord, that is form 18. My lord, this has to be compulsorily filed by any company intimating the registered office address. Now, my lord will see the registered office. My lord will see point 4A. They, as on 1st of December 2006, they have indicated, my lord, the entirety of the building, which now contains around 100 units. And my lord, this form was filed.
Correct. You have submitted on the last occasion.
My lord. So, my lord, this
69 is the total building.
total building.
Correct.
So, my lord, then 100 units were developed, commercial and residential.
3A1, 4A, 4B. Let's kindly comes back to 292 once she herself is accepting it.
Page
215.
Why are you interrupting?
Achha,
At
very well,
page 35.
Yes. Yes, continue. No problem.
So, my lord, after 2006, there were 100 units constructed. So, and sold to different people.
Yes.
So, my lord, there can be a situation where there is an agreement to sell. There can be a situation where there is a conveyance.
Yes.
There can be a situation where the transaction in its entirety has been completed. For some reason or the other, the conveyance was signed, it was registered. My ownership in relation to that property is complete. Now, suddenly, the RP is saying that these particular units are the registered office of the company. The official liquidator is not saying so. The records does not say so.
No, official liquidator in the page 292, which the official liquidator has informed, he stated that the key is being given to the caretaker.
And he acknowledges it's a registered office.
292.
And it's not a 59. Kindly comes back to 215. There are 4 units which are in my case. 3A, 3A1, 4A and 4B. It's in her letter at page 215. 215 volume 2. It's her letter to me.
Okay, first I will deal with
215.
Kindly come to 292 of 83. Official liquidator has requested, wrote a letter to the ex-director Avani project.
My lord, but my lord, what can be seen from this letter if I see it from the start? My lord, to Bhaskar Biswas, ex-director, Avni Projects, and then the address is written. So, my lord, we are presuming that this is the registered office address only because it is mentioned. My lord, this can be an address of correspondence
Not
also.
address. Kindly read the contents.
Very well. With reference to the continuous pursued request of Ajay Kumar Agarwal, the insolvency professional of the company, regarding fixing the date for visit and inspection of the registered office of the said company. So, my lord, where is the address indicated?
I am directed to inform you to provide the key of the lock and registered office.
I am directed to inform you to provide us the key of the lock of the registered office as they are under the custody of the ex-management of the company. An inspection of the... But, my lord, in this entirety of the letter, my lord, the question which comes up is where the address of the registered office company is mentioned. That is the first thing. So, my lord, at the maximum, we were presuming that the address which is indicated above, which can be a presumption maximum, written below the words Bhaskar Biswas.
So as per your submission, all the office records are available.
3A, 3B.
No, all the official records are available here in the
that's right.
My lord, then has an inspection been undertaken?
That is
what
written
is
there. It is.
What?
Okay,
and that's why I filed an application.
Then I will appoint a special officer with whom the key is there.
I am so grateful. And who will give access to the IRP to this. I am so grateful.
To whom the key is there.
My lord, whatever is there inside the premises, that my learned friend's client can happily take. But my lord, the possession has to come to me. Because, my lord, first...
Now the question is that it is not the registered office. Only 59 they have mentioned. They are not in possession. That's why the official liquidator has given the key to, intends to give the key to.
Because may I simplify the matter?
No,
59 is the address that is
That
being
is a total building.
because she has herself mentioned in that letter 215.
Okay, let's
come to
that is an
215.
important letter. My lord, even I want to place that letter. Can I place that letter, please?
Now, you please.
I'll place that letter. If I miss something, please indicate it.
Please.
My lord, now this is my letter which I write to his client. Now, why I say request for handover of possession of RCL premises defined herein under situated in the building Avni Heights. Now, my lord, where in this letter, my lord, my learned friend can point it out, where in this letter I have indicated that this premises is being used by you as the registered premises of the corporate debtor. Not even once I have said. Now, the second thing is that.
Para 1, let's kindly see.
I will read the entirety. We take this opportunity to bring to your kind attention that Reliance Capital Limited is the rightful legal owner of unit numbers this, along with certain terrace gardens and parking space in the building known as Avni Heights, along with undivided right, title and interest in the land over which Avni Heights is constructed. A detailed description of the
RCL.
A detailed description of all the units and spaces owned by RCL in Avni Heights is more particularly mentioned in annex to this letter and is collectively referred to as RCL premises. The said RCL premises was acquired by RCL by way of various conveyance deed executed between Avni Projects and Infrastructure Limited and Reliance Capital. A copy of the conveyance deed is attached herewith for your ready reference. A bare perusal of the conveyance deeds establish RCL is the legal and the rightful owner of the RCL premises since April 13, 2015. Where is RCL saying that, sir, this is being used by you as the registered office premises? I will read the entirety of the letter. We further take this opportunity to bring to your kind attention that the Reserve Bank of India, in exercise of the powers conferred under section this, superseded the board of directors of RCL on this and undersigned Nageshwar Rao was appointed as an administrator of the company on this as per the provisions of section this. Further on this, the RBI filed an application for initiation of CIRP against RCL under section this of IBC, read with rules this. Pursuant to an order dated this, the Honorable NCLT at Mumbai bench initiated CIRP of RCL and appointed the undersigned as the administrator as per applicable provisions under the code, read with the insolvency rules. Well, will my learned friend would want to indicate the particular paragraph?
What about the other flats are lying vacant or what is there? Or all are occupied?
The official liquidator will be able to say that.
No, just 1 second. Okay, you want me to read this paragraph?
No, it's okay, it's okay.
Then 7, 8, 8,
Okay,
8, 9.
okay, well, very well. I'll read 7. Mara, he wants me to indicate.
Anyway, he's
paragraph
asking
10.
for possession from
I'm
me.
asking for the possession. Yes.
Yes, you are asking the possession.
And my lord, what
that is not denial. That is not
There's
denial.
no
You are
denial.
asking the possession.
My lord, what is his
This
response?
is your case only for giving the possession of the.
Now, my lord, what is his response? Please see page 219.
The provisional liquidator has. Para 2.
My lord, para 4. As such, pursuant to the orders passed by the Honorable High Court at Calcutta, the official liquidator acting as a provisional liquidator is in possession of all the assets of the CD, which inter alia includes the property being this. Hence, the undersigned is not in possession or has any control over the said property. My lord, two things are absent, which is being vehemently contended today. That it is a registered office of the company. Nowhere it is mentioned.
Let's forget that.
No,
I give up. I give up.
let me finish the
office.
Let me finish the argument because you are, my lord, there
Yes,
is.
please continue. No problem.
My lord, firstly, that this is the registered office of the company, and my lord, secondly, he has not even anywhere indicated all the story which he is trying to say today regarding the statutory registers being kept over there, the inspection being taken. And my lord, the other important thing is that, which now transpires, if today, say suppose the official liquidator comes and says that the property is not in their possession also, the property is not in possession of the RP also, and the conveyance deed clearly indicates that there will be no right, title or any kind of lien, incumbents, nothing.
When the deed was executed?
2015, much before the winding up proceedings he was initiated. 2000?
When the proceeding was initiated, the CIRP? IBC proceeding has been
much later.
13/3/2019.
13.
Application comes in 2024.
My lord, conveyance is dated
But in respect to the position is concerned, my lord, I have a instruction that all the minutes are lying with the official. If you provide me some time, we can bring it. Because I have stated in another objection that in pursuant to the meeting held on 24th September 2018 at the Ogoni Heights, an apartment wherein the registered office of the company in professional liquidation is situated, certain information relating to various flats, offices, shops, and separate location project, and also the tabulated statement regarding values of shares of its subsidiaries and shareholding pattern have been provided to the subject by the company by its letter dated 8 November 2008. So, my lord, all these documents are lying with the custody of the official. Your losses provide some time, my lord. We shall brought to your losses of all these records. That where the registered office is situated and how the official declared to position of property.
How you can prove where the office is situated? If you write the 59 Chaurangi, then what will happen?
No, there was a minutes. There was a minutes in where, my lord, possibly my friend's client also was present. And others also, they were present. So when the property was the position of the official liquidator, there was a minutes. That minutes I can, my lord, produce it also.
Okay.
My lord, so there were three contentions at the inception. First, with regard to transfer of this matter.
Form 18 টা দেখো তো কোনটা দেখাচ্ছ তুমি? Form 18 টা দেখো তো।
हमारा reply opposition में annexed है।
Opposition
My lord, first is with regard to transfer of this matter in relation to jurisdiction. Second, with regard to registered office. Third, with regard to the main contention, whether at all I should be handed over the possession of the premises or
That
not.
is the main.
So, my lord, the first two contentions are now, I am assuming my learned friend is not pressing for it. So, the third issue is now remaining. So, my lord, over here, his stand is clear. He does not have the possession. My lord, official liquidator, my lord, with what has been submitted in the court today, my lord, he is iffy as to whether he has the possession or not. My lord, if I see page 292, my lord, then it is quite clear that the keys are with the director. Then, my lord, technically, the CD does not have the possession of this property. Even if at all, wrongfully also, the official liquidator has taken symbolic possession of this property, then where is the harm in returning the symbolic possession of the property to me? And my lord, the most important thing is, when my learned friend apprised this honorable court regarding the status of the resolution process, my lord, my property cannot be a part of the resolution process because I am the complete rightful owner of the property. He is admitting to that. Now, my lord, the second thing, if today, my lord, for instance, all other flat buyers, my lord, there used to be like a crowd over here in the earlier days, my lord, when several petitions were there. My lord, all were here either for the execution of the conveyance or taking the possession of their property. My lord, how can I be differentiated today? In fact, my lord, I am better placed today because my conveyance was signed much prior to initiation of the winding up proceeding also. My lord, if at all, today, my learned friend is apprehending that there can be any things which is there inside the property which belongs to the corporate debtor, my lord, the official liquidator, my lord, let the official liquidator be directed to hand over the symbolic possession of the property to me, and an officer can be there independently to assess if there is anything belonging to the corporate debtor that can be immediately handed over to the official liquidator. Because, my lord, pursuant to the order of the High Court, order of the Honorable High Court at Calcutta, I cannot hand over anything to the RP. So I will hand it over to the official liquidator. My lord, it's been 8 months, 10 months now.
So how it was gone to the official liquidator?
I'm sorry. I just, that's why I wanted to have a look at this. I was not
How
present.
this has been gone to the official liquidator?
My lord,
I'll tell your lordship's word. I'll tell you.
official
First, let us clarify the doubt regarding. Well, would your lordship takes up page 35 of my learned friend's reply affidavit, the form 18 which my learned friend showed.
Yes, form 18.
Orders.
Your lordship has the form 18. Kindly sees the date. This is, he's showing a document of 2006.
Yes.
1st December 2006.
Correct.
59A Chaurangi Road. Turns the page, 2006. Now, please come to 218. 218. The deed of conveyance, at that point of time, the entire building used to belong to Avni Infrastructure. The
This is
corporate debtor.
exactly my submission was.
Just a second. So that's exactly my point is, now where is the fresh MCA 21 after selling?
Your client has not filed it.
So my client has not filed. Malad, may I say this? That's why I am an officer. So Malad, I'll take your lordship this. I am an RP.
My lord, today,
official
what
liquidator.
you trying to say that today I will
Okay.
incorporate a company and I'll put the registered office as Victoria
No,
Memorial.
because
Just
that
because
was.
I'm saying, so that my registered office premises will become.
But may I say
Victoria
this?
Memorial.
I exactly what I said. The building was Avni's. They sold it some of the portions to Reliance. 3A, 3B, 4A, 4B. These two on the third and the fourth floor was being occupied as a registered office of the company. Subsequently, this is when I took over. I have no knowledge about this company from 2019, before 2019. From 2019, similarly, our official liquidator 2017, whatever the suspended board did. Suspended board came. The previous management sold the company, sold the assets to Reliance. Whatever done, whatever it is, and then this company, this place, these two, under whatever arrangements possible, was with the company as the registered office. 3A, 3B, 3. That's why they are specifically asking for possession of 3A, 3B, 4A, 4B in their letter. In their letter.
Yes, but
From 2015 onwards, that's what I'm saying. Today, to come and say in 2024 that this is not the registered office, but registered office is vague because Form 18 says this. Form 18 is filed in 2016. After that, they have sold the property. But under what conditions you have allowed this corporate debtor to use this property for
as the
whatever
registered
reason?
office
Possession.
is under question mark.
Let's forget registered office, corporate office,
No,
nothing.
Nothing. Actually, it's nothing.
So for what? What have they done? How have they slept over their rights from 2015 to 2024? Why? Why then?
My lord,
And why are you asking for possession from me?
My lord, there's two things I want to say. My lord, first is, my lord, since certain provisions of IBC has been relied upon by my friend, my lord, two provisions I want to show. First, my lord, is section 18. My lord, since 14(1)(d) has been stressed upon that during the declaration of moratorium or substance of moratorium. Now, my lord will kindly see section 18. 18 subsection 1, just after clause G, my lord, there is an explanation.
Yes.
My lord, for the purpose of this section, because 18 has also been relied upon, 17 and 18. The term asset shall not include assets owned by third parties in possession of the corporate debtor, held under trust or under contractual arrangements, including bailment. My lord, now today is that there is no contractual arrangement which my learned friend could show. Now, my lord, this is a possession, this is a property which is completely
That's why since beginning the court is putting the question how if you 2000 prior to the NCLT and the CIRP proceeding, IBC proceeding, your deed has been transferred.
Yes, my lord.
Correct.
Yes, executed
Deed
and
has been
registered.
Correct.
Yes, my lord.
You taken possession. Not taken possession. How the possession gone to this liquidator?
My lord, I had asked this question to my client.
If it has been registered prior to that and winding up has been in the year 2021, I think so.
16.
17.
My lord, 16.
16.
16.
And when the deed was registered?
My lord, the deed was registered.
15.
My lord, 2015, the deed was registered. And then 16, the winding up proceedings was initiated and 19, CIRP proceeding. Now, my lord, I had asked this question to my client that why was the possession of the property not taken by you?
Correct.
My lord, what has happened, my lord, actually, my lord, since there is a complete overhaul of the management of the company itself, because my lord, initially an administrator from the RBI had been appointed and now it is under the control of a new management by Hindujas. Now, my lord, they are unable to find the possession letter. And when they approached the official liquidator said that it is under their symbolic possession and to do anything
That's why the official how the official liquidator has come to the symbolic possession.
My lord, by mistake, my lord will kindly see.
By which order? Who has given the symbolic possession and how he has taken the symbolic possession?
My lord will kindly see the order passed of 20th February 2025. My lord, when I had filed this application, so the initial issue of the official liquidator was that I cannot take any step until and unless I inspect the original title deeds. So the original title deeds were placed before the official liquidator. He was satisfied with the same. And my lord, subsequent steps were taken and the orders was passed. And my learned friend's client was made a party to the application which I had filed. It was only at the end moment when the symbolic possession of the property was being handed to me, suddenly he realized that, okay, now this is the register office premises of the corporate data, because he acted very late. He acted very late because, my lord, the first order in this matter.
First you have to go to the route, how the symbolic, how the possession was given to the official liquidator.
My lord,
By which order?
The story is Reliance Capital had given some loan to the corporate debtor.
my lord, let the official liquidator answer this question.
The corporate.
How can my learned
How
friend
you
answer this
taken?
question?
Have you taken the possession?
My lord, if your lordships allow me to show, because I understand that everybody was present.
That's why,
Decision
that you
was
have to
taken.
show.
Yes, my lord, I can show to your lordships the minutes of the meeting, where my lord, friends, clients also present. And the position was taken, symbolic position was taken at the consonance of all the parties present here.
That's why, see, if you are taken with in a meeting or in terms of the order passed by this court, so admittedly the RP has no authority on this property.
7th September 2018, my lord, there was a and there was
Because I will only have a right over the what the corporate debtor has.
Corporate debtor.
I cannot better the title. I
That's
cannot
why
better.
the Reliance Capital is not a corporate debtor one.
No, yes, and I cannot have. I will have to say, and today it's a very dangerous thing to say that they don't have the letter of possession. New management. So that's what I'm saying. So Reliance Wallet kindly sees the timeline once. Reliance Capital has started insolvency from 2020, 2021. Right, Malak? The new management has taken over in 2023, 2024.
No, that was a monitoring committee. The new management has just come in during the pendency of this application.
Accepted. So, Malak, the question is what happened between 2015 and 2020?
So that's why how this has been gone to the official
And
liquidator.
what steps have Reliance taken? Had Reliance taken at
That's
that
why
point?
I am not going to this CIP proceeding.
And
I am not
lordships
going-
also can't decide on the title or the
That's
possession
why.
or nothing.
So that I cannot
that's
decide by
Ma'am,
sitting
just
here.
two orders, just to apprise my lord as to how far have we flown till now. My lord will kindly see the order of 22nd January 2025. My lord, 22nd January 2025.
Of this proceeding.
Yes, my lord, of this proceeding. My lord, CA 82. The order was passed in 82.
Dated 18th
22nd January 2025.
Yes. Once for the officer has submitted, the inspection of the original dates are necessary for hearing and adjudication of the instant application. Still with the official liquidator.
That's only the symbolic position. It is not the official liquidator's case that they have the lock or the key or anything. And my lord, when this question was asked, after the inspection, my lord will see the subsequent order, that is 20th February. The learned counsel for the official liquidator, Mr. This, submitted that inspection was carried out in terms of order this. He has found that the document is in original and in order. Mr. Chaudhary submitted that the official liquidator has no objection in handing over the symbolic possession of the premises to the administrator of Reliance Capital Limited. The official liquidator shall so hand over the properties mentioned in paragraph 17 of the application. A report shall be submitted. My lord, these are the orders of the January. Now, when steps were taking over to decide a date on which the actual handing over of the symbolic possession will be done, suddenly in March, mid of March, my learned friend's client realizes that he has to somehow stall the proceeding. That is what it is.
Okay.
First, he is saying to transfer.
Okay, let when you file the total report.
Thought that your lordships will reserve this for us. But nevertheless, one more day. One more day.
My lord, I have got the minutes of the meeting. My lord, I can show to your lordships in which my lord my learned friend's client was present. That minutes was drawn.
By handing over the possession. How you take the possession? I am not with regard
Reliance was present.
How the possession has come?
I'll tell your lordships that
before whom
my learned friend Miss Dalmia's clients are represented by Mr. Vikram Vadera in NCLT.
In writing, I have to
They inform to the house.
how the lease come out.
That's why, because
Vikram Vadera is represented.
Because she is right on her document. Correct. She is right on her document. Now the only question with regard to whether the NCLT will decide or this court decide. And the third is how the possession has gone to you.
Very well, ma'am.
In fact, there is a section 19 pending against Reliance Capital and Reliance Home Finance Limited in NCLT Calcutta for providing, because the transaction was this, not only this.
No, my lord, these facts are not on record. He has not.
I don't, but I want to point out again a point of law. That's it.
It's not about the law. My lord,
Mr. Banerjee is also not that the property should, but only the question is who will.
his contention that till the CIRP is continuing, there cannot be any change vis-a-vis the status of the property. My lord, in my humble submission, that is incorrect and misleading, because the IBC clearly itself says, my lord, my learned friend's knowledge vis-a-vis IBC is 1000 times superior to mine. My lord, I have to concede to this first. Now, my lord, secondly, he cannot today even argue on this point as to what is the definition of asset under IBC.
Because it is,
This completely excludes the asset which I'm contending about.
because still it is an under moratorium.
14,
Because no,
14 is one section, 18 is another section. Earlier prevails over the latter in case of conflict. 18 says what is an
statute
just a
that
second. 18 says assets definition. 14 says does not talk about asset belonging to the corporate or third party. It says something which is in my possession.
But you have
if I am in
denied
possession.
That's why.
That's right.
That's why the court.
That's
I
right.
find.
That's right. That's right. That's
How
right.
the possession.
Justice, you are absolutely right. And the fact that possession is there is not disputed, because she herself is asking for possession either from me or him. So that is not disputed.
Not with her.
So
Not with her.
when I say
Correct.
when-
If the company was having, in spite of
Correct.
having the deed registered, but the
Correct.
company was having the
Correct.
possession and the liquidator has taken
Correct.
possession, the matter would have been different.
Correct.
But
Correct.
this
They
is
have
not
taken
easy.
the possession
Correct.
and official liquidator has
Correct.
taken the possession from her, the matter would
And
be
now the
different.
question is transfer without possession.
Not possession. These are the two things.
Third mind. I put.
That are the 3-4
I'm
things is
so
to be
grateful.
decided.
So grateful. That's the simple matter.
This is the simple.
Absolutely.
Nothing go with this and that. Then law
Absolutely.
point is to be
Absolutely.
For the
Facts. Absolutely.
is to be
Which is why when I started off saying admittedly she's not, she said no. I said that is why I say admittedly.
document she is owner.
Correct.
But possession the
Correct.
admittance is not
Correct.
possession.
Correct. Absolutely.
And official liquidator is dilemma.
Absolutely correct.
Is in dilemma.
Absolutely
So how the property has come to the
Correct.
official liquidator?
Correct.
My lord, let the official liquidator respond to this.
Disclose all these things with the story. The counsel for the respective parties have argued at length. Full stop. Landed counsel for the official liquidator is directed to file the detailed report along with the documents to show that how the property is taken possession by the official liquidator and at present in whose possession the property is. Let the report be filed within 2 weeks after vacation. After ensuing puja vacation, list the matter on 19th of November 2025. Okay?
Grateful.
Grateful.
Lordship, before rises your Lordship, item number 8. And it's a very innocuous application on the office of the court liquidator, your Lordship.
Huh?
From the office of the court liquidator, my Lord.
Ah.
My Lord, this application, they are asking for praying for a leave for a bonus on the festival, your Lordship. Now, this was happening from since in 1980, my Lord. Your Lordship, allow me to place the application. Well, it's very short application, your Lordship. Lordship.
nahi hai. Nothing is there.
Well, Lord,
How you file this application?
it was filed from the office of the
Puja accuracy.
my Lord, it's very innocuous application.
But
Word of
where
the
is-
advisory also.
Can
Well, if I place the order,
Huh? Yes. Who has filed this?
my Lord, so for my information, it was filed.
Filed this. Where is the wakalatnama? Where is the competency?
Well, it was filed by virtue of
Who filed this?
my Lord, assistant court liquidator, your Lordship.
Assistant court liquidator.
My Lord, it was. I've been informed, my Lord. Lord, you kindly keep it. And if your Lordship allows me, it was. According to I've been informed that it was filed.
I have been appointed by the assistant. I have appointed as assistant court liquidator in the office of the court. So how he can say who is praying for the ex gratia?
My Lord, he is one of the assistant office liquidator, your Lordship.
No, Dinesh Pathak is the applicant.
Yes, Your Lordship.
Dinesh Pathak is the
My
so
lord.
why the assistant court liquidator has come in picture? Can you come to the affidavit portion? The I so and so working again of the R and Mukherjee Road, whatever it is.
Yes.
I have been appointed as he's the assistant court liquidator. He's
Yes,
a permanent.
yes, Your Lordship.
He's a permanent employee.
Yes, Your Lordship.
So how the puja exeretia will go to him?
My lord, it was, well, since I have been informed, it is going on since
To all.
My lord, since
Puja
1980.
exeretia is giving to all.
Since 1980. My lord.
My lord, may I just indicate, my lord, here? My lord, if your lordship allows me to.
No. Puja is gracious not to all,
Yes,
not to only for this company paid staff. Not to all.
My lord,
the names are mentioned over there.
Names are mentioned, my lord, not for all, my lord.
That's why.
My lord, kindly come to the, my lord, judges, summon your lordship. Prayer A, his names are mentioned.
Asim Kumar Das, Amit Chandra Sinha. So who has filed this application?
My lord, according to his info, my lord, it's filed by.
How you can file? The applicants, they have to come. They have to file an application who want the ex gratia, whether it is a union.
But things is happening since.
Dinesh Pathak filed. He is the assistant court liquidator. How the assistant court liquidator take the burden of the employees for release of the ex gratia? The employee has to file an application. Where is the application for the employees?
My lord, since all along, my lord, the assistant liquidator is making this application, my lord, on behalf of the. My lord.
I don't think so. How it is maintainable?
My lord, that I to your lordship kindly come to page 10.
Where is the liquidator?
No, my lord, this is not liquidator. It is office. This is my court liquidator, your lordship. This is another. It was constituted under, my lord, Banking Regulation Act 1949, your lordship. And lordship, if your lordship kindly comes to page 10, my lord, if you allows me for a second, your lordship. The similar application was made in the last year also, my lord, and it was granted. My lord, the official assistant court liquidator is making this application, my lord, all along.
Kindly see the present application has been filed seeking ex gratia payment being casual employee of the company.
Yes, your lordship.
So casual employee, where is the casual employee? They are not the applicant.
It is followed for I understand, my lord, they have to file by the applicant who wants to get. Lordship, if you lordship liberty, give me liberty. If you make an application, my lord, I'll keep it on Friday, your lordship, so that, my lord.
Oh.
Liberty granted. May I file this application and make a mention before your lordship to get a liberty to hear on Friday, your lordship, so that during the festival, my lord, these people will get some monetary benefit.
File with then mention, then we'll see to that.
My lord, my lord.
Lord, may I mention the commercial suit and to file the W.S. it is 6 days delays. Let it appear as
6 days delay.
Yes, madam.
After 120. When you receive the writ of summons.
And for the plaintiff, counterclaim has the defendant.
Okay, when you receive the written statement with counterclaim.
19th August 25.
19th August 2025. Liberty to file the same in submit the same in the department. Additional written statement to the counterclaim. Plaintiff is granted liberty to file the counter statement to the written claim in the department. When? Tomorrow?
Yes, tomorrow.
By
It is affirmed.
It affirmed by tomorrow. Subject to
Well, item number 12, that an application by the security agency was seeking the payment of the.
You not require the payment. What can be done? Every day your case is called. You are not.
The last day, I have just badly missed the matter, my lord.
You himself made him Mr. India.
My lord, last day when I was badly missed the matter, I was running throughout that building, my lord. That time, by that time, my lord.
Come next week. Yes.
My lord, I'm extremely compelling circumstances, my lord. Serial number 29 of my lord's today's list. My lord, in this matter, my lord had directed, there was an order in with regard to transfer of a particular asset of the company in liquidation in my favor. The order was passed. We were supposed to deposit the draft deed of conveyance with the OL's office, which was done, my lord. And on the last occasion, my learned friend had sought 4 weeks' time. They have reviewed the deed
returned the draft deed.
Corrected.
Yes, and they have given
to
it
you.
back to us on. We have received on the 17th, my lord. I was humbly submitting, my lord, sometime after the vacation, at least 2 or 3 weeks, my lord. By when we can complete the conveyance? May I hand up the last
When
order,
the date is going to over?
my lord?
When
4
the order
weeks
was
actually.
passed?
My lord, 4 weeks has is over actually.
13th August.
Paragraph number
Liquidator
2,
has
my
to
lord.
file the report and to submit the draft deed to convince the official liquidator within a period of 2 weeks from date of the order. But the applicant has submitted the draft deed on conveyance on 12th August.
My lord.
With a praise for 4 weeks time to complete the process. Yes.
So after this, we had the OL's office has served upon us on the 17th of this month, 17th September, my lord. We have the draft deed. We are considering the changes which they have suggested, my lord. If my lord grants me time till 3 weeks or 2 or 3 weeks after the vacation, within which
Other person is not here.
they
Why
are
you
not there.
mentioning
Yes,
him
my lord,
here?
I know. That
What
is
can
the
be done?
difficulty.
If your other side is there, then I can. Who is the official liquidator? Tanushri, she is not here.
No.
Bring on the next day. You bring. In the meantime, you do that.
My lord.
Do that.
My lord.
Brought to the notice of this court.
My lord. Deeply obliged.